Baker. I did speak with him downstairs this morning when the case was going on and advised Mr. Hawley that he was requesting a continuance yesterday. And I believe Mr. Baker had a DUI case downstairs during the same time. He asked me to request a continuance because he couldn't be here. He was just I've reached out to 4 other different lawyers' offices, including legal aid, in the last 2 weeks to cover all of these motions that have been served on me. Amy Sawyer with the domestic advocate, legal aid, Ms. Robert, who was here earlier, Ms. Duke, and Mr. Baker yesterday. And Mr. Baker took the case yesterday, and I had my friends drop off the documentation.
Well, Mr. Baker has advised our clerk that he has not been retained to represent you, and therefore the fact that you've not hired an attorney according to what you're telling me and what Mr. Baker tells me. This was here today because on the March 23rd of this year, which is 1 week ago, a motion for a restraining order was filed, and based upon the allegations set forth in that restraint motion, the court issued a temporary restraining order that can only remain in effect for a set period of time, and I set it for a hearing for today on the 30th day of March. You have the right to have an attorney because, number one, it involves the possession or use of the marital residence. Number two, it involves the question of whether or not the restraining order should or should not be continued in force. Pardon me. And as a result of that, I am trying to determine whether or not you're asking for a continuance for you to hire a lawyer. Is that what I'm understanding?
Yes, Your Honor. I spoke with Mr. Baker downstairs when we recessed. I went to his office. When I spoke to him yesterday afternoon, like I said, his documentation was dropped off, and I was going over there this afternoon to officially retain him.
Mr. Hawley, she's asking for time to hire an attorney, and she's essentially, this has been less than a week since this, or exactly 1 week since this order was entered, and I think she was served on the 23rd day of March, so she's only had 1 week. Do you have any opposition to rescheduling this with the order remaining in full force and effect?
Address court.
You may.
Well, we're here today for the possession. I
This
know
is
the
Mr.
court.
Shelton, Mr. Claiborne.
Mr. Claiborne, yes.
Claiborne, come up, sit at the table if you will.
Well, Judge, here's the biggest issue of the situation. There is also an order of protection. Let you know what we're here for. There's an order of protection that she filed downstairs in General Sessions. It got served, it got filed, and it got signed as the ex parte order of protection. We were in court Tuesday, and Judge Monsu moved the order of protection hearing to Chancery Court. It was set for the 4th of April, and I had a motion to continue, and I was busy that day. Or to move it to Chancery Court, and he moved it to Chancery Court. And I don't know if you have the file yet. There's still
Well,
a
I've just been
process
handed-
of all that. So
I've just been handed a document that
That's-
apparently was filed yesterday afternoon, a copy of the order that transferred the order.
and we heard that on Tuesday afternoon. But that's the other, and I bring that up because that's the other time-sensitive, hearing that the court has to have in addition to that restraining order. I know the court's apt to give her continuance for an attorney. It's a general rule. The problem is with Mr. Claiborne, this is a 5-month marriage. They've lived at that home since December only. And this home he has lived in for years. It was in his and his deceased wife's name. I've got the deed. The court wants to see it. This is solely his property. He has a business that he operates out of more or less the basement for warehousing purposes of repairing forklifts. I've learned about forklifts in this case. Apparently, from COVID and some of the manufacturing problems that we've had, there's like cars, no new forklifts on the warehouse floor to sell, and everybody wants their forklift repaired. He does quite the business. This is a situation where with this house also, I have coming to court to testify, she's here today, is a neighbor that's going to testify there are parties going on. I have photographs, I have video. I have a lot of unsultry things apparently going on over at that house on a more or less at least every other afternoon basis, of a lot of cars in the driveway, a lot of cars coming and going at all hours of the night, people jumping in and out of the hot tub. It's kind of ridiculous the way the house is being treated, and that will be the evidence before the court. What I'm asking for, and I know the court's apt to continue it, but what we're asking for is, and it is his property only, to have some sort of access to this house on a daily basis during the day. He'll go somewhere and spend the night till we can come back to court, but we're asking for some sort of like 7 a.m. to 4 or 5 p.m. access to his own property at this point, so that he can go down to the basement, pick out the air filters, the fuel filters, all of the oil, all of the things that he needs for his day and the parts that are over there, and have access to this house on pretty much a random daily basis, so he can come in there and do that. And she has every available means to go somewhere during the day, and she can come back and stay at night. We're also asking that there be no one over at this house other than the two parties. There's no reason for anybody else to be at that house other than the two parties. There's nobody else that lives or resides anywhere in that house or with them at this time. So if there's some sort of restriction here that says that, those two will live there, or excuse me, that she will stay there at night, without anybody else being there, and he's allowed to kind of come and go during the day, we can set up some hopefully time parameters here where, this will work out until we can come back to court. With the order of protection and the restraining order, I think we have to be back probably before that second week in April, if I'm looking at my totals and figures
Are you
correctly.
available on April the 4th? That's Tuesday.
I've got a full all-day juvenile court custody in Hickman County on that day. But I think about every other day I'm around. I can look at my calendar. I think in all fairness, to have some sort of parameters around this house in the meantime, and that there be no...
Well, the problem is that we're dealing with both your motions in a divorce case where she has requested the opportunity to hire an attorney, and the order and the restraining order that's just been filed on her and served on her 1 week ago. In fairness to her, the need for an attorney applies to all of those things.
I understand.
She has a right to an attorney, and because it was not, it has been a very short period of time, my inclination would be to grant her a request for an attorney, for a continuance to grant her that opportunity to hire an attorney. The question then becomes, of course, obviously, once I continue this hearing, there's been an ex parte restraining order that's been entered, and it will continue until there is a hearing. The order of protection has just been transferred up. It's a temporary order of protection. And therefore, it's going to have some sort of a hearing on that part, if nothing else, in the near future.
And there is also, Judge, a domestic that we were over in White Bluff on Tuesday for about 3 hours. I can tell you this, too, for the court's edification. They agreed and signed an order. May I approach?
Right?
That even the domestic bond conditions would be modified to follow the orders of Chancery Court, and that's signed by Judge Smithson. So I think I've got everything available to the court now where the order of protection is transferred up, the bond conditions are in front of the court, so the court can make these type of decisions regarding the marital residence on a temporary basis, whether it's today or later, anything like that. You're in control of the whole thing at this point, I guess is what I'm telling the
Not
court.
necessarily me, one of the judges on this level. Do you have a judge here anytime in the near future?
We have one in April, and Valerie said that all her docket was full for April, but you'll have to get with her to get the one of
This
her.
was who?
Judge Wallace.
Well, these, which I can, but the order of protection has a time frame that, of course, Ms. Childers has signed. My restraining order has a time frame that, we've worked on, so we've got some, there's just some time limits on these things.
They have April 25th,
At that point, I wouldn't mind continuing it out and transferring my time frame, but I would need to have something with this house, so, because it's costing him a lot of money with this forklift thing. You know,
There's so many days, I can't give you a day that doesn't exist. That's my problem.
there's an out-of-county experience that we could have here, I'll be glad, I mean, I'll do
Do what now?
anything. There's an out-of-county experience that we can, I'll
She
do
would-
anything.
She would have to agree to it to be out of county.
It's here, fine.
Holly, let her have the podium,
Yes.
please.
Your Honor, I would like to state that, yes, we did have court on the domestic. I was with the DA as well as detective level that day. And if I recall, I was on the stand until after 1 o'clock, and then afterwards I had to speak with investigators as well as Ms. Brooke Allen. So that is what was tying me up on Tuesday. In regards to having access to the house, even Mr. Hawley himself mentioned it. There's people taking pictures of my house. There's my every move is being documented. There's also a police officer with the city of White Bluff that was involved that was terminated. And I'm requesting that absolutely not, he not have any access to the property at this time. I do have individuals staying at the house. One is Mr. Colin Dever behind me. And there's been no parties. And I would be a little alarmed as to how everyone knows my every move. Again, and when in regards to his forklift business, he does his forklift repair business out of his van, which he has in his custody. And I reached out to Mr. Hawley's office. I've already boxed up all the oil filters, air filters, everything that I know that he uses on a daily basis, because even though we were only married since October 3rd, I would like to point out that I've been involved with him for almost 2 years or a year and a half. So I'm fully aware of what he needs on a daily basis as I assisted him with his business and all of that. If that's what this comes down to, is he needs to access those oil filters and oil. If the city of White Bluff is not, it's my understanding they cannot be involved at this time. Detective Level has been assigned to the case representing the county through Mr. Crouch. I have no problem setting up a civil standby and allowing him to pick up those items that are boxed up that is his work equipment. However, I do request, due to the confrontation that's always taken place at the house with law enforcement there, I do request additional officers be there, and I request that I not be there, and I will leave the items in a specific place.
Will you?
I'll address the court.
Yes.
I mean, again, when we get ready to do this, the evidence will show there's several pictures of parties going on, and this does not look like Mr. Devers jumping in and out of the hot tub and doing these sorts of things. There's a lot going on. We just got some time frames to hit. We just need a date as quick as we can possibly get.
Best I can do is tell you that I can offer you the 4th of April, which is the only day I have available. The rest of my month of April is all committed to criminal matters in Humphreys County, Tennessee. First-degree murder case set starting on the 11th, I believe. Is that right, Ms. McKinney? And every other day I've obligated myself. I don't have any other days to give you. Especially so if it's going to take several hours to litigate, and obviously this is. So they have the 25th, 26th, and 27th, is that right? For Judge Wallace. My best advice would be I'm going to have to continue it to allow her to have an opportunity. The only thing that was before me was the motion for possession of the marital residence and restraining order. And those will both be continued until a hearing that can be set before Judge Wallace on one of those 3 days. So you just need to get with Judge Wallace and find out which day is the best day and set it on that day. And that gives Ms. Childress the opportunity to hire an attorney and opportunity to prepare for a hearing.
Judge, in the meantime, though, is there any relief we can have on the house as far as any kind of access or any kind of restrictions on people going over there where he can just have some access during the day to get his stuff?
Well, the access that I'm going to have a hearing if that's the case, because she opposes that. And that means it's got to be heard. So you're going to have her opportunity to hire an attorney. Obviously, if she's being unreasonable about that, then that's something a judge will take into consideration. If she is not allowing access for no other reason, but there's an order of protection down in this case, so we have to be a little bit careful. So, Mr. Holly, all I can tell you is that if I grant her a motion to continue it, then everything's going to have to be continued. I can't do it piecemeal. And I think that unfortunately, she's going to have to understand that if she denies access to this property for unreasonable, reasons, then you can talk to her about whether or not she'd be willing to agree to some sort of method whereby he can gain access, but she's just stated she's not going to agree to it. So I think under the circumstances, the best I can tell you is that I have to give her an opportunity to retain counsel. I don't have another date to give you other than Tuesday the 4th. You change your other case and you want to have it heard on the 4th, and I'll entertain it on the 4th. Beyond that, I can't help you.
Yes, sir.
And I can tell you that you'll have to go to Judge Wallace on the 25th or 26th or 27th.
What do we do then with the order of protection and the restraining order?
Order protections are supposed to be heard, or they expire. The restraining order expires after, it remains in full force effect for 15 days from the date of issuance. So it will stay in effect until that hearing on the 4th, unless you have to continue it beyond that day.
As does the order of protection, it expires in 15 days, I think, unless it's heard, correct?
I can extend the order of the restraining order that I have until the next hearing. That's the one I issued. I have nothing to do with the order of protection thus far.
I mean, just for clarity, because I'm going to get asked this 100 times out in the hallway. The order of protection then, as far as this court's concerned, would dissolve if we don't have it timely heard within 15 days, I think it is. And then the restraining
I'm
order.
not making a declaratory judgment about that issue. I'm simply observing that I am not, this just was handed to me a few minutes ago. I'm not even aware that it had been brought or transferred to this court, but apparently the order transferring it was yesterday. So as of this court's, situation, the order of protection is by the statute, whatever it is. And we don't have judges that can sit day in and day out, as you well know. And as a result of that, we only have cases in which we only have judges who can deal with it in some other fashion. Now, I can only tell you that I will give you the 4th to have a hearing, or you're going to have to go to the 25th, 26th, or 27th with Judge Wallace. You'll have to get that cleared with him.
May we set it on the 4th, like in the afternoon? I don't know what the court's docket looks like on that day, but if we could do it at 1 with the thought that if I get my hands tied over in Hickman County, I may have to call or do whatever. I'll try my
I have a
best.
half-day hearing already scheduled that day. So, and that's, you
From
would
the
be
morning?
after, you would be after that, so that would give you an opportunity to go, if that's what you need to do. So, if you want it set for the 4th, I'll give you the 4th.
But the 4th, maybe at 1 o'clock, is that appropriate?
I'll set it for April 4th at 1 o'clock.
And then if I can't make it, it might not be held against me too bad, or you're not going to send the police after me. I think that 4th thing, they settle, so maybe it will settle. But I'll try every way to work it back over here at 1 o'clock. That's appropriate. If not, then maybe we can pick one dates later in April.
I'll reset this for April 4th to allow Ms. Childress the opportunity to hire an attorney. April 4th, that's just Tuesday at 1:30 will be when it will be heard.
And thank you, Judge. I appreciate your time.
All orders remain in full force and effect until that time.
Yes, sir. Thank you.
All right.
We're back for hearing number 2, which is the same motion as hearing number 1.
But what we have here today is a motion for temporary possession of the marital residence. I decide I wish to make a opening statement.
Judge, if we can, I would like to do a quick announcement on that restraining order, make sure we're all good with it. And then we'll move on from there. Mayor, I am going to request the rule, please, of course.
Rule has been requested. If there are any witnesses in this case, they must go outside of the courtroom and remain outside of the courtroom until you're called to testify. Do not discuss the testimony of any other party until you have testified yourself. Council are under continuing duty to ensure that rule is complied with. Mr. Woodall, what's the other one? Odle? Mr. Odle, Mr. Woodall, you have the case after this, and if we do not get to it today, you can have it heard if you want Thursday. Here in Dixon Chancery, we have the Marcello versus Marcello that you're involved in, so we can have moved this case to Thursday morning as well.
Thursday morning will work with me, Don.
All right. We'll hear it first, your motion first, and then we'll hear the Marcello case thereafter, because this is set before the Marcello. So you're welcome to wait around. I'm just simply telling you that if you need to go, that's what'll happen. So, yeah. You know Mr. Holly and Mr. Becker well enough that at 3:30 in the afternoon, if you think they're going to get to it before 5 o'clock, then wait around. Mr. Holly, you can announce your agreement.
The agreement for the restraining order will be as follows. It'll take me a minute. I just came out with it out in the hall, but basically the restraining order is going to be agreed to with both parties participating in the agreement, such that both parties will be restrained from accessing any and all emails, social media, or any other accounts, financial or otherwise, bearing the name of Kimberly Claiborne, C&K Forklift, Christopher Wayne Claiborne, or Amy Childress. If there's anybody else we need to throw in there, I'll be glad to think, we'll talk about it. Basically, the parties at that point. The parties are restrained from having any involvement and or contact with any of the accounts, pretty much the same thing, including but not limited to their LinkedIn accounts, their Facebook, banking, credit cards, or any other accounts dealing with the business of the husband, namely C&K Forklift. And I guess that's other than Mr. Claiborne has to have access to that because that is his business. That would more or less fall under number one, I guess, at that point. However that works itself out. She has so I understand that there's a LinkedIn account, and somehow or another it got to shown up on there as she was the owner. And I think he's got one and maybe she's got one, and that's how it kind of happened. But I'm assuming she would agree to take, if it's not up to him, she's going to agree to take that down where she's the owner.
I don't know that she's the owner. I don't know that she's the control of that account.
Of the LinkedIn account? I didn't know if she had one. He thought that she
I
had
have
one.
my own for the company, that the one that's got messed up is not mine. I still have mine for the business.
Yeah. Both parties are going to be enjoined from making Amy Childress the owner of the LinkedIn account, and both parties, I guess, would be restrained from not cooperating with each other while we try to resolve that one account that says maybe she is the owner, and you see that and attached to the motion. So that's the one thing that we need to be doing. Is that fair enough?
That's fair.
And I understand that, according to Ms. Childress, she doesn't have any information with any of the passwords that were changed to the email address of his late wife, Kim Claiborne, 1973 @gmail.com, or any of the other things that are listed here. But both parties would be ordered to give up any passwords. If they've changed any passwords on any accounts of the other, both parties would be ordered to give the passwords to the lawyers, and we'll pass it on to our respective clients. And the other thing is, he's got, and we've contested this, it's going to be very contested, domestic with the bond conditions. There's that order of protection that the court saw that came in. And my client was worried, and I think with good concern, and it would actually be reflective on both parties, that if we try to get back in Kimberly Claiborne's email, which by the way is used for the business some, she was big with the C&K Forklift with Mr. Claiborne, and that was the name, Chris and Kim Forklift. And the client still uses her email quite a bit, so he needs to get back into that thing, and he'll work to get back in or hire somebody to get back in. But when we do this, my understanding is, and I'm somewhat familiar, of course, I'm stuck in the 1980s when it comes to electronics. I did get close to Jelly Roll at the Titans game, so I do know who that is a little before you did. But the Kimberly Claiborne thing, if we try to get back into that account, it may very well, if there is some reflection with that email that we saw, it might ding her phone. She might get some sort of acknowledgement that we're going through some verification to change Kimberly Claiborne back, where Mr. Claiborne can have access to it. But if we have a Google notification or we have any other notifications that ding the phone of the other one, that will not count as a violation of anything, albeit the domestic bond conditions, which this court has, the court in White Bluff City Court agreed that you have full reign to change those, whatever you want to do, and I passed that order up prior. But whatever it is, if somebody gets some sort of notification that we're changing these back, it's not going to violate that or the order of protection. So if I missed anything, let me know, Mr. Mayor, but I think that covers it. And I'll do an order accordingly. And
Let's take a short recess. Let me stretch my leg for a second.
yes, sir.
All rise. This court is in recess.
All right, if you wish to make an opening statement, Mr. Holly, go ahead.
Judge, briefly, just to give you a little roadmap, this is a 5-month marriage. Married in October. They moved into this house in December. They haven't been there long at all. There's a domestic, there's an order of protection, there's everything that could possibly be done has been done, I think. It's been highly contested from Mr. Claiborne, and it will continue to be highly contested that he ever committed a domestic assault, that there ever was a valid order of protection that needed to be done. What you're going to hear from us today is that he's had this house since 2016 with his prior wife. Prior wife passed away of a horrible situation with COVID. He was on one floor of the hospital, she was on the other, and it was horrible. But anyway, she's passed away, and of course the house is and continues to be his sole separate property. The marriage has taken a horrible turn for the worse, and these parties are in a situation where they can't agree to much. The neighbors are going to testify about all the ongoings at the house. I think there's significant waste that this court needs to hear about a little bit in this situation. I think the evidence, when the dust settles, you'll see that the wife does have some sufficient funds to get a place and to move on. I really think, we get into these and we know that short-term marriage is only one or two things that apply, but I think the biggest issue in this is possession of the house out of the whole marriage. So we're asking the court to hear that today. He wants his house back. He's been living in hotels, so that's what the court's going to hear. And he runs the business out of his house, and it's instrumental for that aspect. He stores and keeps forklift parts again, and I've learned a lot about how that works. Everybody nowadays, with the way the world turns, they're not making new forklifts like they weren't making new cars, and everybody wants to keep their forklifts running, and he's got quite a business being on call and things like that to keep everything going, and it's totally disrupted all of that. So that's our
If you wish to make an opening,
I'd waive, Judge.
you can call your first witness.
Call Jerry Johnson, she's out in the hallway. Let me get it. You got it, let me get it, you got it. State your name, please, for the record.
Jerry Johnson.
Ms. Johnson, where do you live?
I live at 5276 Highway 70 East in White Bluff, Tennessee.
In correlation to Mr. Claiborne's home, where is that?
Right next door.
Okay, so you are familiar with Mr. Claiborne?
Yes,
How long have you lived there?
I moved in February 1st, 2021.
How do you find Mr. Claiborne since that time as your next door neighbor?
Great neighbor, always looking out for each other. When he would leave town, he'd let me know, various cars were going to be there. Keep an eye on the house and vice versa.
Okay.
Share the same lawn guy.
I'm sorry?
We share the same lawn guy.
Okay. Now, you're aware that Mr. Claiborne has been removed from the home, correct?
That was brought to my attention on the 6th of March.
Okay. And what is it like living next to Ms. Childress at this point?
Various cars in and out, different cars, probably a new car every other day, but multiple cars there.
And with these multiple cars, they're going in and out. When are they going in and out?
All times of the day and night.
Have you noticed unusual people over at the house?
Yeah, some familiar and some unusual.
How often do you see people over at the house?
I would say there's people over there at least on a daily basis.
You seen any of the same people?
Yes, some of the same people.
May I approach?
Right.
Show you a picture and ask you if you recognize this picture. We got a few pictures to get through.
Yes,
You
I do.
recognize that? What is that a picture of?
A few people in the backyard in the hot tub.
And you remember when that picture was taken?
Not the date exactly, no.
Was it taken during the time that Miss Childress was over there?
Yes.
May I approach you, Joe?
You may.
Let me show you another picture and ask you to set that down. Ask you if you recognize that picture.
Yes, I do.
And again, was that picture taken during the time that Miss Childress was over there?
Yes.
So what is that a picture of? Can you describe that to the court?
Two ladies getting in the hot tub.
Okay.
Judge, I'm gonna object to the relevance of this unless this is going somewhere.
Judge?
Well, I've been hearing cases involving a lot of irrelevant things today, but I'm going to allow it, overrule the objection. Are you wishing to make these an exhibit collectively? or-
Collectively in a minute, Judge, yes, and we don't have to do it. Every time I approach,
You may.
show you another picture and ask you if you recognize that picture.
Yes, I do.
What is that a picture of?
People outside on the deck.
And was that picture taken when Miss Childress was over at the home?
Yes.
And it was taken then during the month of March?
Yes.
Okay, are all these pictures a fair and accurate depiction of what you see over at the house?
Yes.
I notice there are blinds here that are in the picture. Whose blinds are those?
Those are my kitchen blinds.
Okay, and you're taking these pictures from your kitchen, correct?
There's some from my kitchen, and then to get pictures of the cars in the driveway, I take them from my bedroom or my daughter's bedroom window.
Did you feel like there was some questionable activity going on over at the house?
Well, I noticed that things had changed considerably after Chris Claiborne, was removed from the home.
Did you see this type of activity going on when Mr. Claiborne had the home?
No.
Collective one, Judge.
Collective exhibit 1. Marking A, B, C, D, E, F.
Three. May I approach again, Judge?
You may.
I'll show you. Might help if I show it here. I'm going to hand you 3 this time. We'll do it this way. I want to hand you these photographs and ask you if you recognize those photographs.
Yes, I do.
Photographs that you took.
Yes,
And did you take them from your home?
yes. 2 of them, one was taken from my bedroom window, one was taken from my front porch, and the other one was taken from my mailbox.
Okay. And you described to the court what we're about to introduce here for the court. What are these pictures of?
Oh, these pictures
Yes, ma'am.
that you gave me? They were pictures of some of the various vehicles that have been over at the house.
Just, it's fair to say this is like a random day in the life of your next door neighbor?
Yes,
Collective 2, Jeff.
Exhibit 2 collected.
I'll renew my relevance objection, Judge.
Same ruling. I'm assuming you're introducing these to show the use and possession of the house and what it's being used for during the time that the defendant has possession.
And the waste that's going on over at the house, and, you know, we just don't know.
It is
So
for that reason, Mr. Baker, I'm allowing it to be introduced. Did you get them?
If I could approach Judge, show you this picture and ask you if you took that picture.
no, I didn't take this picture.
What is that a picture of?
I will object to that. She didn't take the picture, she can't authenticate it.
Well, sure she can. You can authenticate it as to whether or not it represents true and accurate representation of what she observed on a particular day. I don't think it requires that you take the picture before you can authenticate what it is, so overrule the objection.
So this is a picture of the bags and boxes that were outside of the home one day. This was just one of the occasions.
Did you see that yourself?
I did see this myself, but I did not take the picture.
All right, but is this a fair and accurate depiction of, looks like a lot of trash and a lot of boxes and things that are just being discarded out of the home?
Yes,
And does it look like quite a bit of stuff?
it does look like quite a bit of stuff.
Next exhibit, Judge.
Exhibit 3. Ready, Mr. Holly?
I am, Judge, I have just a minute. I have the color photograph of that, I don't know what I'm doing. Oh, well. We'll do the black and white one. I understand, Ms. Johnson, let me show you these 3 pictures. I want to ask you if you recall the day that these pictures were taken?
Yes, I do.
Did you take these pictures?
Yes, I did.
And what do these pictures appear to be?
They are pictures of Chris Claiborne's truck being towed off the property.
How did you find that day that his truck was being towed off of the property?
Extremely odd because, so may I back up a minute?
Go ahead.
So I was first contacted on the 6th of March by Mr. Claiborne's daughter, Sydney Claiborne, letting me know he had been removed from the home.
I will object to the hearsay.
Holly, you have any exception, sustained?
You can't testify about what somebody said, but you can testify as to why you saw the
Okay.
picture to be unusual, okay?
Well, I felt that the pictures were odd. There were new cars that are showing up at the house. Here his vehicle is being removed. Boxes are coming in and out. Trash is put outside. So it was unusual.
Next exhibit, Judge, and I'll link that up with some of Mr. Claiborne's testimony as well. Since she took the pictures, I want to show you a document. I want to ask you if you recall this document?
Yes, I do.
And what is this document?
This is an email that I sent to you on the 29th of March with a text message that I had received from Amy Childress.
Okay. And can you read the email into the record?
Yes, the email, I said, do you think this is something I should go to the police about? Her text message says, "Hi Jerry, this is your neighbor Amy. I just wanted to reach out and apologize if you feel I have annoyed you in any way. I've been nothing but kind and supportive, asking if y'all ever needed anything. I apologize for all the cars coming and going, but it is for my safety and I have not had one party. Also, I have had no more cars in my driveway than you have. There were more vehicles in my driveway when Chris lived here. I will try and get the yard mowed if that is an annoyance as soon as I have the funds. I would use our current yard guy, but Chris still owes him $400 from not paying last year. That being said, Reese Hawley has made it known to many that you are taking pictures of my home and the cars coming in it. I also saw the pictures yesterday from the stand on Reese Hawley and Chris's table. Detective Lovell is also aware you have admitted to taking pictures to Reese Hawley. That is a direct violation of an order of protection and bond conditions that you are fully aware of against my husband. Some of the pictures taken are also of off-duty police officers and security, just so you are aware. I am asking you to stop taking pictures of my home and communicating anything back to my husband or his attorney in regards to me or any activity at 5278 Highway 70 East. Per law enforcement, Chris is no longer a resident at this address currently. If this does not stop immediately, I will call the police and get the detective and DA involved. I have also made my attorney aware of the situation, and he will move forward with legal action next. This is also to make you aware you are not allowed on my property, and if you are, I will file charges of trespassing as this is your official warning. Please do not respond back to me. If you feel that I am being an annoyance at any time, please reach out to the police and they can handle it as they are fully aware of the situation.
So when you received this email, how did you take this email?
Well, it was a text message and
Text
she
message.
sent it to me from both of the phone numbers I have for her. I took it as a threat.
Had you already been to court? This was on Wednesday, March 29th, correct?
That was the day after the first court hearing.
Okay. And the first court hearing, you're talking about the hearing in White Bluff City Court?
Yes, sir.
Okay. And you showed up there to be a witness
I was
for Mr.
subpoenaed
Glover?
there to be a witness, yes.
And you felt like she was sending you this after that court appearance?
Yes.
Am I understanding this right? This neighbor is creeping out her blinds, taking pictures of everything the neighbor is doing, reporting back to the husband, using it against her in court. She writes her a letter asking her to stop and telling her that she'll correct the things that are wrong. And if there's anything really wrong, go to the police and please stay out of my business, which, you know, probably it's not terribly unreasonable. You know, her lawyer probably would get upset about it. And this lady thinks that she's threatening her while she's standing at the window spying on her neighbor. Is she cuckoo for Cocoa Puffs, or am I just not understanding this? OMG.
Did any of the law enforcement at all, the Detective Lovell or anybody ever contact you outside of Ms. Childress at all?
No.
Okay. I would make that the next filed exhibit, Judge.
Exhibit 5.
So it's fair to say that there's issues between apparently Ms. Childress and you being her neighbor, correct?
There is now, yes.
What has that caused you to do in the last couple of years, especially since you've gotten this text message?
Well, it's caused my whole family and I to be uncomfortable in our home. We've constrained our dogs so that they don't have full access to the yard very often. We have been in the past, we don't lock our doors, now we lock our doors. And when I'm away from the home, I turn on the security. If I'm home by myself, I turn on the security alarm.
And who lives with you at your address?
My father, my mother, my sister, and my 12-year-old daughter.
Okay. And have they witnessed all the same?
Yes, they have.
Okay. And how do you, have you noticed that, or whether or not it's affected them in any manner?
Absolutely.
And what have you witnessed about that?
Well, my parents are, I wouldn't even call it paranoid, but you have to understand they are professional dog handlers. And so the dogs that we have are very expensive and they're afraid that their animals will be harmed. They're also concerned about my own safety.
I'm plugged up to the big screen and I'm wondering if there's a button that we could flip. I have a video I'd like to, and this is the end of it. I'd like to play one video that she's.
What kind of dogs do you all have?
Eagles.
We'll show you a video here and I'll ask some questions about it. Did you recall the day that happened?
Yes,
The night that happened?
The night that happened, yes.
Yeah. And when was that? Do you remember?
I don't remember the exact date.
Was it during a time that Ms. Childress had the property or Mr. Claiborne had the property?
Ms. Childress.
Okay.
I can tell you the truck left once and it was like 2:00 in the morning. It returned back about 2:20 and then it left again at 3:00. That was it leaving at 3:00 in the morning.
Okay, and you heard the loud muffler, did it sound like that at your house?
Yes, my bedroom, I sleep with the window open and my bedroom window is the closest to the Claiborne house.
Could you sleep for the truck coming and going?
No.
Did that also affect the other members of your house that evening?
With all due respect, now I do think we're venturing into something that's irrelevant on the possession of the marital residence. I sympathize with her about how it affects her, but going into how it affects her family, I think is beyond the pale.
Fair enough. Your witness.
I would move that video in as an exhibit.
You have a copy of it to make part of the record?
I've got that and the other photos on this thumb drive. I would like to have the opportunity maybe to present that to the court.
Until you made a late file exhibit if you want.
That's what I'm asking, a late file exhibit to that, but I've got it here on the thumb drive if anybody needs
You
it.
submitted exhibit 6.
Sergeant, I want to lodge an objection to that. There was nothing established that that car even pulled into this house. It's a car on the road, and they're trying to infer something.
It shows the truck backing up and then it leaving the driveway, and I'm familiar with this location of these two houses. This is the one on Highway 70, right?
Yes, sir.
Towards, almost to Craigie Hill.
Almost to Kingston Springs, Craigie
Almost to
Hill.
Craigie Hill.
Yes, sir.
I know where it is, I know the houses, I watched them being built, so I'm familiar with it, and I understand what she's saying about the fact that a vehicle that leaves at 3 o'clock in the morning would be something she would recognize. Her testimony is that she recorded the truck leaving the home that was being possessed by Ms. Childress at 2:33 or 2 or 2:20 and 3, and I'm allowing it for that purpose.
Okay. Do you know, go ahead.
Her testimony was she was familiar with it. Her sister took the video while she was standing right beside her. So if that comes out that way, I didn't want to mislead the court.
This is a temporary possession, a temporary hearing anyway.
Do you know who was driving that truck?
No, sir.
All right, so why are you saying that that's relevant to that house? Explain to me, an
Because-
unknown truck pulls in there.
Prior to Mr. Claiborne being removed from the home, we didn't have any of this going on. We didn't have unknown vehicles in and out all hours of the night. I didn't have, if they were having a party or such, or, you know, let's say he was running his race car, I knew what the noises were. That's what,
Well, that's kind of, take me through that, because to me, that's specious reasoning. Just because something happens after he moved out, it had to be related to who had possession of the house?
right, but there were a lot of things going on. Items being removed, trash being removed, moving boxes moving in. There were lots of things going on. A truck removed from his parking lot or his driveway. There were
Normal?
lots of, no, that was not normal.
All right, it's not normal for a person having a divorce whose husband got arrested for domestic assault, was served an order of protection. You're telling me that's not unusual?
I did not know about any, I knew that he had been removed from the home, but I can tell you that as much stuff was moving out of that home was not moved in when she moved in.
Why is it any of your business in the first place?
Because I am the neighbor and I look out for my community.
All right, who told you to take these pictures?
Nobody told me to take those pictures. I took those pictures on my own without anybody knowing until the truck was towed off the property, and I talked to my family about it, and they suggested I reach out to Mr. Claiborne.
Well, how do you think it would make the neighbor feel if you had a snoopy neighbor taking pictures of them all the time?
I would hope that if something like that at my house was going on, that they'd take pictures too.
Because you're the standard that everybody should live by.
Judge, I'm gonna object. We're getting a little argumentative here.
Sustained, argumentative.
All right, this picture of the two women in the hot tub, what's unusual about that?
Usually the hot tub is run at night when the lights are dark and nobody's there.
So you take issue with the time of day somebody's using the hot tub.
I was taking issue of all the different people that were in and out of that house.
Do you know these two people?
Nope.
These cars, do you know who these cars belong to?
Only the black Armada, the blue Jeep that you see in there occasionally, and that's it.
Well, it sounds like to me you're more worried about the one car because you don't know who this one car belongs to.
No, there were more than one car.
May I approach the witness, Judge?
Right.
Can you show me where there's another car?
This is another car, this is another car. There's also been a truck, there's been a red car.
Show me the truck in that picture.
It's not in this picture, it's in the other picture.
Now, I asked you how many. You identified two vehicles and you said there's a third.
Right, the Armada that is usually there.
All right. Do you know who the Armada belongs to?
Yes, Mr. Claiborne.
Okay. The time Mr. Claiborne lived there was more vehicles than that in the driveway, correct?
Yes,
The difference is you just don't know who they are now.
exactly.
So this sounds more like neighbor who's in the neighbor's business is worried and complaining.
Judge, I'm gonna object again.
Is that not true?
Argumentative, sustained.
Judge, I think that's a fair question. What's the difference between, okay, if I know who the cars are and there's more cars there before the divorce, now there's less cars there, but by her own admission, it's because I can't identify at least one of those cars, something's unusual. I
The
think that's a
motivation, Mr. Baker, in taking the photographs or whatever is what you were arguing about. But she is a fact witness about the activities that have been going on at the house. Her reasons or motivation for doing it is not relevant. What she's been brought in as a witness is to show that this is what's going on. So that's the reason I'm sustaining that the question is argumentative.
All right, I'll rephrase the question. There's less cars there now after Mr. Claiborne moved out, correct?
No, there's not.
Then why a minute ago when I asked you, you said there were more cars there when he lived there?
He has a truck, he has his work van, he has the Armada, he has a boat, he has a trailer. And then on occasion, her blue Jeep is there.
And friends come over sometimes and visit and so forth, correct?
Right, and I usually know those vehicles as well.
All right, so that's the whole problem here, right?
No,
No further questions, Judge.
Redirect. Thank you, ma'am. You may step down. You may be released from your subpoena.
thank
Sorry,
you.
next witness.
Call Mr. Claiborne.
Claiborne, come around, please. Raise your right hand and face our clerk.
Do you solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
You're Chris Claiborne, correct?
Yes,
And you're married to Amy Childers, correct?
yes, sir.
When did you get married?
October 3rd, something like that,
What year?
2022.
So this has been a 5-month marriage?
Yes, sir.
If I'm counting on my fingers right. First off, the house, you've seen the photographs. Do you own that house?
I have, sir. Me and my late wife purchased it around, I think, 2016, 15, 16, something like that.
If I could approach Judge.
May.
Heard the testimony the last time you recorded got continued. You went and got a true copy of your deed, correct?
Sir, that's the deed that still shows my name on the property and plus my late wife's name.
And that was from 2016, correct?
Yes, sir.
If anything, that's about a 6-some-odd month situation that you've owned that home, 6 years.
6 years, yes, sir.
Some-odd months.
Yes, sir. I think it was in June is when we actually purchased the home of that year.
Next exhibit.
7.
7.
You heard my opening statement that you guys moved in December into that home, correct?
Yes, sir.
Was that
Yes, sir.
accurate? I
Yes,
guess
sir.
that's what I'm saying, okay. You know, when you lived there, you heard your neighbor's testimony. What type of wild parties did you have?
Not really many. We had a party for my daughter for I think it was maybe New Year's or somewhere right around in there, some kind of a party or a Christmas party or something other, and we had a bunch of her friends over there. Generally though, anytime I was going to have anything going on at the home, I'd say, hey, I would talk to the neighbors. We'd always communicate back and forth and say, hey, there's going to be people in and out or whatever, or I'm going to be gone or something other like that. And then and then a lot of times on the weekends, my daughter, if she was at home, she would have some friends that are here or there over, but very rarely.
And, I mean, you're familiar with these photographs that your neighbor took, correct? You've
Yes,
seen
sir.
them.
Yes, sir.
Is there anybody in these photographs that you recognize?
Well, when they was first took, no, but after the fact, after I found out who one of the girls was that was in the hot tub, I did know, then I found out, I know who that is now, after the fact.
Does that cause you concern with your house being used in that fashion?
It does, because it's a brand new home, and you're seeing so many people come in and out of the home that I don't know what's being brought in and out of my home, what's being done to my home. I mean, there's a lot of valuable things in that home. I mean, there's like hot water TVs, there's weapons in the home. I mean, there's all kinds of stuff in this home. There's all kinds of jewelry in the home. I still got a lot of my jewelry there that's not got removed from the house. Some of my late wife's wedding bands and stuff are still there. That's thousands of dollars worth of stuff in this home that's just sitting there with all these people coming in and out. And I have no idea what's going on inside that home now.
And to be clear, when you were living with Miss Childress during the 90, I guess, or so days, more or less, that she was there, did y'all live like that?
No, sir. No, sir. Like I said, we had the one party she catered for my daughter. I think it was like a Christmas party or something like that, some kind of a party, and we had a bunch of her friends over there. Other than that, the whole time we lived there, Miss Childress never had one guest come to that home because of her that I can recall that she knew. Most of her friends, whether they live in Nashville or her sister lives out of town in East Tennessee, and I don't even met her once at a wedding. So other than that, I had some of my family members would come over, like my aunt would come every couple of weeks and clean the home or something like that. They had the yard guys, about it.
So you had business credit cards.
Yes, sir.
You have any concerns as to how they've been used by Ms. Childress during this time?
Yes, sir.
Tell the court about that.
I had looked down one day on my phone, and I was thinking, well, I haven't checked my business. One of my business cards, I carry 2 Chase cards and a American Express card for work. And I logged into my Chase app to see if there was a payment due. And then all of a sudden, this was the week after I had left the home. And I looked down, and all of a sudden, it's showing over $4,000 in Amazon purchases made in 1 week. So I got chased on the phone and I shut the credit card down and trying to figure out what's going on, where is these over $4,000 in purchases coming from? And they told me that I had to contact.
Objection, hearsay.
No, it would appear to be hearsay.
I would
Can't
say-
repeat what somebody else told you.
Judge, that, this is for all intent and purposes, a business record. It was a business credit card that he has, and he's looking at his.
I understand that, but what you're asking him to repeat is a statement made by someone at the credit card company you want him to repeat what someone else told him to introduce that statement as true, right?
Well, are you trying to say what somebody has told you, not
Well,
what you
they,
saw?
all they told me who to contact.
Don't, you can't testify to what somebody told you. Let's leave it there. Okay, keep going.
So I looked and seen that the charges were all Amazon charges. So I called Amazon, and on each one of the on each charge, it had like a HQ number, H number on it. And I asked them, I said, "What is this charge?" And they told me what each
Judge, I'm gonna
purchase.
object to the
You can't
hearsay.
testify what
Oh,
they
sorry.
told you.
Okay.
But based on your phone call with Amazon, then what did you do next?
I shut that card down and I flagged it off as fraudulent activity because it was nothing that I had purchased.
When you look back over your business card and the Amazon statements, what type of things were being purchased?
Vacuum sealer, dish sets, curtains, some kind of a reef was being purchased. There was soaps, there was a mouthwash rinse thing bought. It was just on and on. There was cases of dog food being bought. It was just stuff that stuff that I would never even think about buying. It was just purchase after purchase after purchase of just different things.
Right, and according to
It
the
was like
statement,
it was movie subscriptions. It was Amazon subscriptions, and I'm like, it just went on for like 5 days of these purchases just went on.
and again, with your business account and that situation, could you tell where all the stuff's being shipped to?
Yes, sir, I could. It was being shipped to the house,
And
to my house.
Did you order it?
No, sir, I did not.
Did Mrs. Childress have any permission from you to use that account for those purposes?
Not for that, no, sir.
The forklift company, we'll strike that.
May I approach?
You may.
Look, I want to show you a document, and ask you if you recognize that document.
Yes, sir, I do.
And that's a document that you put together that shows what?
It shows all of the purchases that was made from 3 different credit cards of mine. That some of the credit cards that was at the house, not even in my possession. Like the one from AT&T, that card was at the home when there was $1,100 was like charged on it in one day. And then Dixon Storage, there was $1,600 charged in one day, back-to-back charges.
You heard Ms. Childress testify at White Bluff City Court about that.
Yes, sir.
What did she say about those
She
charges?
said that she felt that she needed to go pay her storage unit up for I think it was like 9 months. Was something, I believe it was 9 months is what she testified to.
Is there an Instacart purchase
There was
on
an
there?
Instacart purchase on there.
How much was, what was that for?
Are we still on the possession of the house, or were you talking about debts?
Well, these are credit cards that were at the house, and one of the reasons, after she's taking over the house, one of the things she's going through and finding, and, based on her being able to have access to the house, is actually using it. And it's gonna equate to about $7,000 in 10 days. The court's interested in that, fine. If you're not, I'll move on.
I just think we are limited to what the motions are, which is possession of the house. Unless there's a motion down regarding the assessment of debts and so forth. Now, obviously, there's a restraining statutory injunction, that prohibits things, but.
I'm offering to show waste at the house, because there's no other person that could have gotten these credit cards and used them in such fashion. It certainly implies that she's, went rifling through the drawers and things and found some of this stuff and flat taking advantage of it. Let me ask you one question, I'll get off of it. The Instacart, is that for groceries?
It is. It was. It showed to be two purchases, one for $538 and one for $309.
And when you researched that, where was it delivered to?
It was delivered to the front porch of the residence.
Did you make that purchase?
No, sir, I did not.
Judge, I would ask this to be the next exhibit.
I'd object to relevance, Judge.
I'm sorry?
I'd object to relevance.
He's made his argument as to what's relevant, so I'll allow it for the purpose of showing any waste that's occurring because of her possession of the house.
The forklift company that you own is C&K Forklift?
Yes, sir, it is.
And what's the C and the K stand for?
Chris and Kim.
So that was a company that was how old?
Reverently 5-6 years old now.
And I'm assuming then, because of the name, you and your deceased wife started that company?
Yes, sir, it was formed solely in my name. I'm sorry, I get upset when I talk about her. It's always been solely in my name, but she done all the billing to the company, a lot of the communications back and forth with the customers and stuff like that. When it comes to any kind of daily businesses.
So what's going on over at the house then in regards to your business? And we've alleged that you need in the house to keep up with your business activities. Tell the court how you use your home for your business and why you need to get possession of the marital residence for your business, okay?
As of right now, it is costing me more money out of my pocket to run the business than I'm making off of the business, because a lot of the stuff that I have in the garage is stuff that I keep pre-ordered and pre-bought, as far as like service and stuff, filters and oils and all kinds of stuff in the home that I have to turn around. We're talking, some of these filters are over $100 a pop. And, and we're looking, at several of them at times, we're talking thousands upon thousands of dollars just in parts sitting in the garage that I need access to daily. But I never know from day to day what I'm going to need unless it's something we already have pre-scheduled service. I get different calls for different stuff every day, but it could be something that I have in the home that if I don't have it, I'm having to turn around and go order it from somewhere else. And then so now that I'm out money double for what some I've already purchased that I had at the home.
I'm trying to say, sometimes you don't know what you need till you get on the scene of the.
Yeah, unless it's something we do routine maintenance on. I keep filters and stuff at the house for like routine maintenance and stuff on certain accounts that I do on a regular basis, like every 30, 60, or 90 days. But any other stuff like that, there's all kinds of like miscellaneous odd and end parts inside the house that I've kept over the years, stuff that I need access to when I do need them. But the filters and stuff that I have to have on a daily basis, if that customers due to be serviced, I keep all that stuff pre-bought ahead.
So has, strike that. Do you know how have you been living since you were removed from the home due to the domestic bond conditions and this order of protection?
I have
Form of the
spent,
question.
I'm sorry?
Objection to the form of the question. There was about 3 qualifiers in that question.
I'll rephrase.
Rephrase your question.
Where have you been living?
I've stayed several different places. Some nights I've had to stay in a motel. I've had to stay at some of my late wife's families. I've been staying with my aunt, which was one of the employees that works for me. I've been staying with them. I've had to pretty much almost just be homeless for the last month. I've been homeless, and it's living from place to place.
Do you have like a mother, father, family support around here that you can lean on?
Just my aunt is really the only one that's been able to stay with.
Do you know if Ms. Childress, in your relationship with her, however brief, do you know if she has funds to go and get a place?
I've witnessed her receive a check for about $18,000 or $19,000 from the VA for her father's estate. That was money that was left over in the VA that she deposited into the bank. And then numerous times when we first started dating, she had sold her father's home and collected the money off of that. And she had told me that she had put, I think, $30,000, $40,000 in cash down on a Jeep, and then she'd put another $20,000 into the Jeep. And then she had turned around and wrote a check, I think, for maybe $20,000 to the guy that she sold the house to turn around and rent the house back for a year, because that's where she was living when we met. And that's when she didn't, and that's why she didn't move into my home until December, because the house was still paid up for the year. And then amongst that, she had took and went to Florida and bought, she told me, upwards of $10,000 in plants for a business that she was running. And then I think that last December or early January, I had took her to a plastic surgeon in Nashville, and she paid for breast implants, which was about, I think, $8,000 to $10,000. She wrote a check for that day. So she has a lot of money. It's just she's got it put away where it's hard to, where she doesn't want anybody to see it.
You've heard her talk about the Regent's bank account when we were in White Bluff City Court,
Yes,
correct?
sir. Yes, sir.
Did she ever answer the question about?
No, sir,
what
she would
had?
not answer how much money she had in the bank. She kept saying, I know she has more than one Regions account. I think she has about 3. From what I've seen her over the times, when she would help me pay some of the bills at the house, if it wouldn't go through on one account, she said, hold on, here's my other card, or I need to transfer money from one account to the other. So she has multiple bank accounts through Regions.
Do you have knowledge that she has reliable transportation on her own?
She does. She has a 2017 Jeep Wrangler. There's really nothing wrong with it. She's just, from my understanding, from what I've been hearing and seeing, that my daughter has been driving the Jeep everywhere around Dixon County and up towards Cookville and East Tennessee for the last month.
And what vehicle has she been using?
My wife now?
Yes.
She's been driving my late wife's Armada.
Okay. Are you aware that Ms. Childers has a GoFundMe?
I do. I was made aware of that yesterday. That for reasons I was told why it was made, and then those are not true reasons.
That's all I have.
Baker, you may cross-examine.
Well, how much money is in these Region Bank accounts that you say exist?
So one of them, she told me she had, when we first got together, she told me she had around $100,000 in it
And when was that when you first got together?
about a year ago.
About a year ago. How much is in it now?
Sir, I don't know. I'm not on none of her accounts, and she's not on none of my accounts as far as when it comes to banking.
You don't know. The only one that knows your
I can
wife's
tell you,
condition is.
I know how much was in the one account when she received the check in the mail, when she got the check from her father's estate. I know that check was put into the bank. So I know the amount of that check. It was around $19,000.
Well, the truth is, these things you complain, you're trying to point out here about the breast augmentation and so forth, those were all prior to marriage. Correct?
So, yeah, most of them were, yeah.
Yep. So that money was spent prior to marriage, correct? And this Jeep Wrangler, your daughter's driving that, and the only thing you left your wife to drive was the Armada, correct?
I was told that night that she had to have one vehicle there to drive, and I said, she has a Jeep in the garage. She argued the fact about that, and then they made me leave the Armada.
All right, so this Jeep that your daughter's driving is the one that would be $30,000 to $40,000 was spent on, according to you?
That's what Ms. She told me she had to put it down. She put $30,000 or $40,000 down in cash when she bought it, so she could get it financed because she had just filed bankruptcy.
All right, so she put a $30,000 to $40,000 on a 2017 Jeep a year ago?
When it's been about 2 years ago. It was before we met. She'd already done it.
Well, 2 years ago would have been 2020, correct?
But she had
21?
told me she had received $200-something thousand off the estate of her dad when she sold the home. It's what the house sold for. Now, I guess that would be public record to find the exact price.
Okay. Where are you getting these numbers?
I'm from her. I mean, I don't know. That's what she's telling me.
Okay, so the probate's still not open.
I don't know. I've not spoke to her in a month. I don't know what's going on with that. And I know she received the check from the VA of the money that was left over in his account.
Well, let's get back on topic. Name a single thing that's been damaged in that house since your wife's had possession of it.
I've not been on the property in 30 days. I couldn't tell you.
You don't know a single thing that's been damaged, correct?
Not that I know of, because I haven't been on the property.
Then why are you claiming waste?
Well, I mean, from the pictures I'm seeing, there's been all this stuff being toted in and out of the house. There's all these people coming in and out. There's been over $8,000 in credit card charges made. And if you're buying $800 or $900 in groceries, I mean, how does one person need to live off $800 or $900 of groceries? And you're buying, or all these people, are you having parties over for other people? Who are you buying $900 worth of groceries for?
truth of the matter is you're just worried because you don't know what's going on over there,
Sir,
right?
hey, like I said, sir, I just want my home back. It's my home. I've had the home prior to our marriage, and, you know, I just don't want what I own and what me and my late wife worked for destroyed.
Was you and the neighbor in collusion on the pictures?
Sir, I did not meet her till a couple years ago till she moved in.
Did you have your relative that worked for the police department, did you have her casing your wife?
No, sir, I did not.
Was he recently terminated?
From what I understand, he was terminated, but for some images that was found on his cell phone, from what I'm understanding. I don't know the whole details behind it.
Okay, well, let me go through this. Do you know who made these charges on here?
Yes, sir, I do. I was told. It's who I was told by Amazon who made the charges and whose account they was purchased off of, I do.
Okay. Well, I want to go through here. AT&T Wireless, there's 2 charges on there. Tell me how that affects the value of the house or any waste of that house.
Well, for one, that card was in the house and that purchase was made while I was sitting in jail for something I didn't do.
Do you know what waste of property is?
There's probably different definitions of it by everybody.
Well, waste of properties for lawyers means that you're doing something to diminish the value of that real estate. Show me something on here that diminishes the value of that real estate.
Judge, I'm going to object. That's not the definition, and that's not what it was offered for. I've already said what it was offered for as far as what's going, rifling through the drawers and pulling up the credit cards, and that's the reason why it's being offered. Those cards should have never been used. It was one of those situations where she or anybody with access is charging, and that's the waste part of it.
Mr. Baker is right about one thing, and that is that waste as it relates to real property is one thing. Waste as it relates to dissipation of assets in the divorce of personal property and monies is a different thing. You don't call it waste, you call it dissipation of an asset. But you introduced this information on the idea that those credit cards were there and in the house, and this is what they've been used for, which I don't think goes to the issue of possession of the house. I think it's irrelevant, so I am overruling your objection. You brought it up, Mr. Baker can question about it, but none of it's relevant about the possession of the house.
Well,
It goes to the question of dissipation of assets regarding the personal property and economic aspect.
Okay, well, hold on.
We talking a whole lot
Let me
of
back-
me or a whole
Yes,
lot
let
of
me
you?
back up a minute. So that we're not considering this going to the house, because if it is, I'm going to quit asking
I'm not
questions.
considering that as the issue.
Okay, then I've got no more questions about that. Kind of threw me when you got me on my relevance objection, so I thought you were
It
going
threw you
somewhere
that I
with it.
sustained your position.
Yeah, well, no, the previous one, when this was introduced, I object to it for relevance, so then I'm like.
Well, I allowed it, but then
Yeah.
it had no real relevance to what
Right.
I have to decide after reviewing the file. The only issue before me is possession of the house. I don't think it really relates to that, so.
Okay, and then that wraps up my questions, Judge.
Anything further for this witness?
No, sir.
Thank you, sir. You may stand down.
Thank you.
Sure. Holly, you may call your next witness.
I have a moment with Mr. Claver, please.
Mr. Holly?
We're good, Judge. That's all I have.
All right. Mr. Baker, you wish to call any witnesses?
I'll call Mr. Childers briefly, Judge.
Mr. Childers, you will come forward, please. Raise your right hand and let the clerk place you under oath.
You solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God.
Yes, ma'am.
May sound redundant, but state your name for the record, please.
Amy Lee Childress.
All right, Ms. Childers, when did you move in with your husband?
It was closer to the end of October.
He testified December, but your recollection's October?
That's correct.
All right, now, I want to stick straight to the topic. Why do you need possession of that house?
Because, and I don't want to own the house. However, I do need time to get out of the house. I need the financial funding, basically where I was at prior to living in the house. And he would not let me go back to work. He wanted me to work for C&K Forklift and gave me a handful of credit cards for me to use as money. And I have $594 coming in a month, which is my dad's state retirement.
You have any other source of income right this minute?
No, sir. Everything else is tied up in estate of Terry Childress, and there's, like I said, a pending lawsuit.
All right, how much money do you have in bank accounts?
I do have three Regions accounts. The first two accounts, each one of those have less than $200 in them. I couldn't tell you the exact number because I've had to shut off all my online banking as well as my cards, and as well as the estate of Terry Childress. That is the check that Chris was referring to, because nothing's been paid out yet.
All right, did you start a GoFundMe page?
I did not start a GoFundMe page.
Did somebody start one on your behalf?
Yes, sir.
Okay. Do you know who did that by chance?
Yes, sir. It was actually Chris's daughter, Sydney Claiborne.
Okay, gotcha. All right, now, you realize, your husband's gonna get the house back, obviously.
Absolutely, I want him to.
Okay. But how much time are you needing to get moved out of the house and get ready?
If I've got the resources available to me, I can be out 30 days or less. I want to be out based on the pictures that are being shown. I'm stopped nonstop.
All right, what was your financial position when you came into this marriage?
I had a job making six figures. I was an engineer. We're right at six figures. Of course, I had my dad's estate money coming in, and I had I don't know, probably $50,000 or so. I did have money in savings. However, we've blown through that.
What do you mean specifically? What do you mean since October? What happened to that $50,000?
Well, I had the $50,000. Chris and I dated for a year and a half, and I paid for everything. Or we would go places and I paid for every trip. Or we would go to the store together and he would not bring out his credit card. I would bring out my debit card. So I paid for a lot of stuff and lost a lot of money.
Okay. Give me the total amount of money you think that you've got right now access to.
That I currently have access to me. $400 is what I've got in my bank account, and I have, I believe, $600, and that's set aside to continue to retain you.
Okay. How much was your lease that you terminated when you moved in with your husband?
$2,400, I believe.
All right. And were you still at Electrolux at that time working in engineering?
I was, correct. Technically it was HCL. I was a contract engineer for that company, Electrolux.
Okay. All right. So we'll get back to the question, because ultimately the question is, how much time do you think it would take, or money, to get you back on your feet, to get you moved out?
If I had basically $3,000 a month, which would cover a house for 6 months and utilities until I can get a job again and get packed up, I'm willing to go sleep on someone's couch and be out of there within 30 days. However, I do need funding until I can get a job. I have to have resources.
Gotcha. You got any other relatives close that you could live with?
I don't. I had a mother, or she was like a mother of 20-some years. She passed away in May, and then that was our neighbor. And the following month, my father passed away in June.
Okay. And do you think you could, and I know we don't have a crystal balls, do you think that you might be able to have employment within 60 days?
As long as I'm not tied up in a courtroom nonstop, yes, sir. Sorry.
All right, fair enough. And nothing's been destroyed in that house?
Absolutely not. And if anything, I've been cleaning the house, and I've been moving his late wife's marital property from storage back into the marital residence and placing the items where they were at prior to I moved in.
Okay. Now, that picture it looked like some trash bags or something outside the porch. Maybe it's pizza boxes. What was that?
So Chris hardly took the trash off. It was Logan Brown that always took it off.
Right.
I did not feel safe leaving the house. So the night that Chris was arrested, I threw all the trash that he had previously piled up in the garage. I threw it right outside the garage door. I shut the door, and then Logan Brown picked it all up in his truck or trailer and hauled it off the next day.
All right. The white pickup truck, do you know anything? Who was driving that white pickup truck?
The one with the muffler? Yes, sir. It was Curry Hicks.
Is that a deputy?
She works for the county jail. Yes, sir.
Okay. And you know what she was checking? What was she doing out there?
I've had a lot of friends reach out because I am in fear for my safety, especially when I've seen what I've seen, and I won't go into it because there's an active investigation with the city of White Bluff. However, she had came by the house because she drives by Jeremy Duke's house on the way to and from work, and she left at that time of the morning because she wanted to make sure that my husband was not living there, which was a violation.
All right, and it was Mr. Dukes, was he at the White Bluff Police Department?
Mr. Duke was not at the White Bluff Police Department. Mr. Duke was at home with Chris Claiborne.
Okay. All right,
And that's my understanding, is what she told me.
okay. Mr. Holly, may I ask you some questions?
Okay.
Holly?
So, all right, Ms. Childers, is it fair to say then you're capable of making 6 figures a year?
Yes, sir, I am very capable if I have the time and I'm not tied up in a courtroom nonstop. I was in a courtroom personally with you twice last week and preparing and working with investigators and detectives. That's my full-time job right now.
This happened like the 5th or so of March, and we just started court last week. What have you done from like the 5th or 6th of March to last week to find a place to stay?
Like I said, I've been working on packing up items, and my charges, which were made with a card with my name on them, I had purchased storage units to pack up my belongings, and then I was issued a restraining order from you not to move anything out. So do I move out? Do I stay? So that's where I'm at. I will confirm and tell you, I absolutely do not want the house. I do not want to stay in the house any longer than 30 days. I just need arrangements to get out of the house and the funds to do so. I do not want to be there.
Well, all fairness, it's not your house.
It's not my house.
Have you ever told anybody that you were going to stay in that house forever?
I have not, but actually I have a recording of my husband saying if I would go make a false police report that he would put my name on the deed.
Did you ever tell, you know Pat Jones, you're familiar with her, correct?
Yes.
Did you ever tell Miss Jones that you're going to stay in that house for as long as it takes?
Nope. Absolutely not.
So if she comes in here and says that, then she's not being very truthful.
That would be a lie.
Asked and answered.
Sustained, I believe it was asking.
You said that you had, in previous testimony, White Bluff City Court, you said you had ordered a lot of that stuff on Amazon, and you agreed that you were getting curtains for the house, correct?
And that is correct.
So if you're not doing anything unsafe, and the reason for that was so that your neighbor couldn't see in.
The reason for that is based on the number of pictures that have been taken of this house. I did not feel safe, especially since she's communicating with my husband and there's an order of protection and bond conditions in place.
You lived over there for a long period of time without those curtains on those windows, correct?
Yes, and I complained about that then, and my husband said we would get blinds and put up.
So if you're not doing anything unsavory in that house, why would you need those curtains?
Again, like I said, because there's an order of protection, there's bond conditions out, and like you clearly made available to the court, there are a lot of pictures of my every move being taken.
You didn't like that, did you?
It's not that I don't like it, it's creepy. Because the amount of time that those girls were in the hot tub was maybe 5 minutes. And you have pictures of every vehicle coming in and out of my driveway, including Mr. Claiborne's own half-brother, who is a police officer with Mount Pleasant, who came by the house to go meet with me in Detective Lovell. So yes, it is creepy, which is why I want out of the house.
Matt Brooks.
May?
Childers, I want to show you a document and ask you if you recognize that document.
Yes, sir, I do.
That's a Facebook post.
It is, absolutely.
That's your Facebook post, correct?
Yes,
And you posted this.
yes.
And there's a photo in a frame. And who is in that photo?
That is Chris's late mother, or late wife, I'm sorry.
Wife, yep. And there are 2 wedding rings in front of that photo in a frame, correct?
That is correct, the 2 he never wore.
And you posted some words above that, correct?
Yes,
Can you read those?
Judge,
You-
I want to object to the relevance of
What
this.
is the relevance?
Yeah, it's going to waste. This jewelry, and I can bring him back up later, but these rings were at the house, and these rings
This is
were,
not about possession of the house, this is about, you're talking about personal property now.
well, personal property should be at that house, and that's,
Personal property, real property. We're talking about real property, not personal property.
Okay.
Sustain the objection.
All right, if I could approach. But you're not trying to get even with him just because you own the house to put this kind of stuff on Facebook, are you?
I'm doing that because he kicked his daughter out of the house in basically the same manner, no car, no vehicle, no resources. And I am supporting his daughter as well as his daughter is supporting me.
And you're going to get even with him because of that?
I have no reason to get even with
Do the
him.
activities you're doing now?
No, sir, I have no reason to get even with him. I simply want out of the marriage.
I'm fine. Thank you, Judge.
Redirect.
You think 90 days you can be out of the house and have a job?
As long as I'm not tied up in investigations and courtrooms, yes, sir.
Fair enough. No further questions.
Thank you, ma'am. You may step down. Mr. Baker, you may call your next witness.
That's our witnesses.
I hear you improve in argument.
Well, Judge, briefly, it's his house. We've established that. Been his house for quite some time, him and his late wife's house. You see what's going on over there. The neighbors are, for all intents and purposes, terrified of what's going on next door. And that's not the way that Mr. Claiborne lived. That's not the way this should be going. And there's some reasoning for that, and hopefully we brought that about. But there is some waste going on. Hopefully we've showed that with these photographs. And Mr. Claiborne, again, this is his separate property, and he's entitled to get it back. We're not here on spousal support. There's been no motion filed. There's no notice opportunity to be heard on her with any spousal support and have opportunity to bring in his income and expense statement. We've got plenty of time to do that. We obviously have a order of protection that we have to try, and we have to come in here for some sort of, division of marital debts and spousal support argument for her, then so be it. But right now, she has the means to get out. She's got that Jeep. She's more or less already packed everything up, it sounds like, at this point. And Mr. Claiborne needs his property back. He's homeless, and the business depends on him to be able to get into that house to make a living. He's got much more need for that house than she does at this point.
Judge, the husband has left the wife in a lurch here. You know, we're roughly 2 weeks out from filing this petition. You know, you couldn't even get notice on a detainer action by statute this quick. I think it requires 20 days to even get to a hearing on a detainer action. And the husband is now run into court. Ooh, I want to make my wife, who now I had to quit her job, I want to throw her out in the street with no income, no money, no place to live, and no means to support herself. Judge, I'd ask that we be awarded temporary possession, at least on a 90-day interval, and we revisit this if necessary till she gets back on her feet.
Well, Mr. Baker brings up a detainer action, and essentially that's where we are. This is a marriage of some 5 months. Clearly, the proof established without question or doubt that this property is a separate property of Mr. Claiborne. Ms. Shortis has obtained various things in the way of like an order of protection, which is not before me. It was pointed out, and I certainly have examined this file numerous times this afternoon. There is only one thing before me, and that's possession of the house. Mr. Mr. Claiborne is the owner of that property. It's acknowledged by Ms. Childress that it's his property. She acknowledges she doesn't want it. She's just asking for time to get out. In a detainer action, once the court determines that the owner of the property is entitled to possession, then the occupant is given 10 days to remove themselves from the property. In this particular case, Mr. Claiborne not only is the owner of the property and has concerns about what's taking place in the property itself, but also it is the location of his business activities that is hampering his ability to operate his business. Based upon all the proof, this court is of the opinion that the temporary possession of the property should be given to Mr. Claiborne. She will have 10 days to vacate the property. There is no motion before me regarding support for her or any other economic aspect of it. And it's only solely a possession, and I'm treating it as a detainer action. And in General Sessions Court, it would be the same thing. She would have 10 days to vacate. So that 10 days is operating as of right now, effective starting tomorrow. In addition to that, the restraining order that's previously issued is modified to prevent her from removing any personal property that might be separate property of Mr. Claiborne from damaging or destroying anything prior to her leaving. Mr. Baker, you have stood up.
Well, Judge, if we're treating this as a detainer, I would ask for at least 16 days since we're required 14 days notice on a hearing on a detainer.
Well, I said I'm treating it. It is obviously not a detainer action, so it was a nice effort, but nonetheless, I'm sorry that she is in such a situation that it may call upon her to rely upon friends and so forth. And upon the filing of a motion for spousal support, then certainly Judge Wallace can give you a hearing date and you can come back in before him on your order of protection or the spousal support and have that heard. He'll be here next month or this month? April's this month, so you probably should check with him. All right.
May I address court?
No. What about?
Well, I know I'm gonna ask this out in the hall, so if tomorrow's day one, if I'm looking at that right, that would be the 14th, at lunch or 5.
10 days, starts running tomorrow.
And the weekends and all, that'd be the 14th, so that'd be, we need a time,
I'm
12,
assuming you
6.
two good lawyers can calculate 10 days without me having to do it for you. First day is tomorrow. 10 days from tomorrow will be, tomorrow is the 5th. 10 days from tomorrow is the 15th. That's 10 days.
15th, yes, sir.
She has to be out by 6 p.m. on the 15th day of April.
Yes, sir. Thank you, Judge. Put it in order.
That is the judgment of the court.
All right.
All right. I want to make sure of what we have pending before the court. So bear with me while I go through these motions and then we'll address them all. First of all, is on April the 19th of 2023, a motion for exclusive possession of a vehicle was filed by the respondent through her attorney at the time, Mr. Olin Baker. I have a motion for Pendannular support, also filed April 19th, 2023, on behalf of Ms. Childress. I have a motion to compel and for sanctions, filed May 18th of 2023 by Mr. Claiborne. A motion filed on May 24th, seeking to prohibit the respondent, Ms. Childress Claiborne, from continuing to post on social media negative inferences about him and his company. I have a motion for violation of the automatic injunction filed on May 24th by Mr. Childress. I'm sorry, Mr. Claiborne. I have a motion for no contact order entered or filed May 24th by Mr. Claiborne. A motion for contempt filed June the 8th of 2023, filed by Mr. Claiborne, seeking to have Mrs. Claiborne found in civil contempt. And lastly, according to what I am saying, is a motion filed by Mr. Claiborne for an order removing her, Mrs. Claiborne, from the party automobile insurance. Have I missed any motion? You have two motions that you filed through your attorney prior to his withdrawal, and then the rest of these have been filed by Mr. Claiborne. Is that correct?
Your Honor, that is correct. There should also be one regarding a temporary order of protection that was submitted into the courts on March 14th.
Judge, that is a temporary order of protection. Now,
That was in general sessions. It was on that day sent here to be heard. We never had a temporary hearing. I would like some clarification to that today. That's not on the docket for today. I'm not necessarily prepared to get into any of that, but I think the TRO's expired because of the timeliness of the final hearing when it gets transferred up. And I expressed that to Mr. Baker prior to his withdrawal, and it never was said. So
Your
a
Honor,
little clarification maybe on that would be where I would be.
Your Honor, this order of protection has been tossed back and forth in courtrooms. I've came to court every time expecting that the order of protection be heard. I've not been made aware that it was expired. I simply can't help if the court can't get it before a judge in time.
Well, first and foremost, there is no order of protection. There is a petition for an order of protection that's pending, and we'll hear that today.
Yes, Your Honor, thank you.
All right. Then, under those facts, it would appear that Mr. Claiborne is the plaintiff, so we're going to allow you to go forward with your motions first. And, well, actually, I guess she filed hers contemporaneously, or at least time-wise, hers were filed first. So, Ms. Claiborne, you are representing yourself. If you'd like to come forward and you want to testify.
Yes, Your Honor, I would. And no disrespect, but I would like to state for the record, my legal name has always been Amy Childress. I've never changed it. There's never been any indication that my name is Claiborne, and Mr. Hawley is fully aware of that.
Well, the petition that was filed for order of protection identifies you as Amy Lee Childress Claiborne. I don't know who filled it out, but it was not me. So I will address you as Ms. Childress.
Thank you, Your Honor.
I don't think
Don't mind
Mr.
doing the
Claiborne has
same.
any problem with addressing her as Childress.
I don't have any problem with that. I can tell you, we've known her as Miss Claiborne. She did a will outside of my office and said her name was Miss Claiborne, so, but whatever she wants to be called today is fine. I have a little preliminary motion before she begins to testify about the support motion, and that is what I kind of talked to the court a little bit about earlier, and that's for my motion to compel her for sanctions, mainly because we've had this discovery outstanding since mid-April, and that was when Mr. Baker was there as well.
What does your discovery motion relate to?
I don't have it. I filed it and I don't have any discovery. Nobody's ever responded to it.
What information are you seeking in your motion for discovery that you feel like is relevant? In other words, what I'm trying to do is to identify what I can address in these motions today. And if you're saying that you have to have the answers to the interrogatories or your discovery before some of it has to be done, that's so be it. But for example, the petition for order of protection does not require discovery, and normally there's no discovery made in that. So certainly we can go forward with that. The next question would be on all of these other motions, such as spousal support and so forth. Are you saying that you must have your discovery responses before you're prepared to do that?
What I am saying, Judge, is that, of course, I don't have it. The financial questions are in my discovery. I believe she has a job. She's asked for, I think, the Armada, which the Armada's been sold. We get into all that testimony, but the bottom line is, I think she has transportation, which I've asked about in the discovery. I think she has a job and an income, money in the bank. There's a lot of financial issues that goes with her motion for spousal support here today. I just don't think it's fair that we can sit on this for what, that's now about 4 months. And if I had that, it would definitely streamline these motions today, I will say that. But long and short of it, I think it's only fair that I get the answers to my discovery, which were due prior to the setting of this motion in the first place, before we come in and want the spousal support. I'd like to have the answers to some of these questions so that I can prepare and put together a defense to this and know what I'm objecting to, what I'm going to allow, what the actual figures are going to be in some of this, so that I can put a decent defense in front of the court and not waste the court's time.
Your Honor, if I may.
You may.
The interrogatories were entered as a response to the final or the divorce proceedings. The motions that were filed were to grant me spousal support and other aid that I might need until that time. I did respond to the interrogatories or the discovery request to the best of my ability. However, a lot of these questions are either not relevant, they're being sought to call out names of individuals who are continuing to be harassed through this court system with the information being obtained, as well as there are multiple criminal cases going on currently, and I do not wish to disclose that information until after the criminal trials have taken place.
Well, you don't really have that right. In a criminal case, the only person who has a right to avoid answering questions is a criminal defendant. The defendant has the right, under the Fifth Amendment of the Constitution of the United States, to decline to answer questions that might tend to incriminate him in a criminal action. So you will have to answer those questions whether you wish to do so or not. And under the discovery rules and the rules of civil procedure, if you refuse to answer the questions, then it only gives me a couple of options. One of them is I can hold you in contempt, which I don't want to do. Another is I can order that you have to pay the attorney's fees for the other side, which obviously you're probably not able to do. And a third one is I can dismiss your pleadings in the case, and that allows the other side to proceed on a default basis. None of those are good aspects for your side of this case. So I'm concerned that you need to understand you don't have the right to simply say because there's a pending criminal case that you're a victim or alleged victim in, that you have the right to simply refuse to answer civil litigation questions. You, at this point, have the right to proceed on your petition for order of protection. I am going to allow Mr. Holly to argue his motion for to compel production of documents, if that's how you wish to proceed, and then I'll decide where we are at that point. So on these other motions, you want to come to the podium, and I'll hear you on your motion to compel.
And Judge, may I address the court too on that order of protection? I'm just sitting there thinking, I wasn't prepared to do that. There was no notice that today was going to be that hearing. I've got video basically of what transpired during the entire domestic assault from the outside cameras of the parties. And I don't have that with me here today. We played in general sessions in White Bluff. I think the court may want to see some of these things if we get into this order of protection hearing. And I would need it for a proper defense. But that order of protection, as far as I know, I never got any notice that it was going to be set actually for today.
There is no notice in the file about it.
I'm just asking for a continuance so that if we're going to do the order of protection, so I can put everything in front of the court.
Well, it's not on the docket, and as a result, it's not a question of continuing. It's actually a question of setting it. If you're not prepared, then I cannot force you to go forward on it because it was not set. So we'll have to find another day for that. But let's hear your motion to compel and find out if there's any of these things that I can actually hear today. First of all, are all of these folks that are in the courtroom witnesses, or are they here with the rest of the folks that are here? Are they here on this case?
I think
Your
there's
Honor, I didn't
potpourri
subpoena.
of all of that. And I would ask for the rule for the witnesses to at least.
Rule has been requested. That means that anyone who's going to be a potential witness in this case, other than the parties, must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You are to not discuss the testimony of any other person until you yourself have been called to testify.
And Your Honor, I would like to request to clear the courtroom. This individual right here was my childhood best friend. She's been brought in here every time to intimidate me. I would request to clear it.
Don't have a right to clear the courtroom. We are a public proceeding, and as a result of that, unless they're a witness, you don't have the right to. Anyone who's in this courtroom will conduct themselves appropriately. There'll be no intimidation or attempt to intimidate, or I'll have them removed and held in contempt.
Thank you, Your Honor.
But I am simply telling you, you don't have a right to close a public proceeding.
Thank you, Your Honor.
Next thing is that I don't know if the monitors outside were on or off. Would you double check to make sure?
I'll go double check it.
All right, let's deal with your motion to compel.
Well, Judge, as always, these are kind of simple. And my motion states the discovery was filed on the 10th day of April this year. I sent an email to Olin Baker on the 21st day of April asking if the discovery was going to be filed. He already talked about getting off of the case a little bit. I want to make sure I got a letter into him before he left, if he was actually going to withdraw. And I do not have any answers. My standard discovery ask all the financial basics of the other side. Is there money in the bank? How much money do you have at your disposal? Do you have employment?
what is your pay produced to me in the request for production of documents, your pay stub, your tax returns, all of these things that would be beneficial in me trying to ascertain whether or not she would have even a need for discovery or be able to handle the expenses herself for whatever her living condition is. And I don't have any of that. And I don't think it's fair for that to wait for 4 months when this motion was outstanding since, or her motion, I guess, was outstanding from what the court has said. The motion for pendant light support, I don't have the stamped filed copy, but it was signed by Mr. Baker on the 19th day of April 2023 and certified to me on that day. And purposefully, we've had absolutely no attempt to answer these questions. There's none. If the court wants to see my discovery, it may take me a minute to dig it out of my bag over here. I'll be glad to do that. I don't have it on OneNote.
There's a copy of it in the file.
Is there? Okay, so I filed this one. I do some, and then with the Nancy Miller rules, sometimes I don't. But in this case, I did, and the court can very well look at that and see some of these questions would be definitely on point with whether or not she would be entitled to any spousal support. I'm not saying she can't bring a motion, but I would just like to have an answer. Part of the sanctions and the motion to compel and sanctions would be that she provide me an answer to this prior to taking this up.
Ms. Childers, you want to come to the podium? I'll hear you on why you should not, why you haven't answered these questions and why you should not.
Yes, Your Honor. Again, at the time that these were filed, I did have a retainer in to Mr. Baker. Mr. Baker did forward these to me. I did respond to the best of my ability. Some of these questions in here are not relevant to a 5-month marriage. Where he's going back and asking things of all of my communication, social media, phones, you name it, from the last 12 months. He's asking information pertaining to my father's estate, which has nothing to do with this marriage. I'm simply stating this is a 5-month marriage. There was no debt. There's no children involved. All I'm asking for is just the spousal support to get back on my feet in a divorce. There's no need to drag this out. I don't have the money to fight this. I truly don't. You see the number of motions that have came at me. I just simply don't have the money. I've tried to get a retainer in order to fight this. I don't have the funds. I just started working in May, and I've had to purchase my own home. Since April, I was given 10 days to leave the marital residence. In that 10 days, I had to sleep on my stepdaughter's chair for several months, had to move again, finally got employment, and that money, it's every penny that I make is going to currently how I live and to pay people back. I simply don't have the money to fight this. I am prepared. Look, I am prepared to sign papers, walk away, and cut our losses. The only option that I've been given by Mr. Claiborne is I can live in the marital residence for 6 months. He would pay all the expenses. However, he wanted me to lower the bond conditions or the order of protection. I do not wish to do that. I've even gone as far as I would walk away with nothing, as well as if he would leave me alone, I would consider going to the DA on this domestic, but it's just not stopping. I just simply want a divorce. We don't have any real estate together. We don't have any financials together. We lived for 3 months together. That was it.
Well, a 5-month marriage, one of the factors that the court has to consider in any sort of spousal support request is the length and duration of the marriage. It also is the separate assets that the parties have and the income that the parties have. So all of these issues are relevant if we have to have a contested hearing. If you're telling me that you're wanting to just terminate your marriage and walk away, count your losses or whatever, I'll take a recess. You and Mr. Holly can talk about this case. If y'all come to an agreement, then so be it. This is not a proceeding whereby we bargain criminal proceedings versus civil proceedings. So, I mean, that's a decision you can make, but it's not part of what I condone as part of the situation. But the district attorney's office is readily available, and if you all negotiate something that you want to resolve so that you're done with Dixon County and can be on your way, then I'll certainly give you an opportunity to do that. So I'll take a short recess and let you and Mr. Holly talk about it, and we'll come back to it. Otherwise, I'm going to have to order that there be an entry of an order regarding the discovery, because it is going to have to be answered under oath. We'll stand at recess for about 15 minutes.
Yes, Your Honor.
All rise.
You have argued your motion to compel, and there's no agreement reached between the two of you, so your motion to compel is granted. Ms. Childress will file her responses under oath, making full and complete answers to all of the questions, or pursuant to the rules of civil procedure, she will file an objection. If you need to access the rules of civil procedure, you can do so online, I think through the administrative office of the courts, but you will either have to answer them fully under oath within 30 days, or you will have to file an objection and state the reason why you do not feel you should have to answer it. Then I will consider at a later date, or one of the other judges will consider at a later date, whether or not you're justified. If you are not justified and have failed to answer them despite my order, then sanctions will be applied. So be careful when you object to it to make sure that you have a valid legal reason to object, or else it could come back to haunt you. I've already shown that the order of protection will have to be, there was an order of protection temporarily issued in general sessions, and it was transferred, but under the law, that order was only valid for 15 days because it was issued ex parte. That means the petition is still pending, but there is no current order of protection in this court's opinion. The issue of your request for attorney's fees on the motion to compel is reserved. Are there any other motions that you wish to address, Mr. Holly, before we adjourn?
Judge.
Seems to me that you can't have it both ways. If you're asking for a continuance in order to obtain this information before you can proceed on some of them, then we'll be resetting everything.
I understand that. What I would say to that, as far as the motions that have been filed, first of all, it's a situation where I have trouble talking to Ms. Childress. I just think we can't seem to communicate. So I'm having to file motions in a 5-month marriage, and that's just where we are with these folks. The motion for contempt for the dogs, the motion for contempt for the Armada, I'm going to pass those. We got the dogs back, we got the Armada back. And a little bit here, the court entered an order April the 17th, and it was from a temporary hearing that we had. Mr. Baker was here. If you recall, there was a witness, a neighbor, that got on the stand and testified about the pictures of the home. It's over there in White Bluff, the end of White Bluff, over by Craigie Hope. The court said you knew where it was.
I know where it is.
Went through the whole thing with her. You found her to be credible, found the pictures to be credible over objection, and ordered that Mr. Claiborne could have the home back. Mr. Baker and I had entered into an agreed order regarding a restraining order that we had filed, and we had an agreement. We had announced that agreement prior to the hearing. This court's ruling, at the end of the day, you went back to our agreed order and said, I'm going to modify that just a little bit for you gentlemen, and I'm going to add a paragraph to the end of it that says that the wife is restrained from removing any of the personal property of the husbands from the husband's residence located at 5278 Highway 70 East White Bluff, and or damaging and or destroying any of the personal property that might or is a separate property of the husband. So that was in place. We got the home back, not on that Saturday like the court anticipated. I didn't get the order, the ability to sign it from Mr. Baker until a little after 4 o'clock on Friday, so everybody's closed. White Bluff Municipal demanded an order before we could go in and hear, or go in and take possession of the home. So we came back Monday with the order, you signed it, and we went back in that Tuesday afternoon and took possession of the home. And an abundance of caution, as contentious as this has been with her putting everything on social media, you've seen the motions, what's attached to the motion for social media prohibitions and things of that nature. We hired 2 off-duty police officers to go inspect the home first to get any liquor, any guns out. The court has said that the temporary order of protection has expired. However, there is some recourse because he still has those domestic bond conditions. We have adamantly opposed that domestic. It's currently set for trial. And Judge Creasy is representing him on that. But what happened when we got the ability to go in the home on that Tuesday, it's been cleaned out. There's all sorts of damage. You're going to hear and see photographs of white powdery substance in the gas tank of the new Harley, water in the gas tank of the side-by-side. Somebody defecated in his clothes drawer. There's urination stains all over the place. There's a whole list of things, TVs, jewelry. We've got about $8,000 worth of jewelry that is missing. We have seen this on different sale sites on the internet right now. I fear that if we don't at least be able to have heard the motion for contempt for the stolen damage in personal property, some 42, we're estimating that to be by our list that's attached to the motion, some $42,000 worth of personal property and damages. The personal property will be just that much further out of reach. So that's a fairly important motion for Mr. Claiborne at this point, whether it's today or a quick reset. But the two officers are here to testify about what they found, the condition of the home when they first went in. Then they went in, inspected it. There was some alcohol in there, which they got out and gave to a neighbor friend. There were no weapons in there, so they cleared it for him, and then he came in and took it over. They're here to testify, and we've had to pay them because they're off duty. They're privately hired, and they've been here on both days. It's a little expense to Mr. Claiborne to be able to do that. I just feel like this one, particularly this one motion, needs some attention soon. I'll put it that way to the court. I understand the court's reasoning of what you're saying. I'd like to be able to do it today, or at least be able to put the officers on so we don't have to pay them anymore, if that's a consideration. The posting on social media, the no contact, that should be a relatively simple motion. I mean, if we're going to hear that, I stand on basically what I filed. I mean, I put all the social media posts that's attached. I don't think it's hard to say that, both parties would not have any contact, or both parties would, not put anything on social media, that sort of thing. But we're concerned about the personal property, and it's just and if the court will remember it kind of, the photographs resembled something going on in the Animal House movie over there, and I just, and Mr. Claiborne does as well, want some sort of relief for this personal property, or at least figure out maybe what she's going to say where it is, or if we can get our hands on any of it to preserve it. That's the divorce case. It's a 5-month marriage. They don't have anything else. But that particular motion right there is pretty much our divorce case in full.
Ms. Childers?
Yes, Your Honor, I did attempt to speak with Mr. Holly. He basically held a piece of paper in my face and said, "Where's my $100,000 worth of stuff?"
I don't care about
Okay.
that. You just tell me, are you prepared?
I am prepared to speak to the theft and damages today. I have video myself, I have witnesses, and I have receipts for
All
everything.
right, then we'll hear that.
Yes, Your Honor. And I would also like to hear on the no contact, I would like to hear that, as well as he had brought up another, he had filed a motion on accessing email accounts previously. He filed another motion against me again. I've turned over that email address. However, I never received any of my account information, and I would like to hear that motion as well today.
We will hear every motion that both sides agree can be heard. So,
Yes, Your Honor. Thank you.
Mr. Holly, you may call your first witness. This will start with the motion that you filed for civil contempt on June the 8th of 2023, correct?
Yes, sir.
Right.
Hunter England, he's out in the hallway.
You'll step around here, please, and face our clerk and raise your right hand.
Macy.
Mr. Anglin, state your full name for the court, please, sir.
Hunter Anglin.
And are you employed with the Dixon County Sheriff's Department?
Yes, sir.
Do you have a chance to do some off-duty work for Mr. Claiborne?
Yes, sir.
Did you have a chance to go out and do a civil standby for him when he was trying to get his home back?
Yes, sir.
And what date was that?
The first time we went was on 4/15/23.
Okay. Tell the court what happened that time.
On the first civil standby, pretty
And I
much.
just say that was a Saturday, right?
It was, yes, sir.
Okay, go ahead.
The first time we went for the civil standby, it was due to a recent court appearance where Judge Wolf had signed off that he could have possession of the property back. My whole purpose for being there the whole time was just to check the house for firearms and alcohol, and that was it. The first time we went, we got canceled because I realized there wasn't a signed copy by Judge Wolf. So I actually ended up canceling the civil standby that day.
And was White Bluff Municipal Court demanding that as well?
From what I've gathered, former Officer Jeremy Duke had spoke with White Bluff or been in contact with them, and White Bluff actually drove by and I said, without this signed paper, I'm not going to do it. So the first day we left.
All right. And then you came back then that following Tuesday, and we had a judge sign, stamp filed order that said Mr. Claiborne could take back the home.
Yes, sir. That was at 12 p.m.
Okay. And explain to the court how you found the house when you went in.
How I found the house, I'd never been there before. So pretty much when I went, we left Mr. Claiborne outside. Sergeant Lashley was already on scene. I did observe him carrying out some alcohol bottles because that was the whole purpose of us being there, was to get the firearms and alcohol out so he would be in accordance with his bond conditions. After that, we went through the house. I did notice a few things. And after we realized that we got everything, we just wanted to double check. So we actually got Mr. Claiborne to come in with us and walk through. But I can't say how the house ever was before because I didn't know either party.
I'm just asking how you found the house when you went in. Was it?
It was fairly empty, honestly. There was furniture. There were big trash bags, I believe, in the kitchen that had leftover crab, and it really made the house stink up. If you got near the kitchen, you knew it. Items were in disarray. I walked through, like I said, just to make sure, because we wanted to make sure he was in accordance. I did observe his Harley in the basement. It had what looked like powdered sugar or something around the gas tank, but like I said, I'd never seen it prior. Couldn't say what the substance was. But anything after that, if you're asking, the house was, it kind of looked like a newly modeled house, really. Like it was empty.
Okay. And as far as you entering the home, are you saying you entered it before Mr. Claiborne went in?
Yes, sir, I did.
Okay. Did Mr. Claiborne have any opportunity to sabotage this house to make it look like that?
I was there on the 15th, and of course I left. I didn't sit there the whole time, but no, not on that day because we had left him outside specifically, so he was not in violation of his bond conditions.
All right. And did you have an opportunity to serve one of the witnesses here today?
I did.
Which one?
Mr. Colin Dever.
Okay. When you served him, what did he tell you about Ms. Childress?
He was very cordial. Mr. Dever was very polite. When he opened the door, I think he was a little bit shocked to see me there. And I handed him the paper and I said, Mr. Devers, you've been served. And he said, is this about that bitch Amy? And I said, sir, I don't know Amy. You'll have to read the paperwork.
Your Honor, I'd object. Mr. Collin is outside. If we could ask him those questions directly.
We absolutely can.
Objections based on the hearsay statement, I sustain the objection.
So, that's all I have. Thank you.
Do you have any questions for this witness?
I do, Your Honor.
Come to the podium.
Deputy Anglin,
Yes, ma'am.
Can you tell me what time you arrived at the house on 4/15?
On 4/15, it would have been after 6, ma'am. It was roughly, I know I was passing Montgomery Bell. I went back on my text messages at 5:50-ish. But I wasn't supposed to be there till 6. And like I said, I'd never met either party involved in this. I was only there just to make sure there wasn't guns there.
Gotcha. Can you specifically speak to the damages that I mean, this list is pretty big, and you said the house was pretty empty, so.
I never made a list of anything. Like I told you, Attorney Holly on that, I never knew what the house looked like before. I didn't know either of y'all.
But there, I guess let me restate it. These 2 deputies, you've been one of them.
Yes, ma'am.
That was hired, is testifying to close to $100,000 worth of damages and items being missing. You stated that the house was pretty much
Judge,
empty.
I'm going to
I have no
object. That
knowledge.
wasn't part of my questioning and wasn't part of his answers to that. There's no way he would even know that.
Sustained.
Did you state that the house looked empty when you went through it?
It honestly, Miss Amy, it looked kind of like a house that was up for sale, really, because there was things kind of moved, but most of the cabinets were empty. It's like it had been cleaned out.
Did you interact with Officer Matt Ray with White Bluff Police Department on 415?
I don't know that name, ma'am. Did you say Matt Ray?
Yes, sir.
Who? Never heard of him.
Officer Ray with White Bluff Police Department?
I've never heard of an Officer Ray.
So what other date did you go back into the house?
Are you talking about the first time? I didn't go in the house on the 15th.
That's the second time,
The second time, that was the 18th, ma'am.
on the 18th. About what time?
We were scheduled to be there at 12. I looked back on my text as well to be specific. I was passing in relation the backside of Montgomery Bell just before 12. So I'm assuming I got there around 12:10 probably.
Okay. And so if I'm understanding this correctly, Mr. Claiborne never entered the home on 415, correct?
That would be a question. He did go in after myself and Sergeant Lashley had already went in.
So after y'all had exited the home,
Sergeant
correct?
Lashley was actually inside once I arrived at 12:08, 12:10 in that area, and he was carrying out liquor bottles and giving them to, I guess, one of Mr. Claiborne's family members.
And that's on the 18th.
Yes, ma'am.
On the 15th, did anyone specifically go into the
No
residence?
one entered the house. We did get a complaint about a dog possibly being in there. No one went in the house at all on the 15th, and I made sure of that because I did believe Attorney Holly that he said that the Honorable Judge Wolf had signed off on it, or not signed off on it, but he had ordered he could. But without something doing my job for as long as I have, I'm not going to go in unless I see it on paper.
Are you a client of Mr. Holly's?
I have been in the past.
So that would be your relationship with Mr. Holly?
No, that's not correct. I've been friends with Judge Holly, Attorney Holly for 20 years.
But you are a client, correct?
I wouldn't call myself a current client. My case is,
According to the news media, you are. Mr.
at
Holly.
one point it was.
Object to the
You're
relevance.
kind of going out
It's
there.
relevant to state
You need
the,
to address me rather than him. He's objecting to the relevance.
Sorry, Your Honor. It's relevant because if Mr. Anglin was hired by Mr. Claiborne as his personal deputy to go inside this house, I know the 2 deputies involved in this case are personally directly connected to Mr. Holly. And there is relevance there. So I would request to allow it.
How does it make, relevance means that something, a piece of evidence that makes an issue more likely to be true than not. That's why it's relevant. What issue are you trying to say? It makes it relevant that he was a former client or a friend or whatever of Mr. Holly.
Because of the law enforcement involvement, Your Honor.
Sustain the objection.
Were you reprimanded by Lieutenant Humphreys or by your,
Oh, absolutely not. They looked at the complaint and said they were frivolous.
okay, so
Your complaint.
Lieutenant Humphreys' text message to me would be,
Yours was
Incorrect.
frivolous.
okay, I have a text message from Lieutenant Humphreys that
Argumentative.
Judge, I'm going to object to the hearsay of that.
Well, number
it's
one,
not, sorry.
You cannot, your job right now is to question, not to make statements or offer evidence. So you can ask questions of this witness, but you cannot state facts as you believe them to be. So sustain the objection.
So you were not reprimanded,
Oh,
correct?
no, not at all.
No further
I was
questions.
told to have a great day.
Anything further?
The door is open. Ms. Childress did file a complaint against you for this civil standby, correct?
I've never met the woman.
Well, I mean, she did file a
Oh,
complaint against you.
she did.
And what was the, excuse me, what did you go through in the process of that with the sheriff's administration?
Oh, about a full support from them, about a 10-minute meeting, and they figured out it was frivolous.
And they took what action, if any, toward her
Nothing.
complaint?
Told me to have a good day.
Thank you.
Your Honor.
Too bad.
If the court will allow it, I have my cell phone out of my vehicle where Lieutenant Humphreys is in fact confirming that there was reprimands
She's
involved.
asking to get in some hearsay.
Well, Mr. Hawley, you went there with it. I mean, you're the one that said that I made these motions against, or these complaints against him, and I do have the evidence that it's not frivolous.
Well,
I got promoted to sergeant.
Everybody stop talking except me and listen to me. Number one, any out-of-court statement you have in the form of a text message is considered to be hearsay and would therefore not be admissible. If you want to subpoena the person that supposedly made that statement, then you can bring them into court and have them testify. But I will not allow you to bring in a text message from another person who's not subject to being cross-examined here in the courtroom and have that brought in to disprove or to prove a fact. So I'm sustaining the objection on the basis of it is hearsay.
Yes, Your Honor, and Lieutenant Humphreys is out on medical this week, and she was not allowed to be here, so if I need to have her subpoenaed at a later time, I will.
Your call, I'm just simply saying your text message is not admissible.
Yes, Your Honor.
Anything further? Thank you, officer. You may stand down.
Thank you, Judge Wolf.
You are released from your subpoena. You may go about your business. Call your next witness.
Chris Lynch. Mr. Engel was asking if he could stay in the courtroom and watch.
Public proceedings, and you may stay as long as you like.
Thank you. Thank you.
Come up, sir, and raise your right hand.
Do you solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
You will, for the record, state your name, sir.
Christopher Stanley Lashley.
And what is your employment?
My employment, I'm a Dixie County Sheriff's Patrol Sergeant.
Did you have an opportunity to go to the home of Mr. Claiborne off duty as being employed by Mr. Claiborne to do a civil standby?
Yes, sir, I did.
And that was on a private basis, correct?
Yes, sir.
And you went there on a Saturday, I believe it was the 15th of April, somewhere around in there?
Yes, sir.
And tell the court what happened on that day.
Well, we got up there, got a copy of, we were supposed to go in there, make sure there wasn't any guns or alcohol in the residence.
And that was because of the violation, possible violation of bond conditions, correct?
Correct, correct. And so we got up there and we're looking at the order, and the order wasn't signed. We had to terminate it. We could not go in.
Did White Bluff Municipal Court ask for the order before you could go in?
They did.
All right, and they're the ones that said without a signed order, they're not going to allow that at that time.
That's correct.
Do you have any doubt that if Mr. Claiborne would have went there on Saturday without a signed order, that would have been an altercation between him and the White Bluff Municipal Department?
I'm positive it would have been a violation without the judge's signature or attorney's signatures.
And then you had opportunity to go on that following Tuesday, correct?
Yes, sir, I did.
All right, and explain to the court again what happened when you got there and get into how you found the house and that sort of thing.
On the 18th, how I found the house, I had served a subpoena there before.
I mean, like the condition of the house, how you found the condition of the house.
Oh, okay. Well, the house, it was vacant. Nobody was there, empty. We were concerned about pets being in the house. There were no pets in the house. The house was, it was stripped down. It's like most of the stuff gone out of it, except for the shop area, from what I could tell. Kitchen was a wreck.
How so?
It was just trash everywhere. There was stuff in the trash can it was like food put in there, and it was just a rotten smell to it. After that, we walked around and removed any alcohol that was in the residence. Did not see any firearms in there. And then I had Deputy Angler, Sergeant Anglin, at the time, that's what I call him. But he come in there after me, and, I had him do another walkthrough with me. After that, we went out to the driveway and got Mr. Claiborne and allowed him to walk through to make sure everything's good, because we took out everything we could find.
Everything you could find being alcohol or gun related?
Yes, sir.
Okay. And based on this, has Ms. Childress, we got into it earlier, has she filed any complaints against you with the sheriff's department?
That is correct.
What was the basis of those complaints?
Basis of the complaints was where I'd met up with her. I had went on duty and served one of the papers on her, because off duty she would not answer the phone or.
Officer Lewis, Sergeant Lewis, pull that base of that microphone closer to you. You can lean back as long as that's a little bit close. There you go.
Sorry, Judge.
That's all right. Go ahead, I'm sorry.
What was the outcome of that investigation with the sheriff's department?
The outcome, there was no policy violation, but the ethics part of it, I was told that I cannot serve anything while on duty anymore.
So have you had an opportunity now that this is all going by? Well, strike that. Is there anything else that's come about this in the last couple of days?
That's correct. I was informed that as one of the news stations wanted a copy of mine and Hunter England's work file or a personnel file.
Okay, somebody complained to the news and?
Yes.
All right, nothing further.
Ms. Childress, you have questions for this witness?
Yes, Your Honor. Mr. Lashley, what time did you arrive at the residence on the 18th?
On the 18th, it's somewhere around noon, maybe a little after.
Okay. According to Mr. Hawley's motion, there were drug needles, there was people had defecated in the house, supposedly. There were prescriptions missing. Did anyone take any DNA or take any pictures?
I don't recall any of that.
So $100,000 worth of vandalism and items missing and defecation.
I don't object to the relevance of the $100,000. I don't believe I ever said that. The list is attached to the motion. It's around $42,000.
Sustained as to the form of the question, you may rephrase.
Sorry, I misunderstood Mr. Hawley on the hall. $42,000 worth of items. Any pictures taken?
No, that's not what I was there for.
Was there a report taken? Any type of report, any type of statement?
Not that I recall.
So you're just here testifying on what you observed? No pictures, no DNA, nothing, right?
I was there on hired out personally.
No further questions, Your Honor.
Mr. Hawley?
Nothing else.
Thank you, Sergeant. You may step down and you may leave or you may stay as you choose. Call your next witness.
Mr. Claiborne.
You're Chris Claiborne, correct?
Yes, sir.
And you've heard the officers, or the off-duty officers at the time testify about you getting the home back on April the 18th.
Yes, sir.
Is everything that they testified to accurate?
Yes, sir.
Yeah. And when you got into the home, there was no alcohol, no guns or firearms or anything of that nature, correct?
No, sir. There was very few bottles of the alcohol that was left at the home out of the collection that I had collected over the years. And then the firearms were missing from the home, 3 of them, 3 pistols.
And because you have bond conditions on the domestic, you're not to be in possession of alcohol or firearms, correct?
Correct.
And you were concerned if you went to the home that it would be in the home and you might get in trouble.
Yes, sir. That's why they was sent in to retrieve the items first before I come onto the property.
And you understand today that we have filed this motion for contempt for stolen, damaged personal property.
Yes, sir.
And overall, when you got the home back, how long did it take you to go through the home and to see what was missing, damaged, stolen?
You know, me and her, the home was mine prior to the marriage, and it was mine and my late wife's home. We was together for 20 something years. So, I mean, there was, it's a lot to go through a 20-year marriage of stuff. And so, I mean, it took me weeks and weeks and weeks to go through. Like, even since this has been filed, I've still come across odd and end things that I'm missing still, like another Yeti killer that I forgot, like a long green zip up. When there's still stuff I'm finding missing today. I mean, I'm just like it took me a month almost to go through this house. I mean, we have all kinds of totes in the attic, and there's all kinds of stuff for business that's tied into it. I had to get back and find business receipts because when I went back into the home, a lot of the stuff in the garage had been put in boxes that belonged to like parts for work and stuff and this and that. I'm trying to figure out what I had and what was missing. All kinds of just different things.
And to be clear, refresh the judge's memory a little bit, you have a forklift repair
Yes, sir.
business,
I own my own business.
C&K forklift.
Yes, sir. Me and my late wife started it together.
That's the C and the K, Chris
Yes,
and Kim, correct?
Yes.
And you repair forklifts.
Yes, sir.
And you do that primarily out of your home.
Out of my home. Yes, I keep all the parts and stuff stocked out of my garage and stuff at the home.
Okay. And I know we've got some photographs of this we're going to get to. Did you, and you heard Deputy Anglin talk about a white powdery substance in the Harley Davidson.
Yeah.
You had a Harley Davidson?
Yes, it's a brand new, it's bought in 2019. When I first entered the home that day, when I pulled onto the property, everybody was.
It was a 2019 Harley?
Yes, 2019, yes. Sir.
Okay.
Yeah.
And it was there when you got dispossessed of the home on this domestic charge, correct?
Yes, sir.
And was there a white powdery substance around the gas tank when you left?
No, sir. I'd been riding the bike, I think, before then or something. I'd been in the garage because I had moved it around because I had took the side by side, had some work done to it and brought it back.
When you got back into the home and you noticed that, describe it to the court what you saw.
Me and the deputy and somebody else was all kind of standing in the garage and leaning over the bike. And I started looking at the bike, opening up the saddlebags and stuff, and I noticed the keys were gone to the bike. I always kept them down in one of the saddlebags on the bike, and I just sat there and I flopped the gas tank open and turned popped the top up off the gas cap.
David, pull that microphone closer to
Sorry.
you. You can stand back, but just pull the base of it closer. There you go.
I pulled the lid up where the gas cap is, and I said like something white. I screwed the gas cap off of it, and then when I did, it was just there was white powder everywhere down, like somebody put white powder down in the gas tank because it was all around the gas cap and everything on it.
Did you drain the gas?
We got the side cock loose on the bottom of the tank and got some of the gas out to kind of see what it was. And then a day or two later, I went back and I had to pull the complete tank all the way off the bike and drain everything and flush the tank out.
And what did you find in the gas tank of the side by side?
Water, because when I had got back to the house, there was no keys or nothing. All the keys were gone. We actually found one key hanging up in the kitchen to the side by side. So right before I had got removed from the house, I had just took the side by side down to America's Motorsports and had a lift kit put on it. And when I parked it back in the garage, it was sitting completely on empty because it hadn't been rode. So when I found the key, I went downstairs and I pushed the power button on it. And when I pushed the power button on it, it went straight over to full. So I cut it back off real quick because I knew something had to be wrong because I had not put no gas or nothing in the side by side. So then I had popped open the glove box and stuff on that, and noticed there was stuff missing out of the glove box of it, and there was another insurance card inside there.
Did you find water in the gas tank?
We did. We drained the gas tank on it, and it was pretty much about 95% water in the gas tank.
The defecation in the drawer, can you describe that to the
It was
board?
on, when we took some of my clothes, it was up there. I had set on some of my clothes, which had been put in bags. I guess she bagged a lot of my stuff up, and it was set up. And so we put some of the stuff up there on top of the dresser. And in my bedroom, my dresser sits on pads. So if you scoot it, it won't scratch the hardwood floors. So I had set stuff up there, and some stuff had fell behind the dresser. And when I slid the dresser out, some of the drawers had come open in it, and I kneeled down to get stuff. I looked up, and there was something smeared underneath the bottom of the two top drawers on it. And I got to look, and I scratched something. It was some kind of feces had been put underneath the bottom edges of the drawers.
What about the urination in the bed? Can you describe that to the court?
I'm sorry, what, sir?
The urination on your bed?
We went in one of the guest bedrooms, when I had entered the home, it had a comforter through over the bed, and I pulled it back and noticed there wasn't no sheet on the bed. It was just a comforter on the bed. And so whenever I pulled the comforter all the way back, it was a pee stain all the way around the bed. I mean, the whole size of the bed, like somebody just had peed all the way over the whole entire bed. And just do a comforter back over the top of it with no sheet or nothing.
How'd you find the hot tub?
It looked like somebody had a wild party in it. There was beer bottle caps on it. Like somebody had puked all in it. And there was just puke or something, or some kind of puke looking thing all in it. It was all stocked up. I've spent hundreds and hundreds and hundreds of dollars trying to get the hot tub back in the right shape, trying to get it fixed back.
Did you find any like drug needles at the home?
I did. When we was over there was trash that had been, there was probably about 6 or 7, 8 bags of trash. It was put on one of my trailers that sits outside. And then there was about, 6 or 7, 8 bags of trash on the back porch. When we first got there, we was going through some of the stuff. And then one of the bags that we opened up that was outside, there was a needle in it. And then when everybody kind of got going through the things, and we started pulling all the stuff out of the trash bags, there was a bunch of needles in it that was uncapped. There was a bunch of needles that was inside water bottles that didn't have caps on them. So, I mean, and it was none of my trash, because that was none of my trash bags or trash that was there, because I hadn't been in the house in months.
Judge, if we could have we got some photographs of these things for the court. If we could
Have them connected to the HDMI.
I think I've got plugged in.
Cox, would you hit the light for me?
So let's go over some of these photographs, Mr. Claiborne, and I'll ask you some questions about them. Mainly if you can identify the photograph, what it is for. And let me ask you this real quick. You've put together a list that we've attached to the motion.
Yes, sir.
Of all the items with a dollar value beside them, correct?
Yes, sir. And a lot of that stuff I still have the receipts for too. Or I was able to retrieve the seats from the stores that I had bought, and some of the model serial numbers as well.
Okay. So what are we looking at here?
That's a picture prior to me moving out of, or me going out of the home. As you can see, the big screen TV that's hanging up on the wall with a sound bar mounted to the top of it.
Admittedly, some of these photographs, you had to go back and pull these photographs from the
Oh,
time before you got displaced, correct?
Yes, sir. I went back over my old phone or back over pictures of my late wife's social media, where she had posted some pictures on Facebook, and or something or other, to find some item in the house that was missing, or some of my old social media posts, that would show items in the house where a picture was took or something.
All right. So, I mean, this is not just a square-on picture of the television, but that's why.
Yeah,
correct?
yeah. That's showing the TV was there at the house.
All right. And then,
That's another bit, the picture the same. I think it's a 55-inch it hung on the wall in the bedroom.
okay. And then, what's that a picture of?
That's where the TV was took off from the wall, and whenever they took the TV off the wall, the cable box that was mounted to the TV was neatly folded up and put in the kitchen cabinet.
And this was a TV, again, I want to make sure you brought this into the marriage with you.
Yes, sir. I bought that prior to the marriage, sir.
And you actually have the receipt for the television?
Yes, sir, I
correct?
do. I bought the TV, and then I went back later and bought the sound bar and stuff, a little bit later on.
And the television value here is $801 and whatever, 14 cents?
Yes, sir. Yes, sir.
And you still, to this day, where do you know the TV is at this point?
It's missing. I mean, I have no idea. It wasn't there when I returned to the home.
Okay. And then talk about the sound bar. We don't have any pictures of the actual sound bar, do we?
It was on that one picture of the TV. It was mounted at the top. It's black. It matched the TV, I think, on the first picture that you shown. Not that one, the first picture. It should have been up there. Maybe you can see the top of the sound bar where it's mounted to the top. That's how Denton's come out and mounted it up there.
Okay.
Yes, sir.
And the sound bar, was it there when you got your home back?
No, sir. It was the sound bar's there. Then if you look in the picture where there's a little table underneath that mirror right there, you can see the top of a subwoofer that should be sitting in the floor right there that goes along with the sound bar. The sound bar subwoofer combo.
Okay. And your value for that, according to your estimate, is $655, $64?
Yes, sir. That's what the original receipt said.
Okay. And that's the receipt for the sound bar?
It is, sir. So I went back to Denton's and had them pull the receipts.
Talk about your late wife's jewelry box with jewelry. What all was in there?
Should have been some earrings in there. There should have been maybe over the broken bracelet that was in there, and then all kinds of like little other necklaces and stuff. Mine and her, or my wedding band that I wore with her was in there. And then I had another wedding band. I had two wedding bands with Miss Childress. I had a plastic one like a rubber one that I wore when I worked all the time, so I wouldn't get it. I had a black titanium one, and it was in that jewelry box as well. And so then plus all the odd and end jewelry that my late wife had in there. It was some earrings and other stuff like that and whatnot.
It's one of the things you didn't put a value on your list.
No, because some of the stuff, I still haven't got receipts and case for. Some of the stuff I couldn't really put a value on it. But then her wedding band that she actually wore, her diamond ring, I have a separate jewelry box that I kept in the bathroom on the counter that I kept two of my watches in, and I kept her wedding band in there, and her wedding band and wedding ring in it. And then when I returned to the home, that one of the watches was gone, and then her wedding band and wedding ring was gone, and that ring today is probably worth over $5,000 or $6,000, if not more.
That's a picture of the ring there?
That's the picture of the ring. It's got, I think, 20-something diamonds in it. I remember when we bought it 20 years ago, we paid quite a bit for it. It could be worth up to $10,000 today, if even more. And then that's my jewelry box. That's where the ring was supposed to have been kept. And then it was in a little white bag, like a little pull string bag that I kept in there, along with another watch that she had bought me, because she had bought me that Harley Davidson watch and an older watch that she had bought me years ago.
And was the engagement ring, it wasn't there when you got the home back?
That and her wedding band was gone too. Both the rings were gone.
Do you have any idea today where they are?
Sorry, do what?
Do you have any idea today where they are at all?
I do not know, sir. I do not know where they're at, no.
And your late wife passed away of COVID.
Yes, sir, she did.
Refresh the judge's memory.
Yes, sir,
of
she
what it
did.
was.
Yes, sir.
You guys were both in the hospital at the same time with COVID.
Yes, sir.
correct?
They expected both of us to pass away. She passed away on a Friday night, and then they kept telling me they didn't know if I was going to make it or not, because they kept trying to put me on a ventilator as well. And luckily, I didn't have to go on one.
Explain that picture to the court. What is that a picture of?
That's the top section of the jewelry box. And then there's like the upper section, and the underneath section was showing where the other watch was at. You pull that little tray out. It's like a two-story jewelry box. That was the one that I purchased after she passed away.
For brevity's sake, you've got on your list a gold wedding band, a man's watch. Both of those is it your testimony, both of those were in the home when you were displaced, and they're not there now?
No, they're not, sir. They're not, no.
And sitting here today, do you know what happened to them?
No, sir, I do not.
And is your value $150, $250 accurate as to what you valued this personal property of yours at?
The watch, something like that. It's an older watch she had bought me. She bought it in one of the jewelry stores back years ago, and that's probably about what we paid for it years ago.
see. May I give this to Mr. Claiborne, and I'm going to enter it into evidence,
This being what?
the list. I think it might help him to look at the list as we're going through this. I'm going to try to speed this up. We've got a lot of property to get through. And you've got your gold wedding band and the men's watch at 150 and 250 collectively, correct?
There were smaller bands, just on those. Just,
And then you've got a men's gold rope necklaces. You have 2 of those, correct?
my late wife had purchased those for gifts before she had passed away.
And is this a fair and accurate depiction of?
Yes, sir.
of
That's
those?
one of them there. And actually, I believe if you zoom in on the far right of that picture, you can actually see her wedding ring, the little round like ring she wore, the wedding band part of it. I wore it around my neck after she passed away. I kept it on that chain right there. You
Right
can see
there.
it. Yes, sir.
Yeah. And you recall when this picture was, this is a valuable piece of merchandise. You recall
That
when this
picture right
was
there
made?
was took not too long after she passed away, right when I actually was able to start getting back up and getting out of the house again and start doing things.
And when was that? The court doesn't know that.
Well, I mean,
Ballpark figure, I mean.
she passed away in August. That picture right there may have been taken probably late September, maybe something like that of 2 years ago.
Okay.
Yeah, I would probably say late September, end of September, maybe somewhere around there. Because when I come home from the hospital, it was a month almost before I was actually able to get up and do a lot.
And again, this is a fair and accurate depiction of those 2 necklaces that you're asking.
Yeah, because
monetary
that's
reimbursement.
actually her jewelry box that's missing from the house, still sitting there because I had not purchased the other one yet.
Sitting here today, do you know where that necklace is at all?
No, sir, I do not.
All right. So you also have a receipt for the purchase of the necklace, correct?
Yes, sir, that's the receipt of one of them. I was actually able to go back to, I believe, K Jewelers and get.
And this is one of the necklaces, correct?
It is, yes, sir.
All right. And the retail is $3,500, correct?
Yes, sir. Yes, sir.
So this next document is a receipt from Southern Gun and Pawn with Ms. Childers' name on it.
Yes, sir.
Explain that to the court. How did you get that? and what is it?
When I got possession of the home back, that was hanging on the refrigerator, along with some other stuff that they had left up there for me, some other cards and whatnot, making fun of me basically. That my wife's jewelry that she had purchased me was at a pawn shop.
Did you check at the pawn shop?
Well, I did, and then they said it was still there, but they could not go into much detail from me because I was not the one that per se pawned it, but I could come and pick it up since I had the receipt for it. I believe that's the accurate description of what they said, I believe.
And you and I discussed this with a detective, did we not?
Yes, sir, we did.
And was there any relief there at all?
No, sir, there was not.
They were told it was civil, and we had to come to civil court and deal with it.
That the judge deal with it in civil court.
I'm sorry, repeat that.
He said that he would not deal with it, that it was pretty much the judge would need to deal with it in civil court.
Did you ever recover these items?
No, sir, I have not to this day not been able to get them back. And that, those are what my late wife purchased me right before she passed away.
Detective Martin's out there. I subpoenaed him if we need him to explain that. This is why I'm here. We can't get relief except for a civil action, apparently. So, all right, change jar. Just a fair and accurate depiction of your change jar.
Yes, sir, it was. It probably had around $500 between cash and coins and everything, whatever. Because I don't carry a lot of cash on me, and anybody can verify that. I always just, if I get anything back, I always throw it in that jar because I save it for vacation money or whatever. If I want to buy something at one time, I've got just cash money there. I can go in and get the cash out.
Is this how you found the change jar when you got your home back?
Yeah.
And do you have any idea about how much change you had in there?
Probably about $500. Between the cash that would be in it and the change, it probably would have been about $500. I'm always throwing a 10 or a 20 or whatever I have back from something.
And did you have it before the marriage?
Yes, sir, I did. I've had that for you. Me and my late, that goes back to my kids when they was all little.
Your testimony today, you had that value of $500 in it before the marriage?
Yes, sir, probably so.
With Ms. Childers?
Yes, sir. It was probably more than that because, I was in and out of the house throwing money in it all the time.
The next thing on your list, and you have it there at number 9, the iPads. Describe that to the court. What is that?
One of them is my work iPad that I used for work, and then the other one was it's kind of a complicated story, and it's technically my iPad, but my daughter had went and got it on my late wife's account after she passed away, and then when she moved out of when I had her removed from the home, the police made her leave the iPad there, because it was technically still under my control, because of the account was technically mine and my late wife's Verizon account.
And you valued those at $1,300?
Something like that. I know
Were they there when you got-
the one that I used for work was more of expensive iPad, because it had more, I guess, gigabytes and it held more information on it than the other one, because I had to have a bigger iPad for the one for work.
And it was there when you got displaced from the home?
It was, sir. Yes, sir.
And it wasn't there when you got your home back?
It was not.
Okay. Late wife's cell phone, can you describe what that is to the court?
It was an iPhone with a white plastic case on it that held all of her personal information on it from over the years. All of her pictures from me and her grandkids, everything. It had all of her, personal documents up for work, her work emails on there, her personal emails on there. It's got probably company information from the company she worked for, other companies' information on it. It's got all my business information. It's got my QuickBooks on it. There's that phone. It's got a lot of personal information to a lot of other companies and people tied onto it.
And it was there when you got displaced from your home?
Yes, sir, it was.
And it was not there when you got your home back?
It was not, sir.
And you think this is a fair and accurate valuation of it?
Yes, sir.
What about the spare iPhone Sydney used? Was it there when you?
The day I had Sydney removed from the police. I mean, the day I had the police remove Sydney from the home. The phone, the police told her she left the phone there, and I had the phone cut back on under another number that I would use it just as a spare phone to keep around the house.
And it was there when you got displaced from the home?
It was there because that night I tried to get the phone that night, and the White Bluff police officer would not let me remove that phone from the home because he said, well, we don't know who it belongs. I said, well, sir, it's in my name under my late wife's account. And he would not let me remove the phone from the home that night.
And it's not there when you got your home back?
That was not. It
And
was
the fair
not.
and accurate value of that's $800?
Yes, sir.
I'll make a quick, somehow this photograph has gotten in there, but what is this a picture of?
That was one of the bags of my brand new clothes that she had bagged up, and somebody had taken desiccated on top of them. When we tore the bag open, you can see it had been on there, and it started growing like mold over the top of it.
So your testimony today is that's the feces on your clothes, and that's how you found it when you got your home back?
Yes, sir. Yes, sir. That's when it goes back to where I told you some of the stuff had fell behind the dresser, and I scooted the dresser out.
Your item 12 is a deodorant. There was $40 each. You got body wash, $50 each. You had 5 and 2 of those respectively. Were they there when you left your home?
A lot of them was gone because I always buy a bunch of those
Now,
ahead.
hear me now. When you got displaced from your home, were they there?
Yes, sir. They was.
And
Yeah.
when you got your home back, were they there?
No, sir. That was not.
Just fair and accurate depiction of what you say the value of these things are?
Somewhere about there, yes, sir. Because I tried to pull the receipts back offline.
All right.
All right, let me interrupt you. We're going to take a short recess. We'll be in recess for about 15 minutes.
All rise.
All right, apologize for the delay, but let's go ahead with your questioning.
So, all right, Mr. Claiborne, you had a chance to look at your list.
Yes, sir.
Is everything on your list a fair and accurate depiction of items that were A, in your house when you got dispossessed of it, and B, items that were not in your house when you got them back?
Yes, sir.
And as the values, is there a fair and accurate value of all the items that you've listed in your
Yes,
list?
sir. The best that I was able to find old receipts or get old receipts or look the stuff back up online, from where we had bought it in the past or something like that. It was the closest I could get to the value of it.
So, Judge, here's the formal list, and it was attached to the motion. Ms. Childers should have it. I'm going to ask that be moved into evidence.
Will this be Exhibit 1?
Yes, sir. And we're going to go through these photographs fairly quickly. We've talked about Mr. Claiborne. And again, as a blanket question to all of these photographs, would you say all the photographs that we're going to show here, and you're familiar with the photographs, correct?
Yes, sir.
I have these on OneNote, and you signed on to that,
Yes, sir. I looked
My
at it
office.
again the other night. Yes, sir.
and you've looked at every one of these photographs, and you know the order that they're going in.
Yes, sir.
You've looked at everything that I've seen,
Yes, sir.
everything that I've done, correct?
Yes, sir.
And are these a fair and accurate depiction of these items, the ones that you do have photographs of?
Yes, sir. It is.
And again, all of these items that we've got photographs of, they were in the house. You took these pictures while they were in the house prior to your dispossession.
Yes, and you can tell that they was older pictures that was took, originally in the house before, over the years.
So let's look at this number 15 Dyson air purifier.
Yes, sir.
You have that
Yes, sir. I have
pointed
two.
to.
I have two of those in the home, and I paid $500 a piece for those at Best Buy.
Okay. And how many of these are you missing?
Two of them.
Okay. What do they do?
They heat and cool the room. It purifies the air. You can use them like they turn heat on or
It's a trick
whatever.
question. What does an air purifier do?
Well, they do different things. He's saying this heats and cools, and the one that I have is like $50. I mean, this is that's why I'm
Yeah,
asking.
those actually rotate, go up and down, and they move around, and then you can heat a room up with those things and everything. Yeah, those are nice.
Yeah, those are the more expensive ones,
Yes, sir.
right?
Yeah, I paid about $500. I think it's $500 a piece for them.
So, go to number 18, the Oakleys with the red lids.
That's a picture of my late wife with those glasses on when we was in Florida, I believe. There's another pair. We was down our place. We had a place at the river when she was alive, and that was me on one, probably this Sea-Doos or something with those glasses on.
This is your number 18 and 19.
Uh-huh.
And what are these?
That was two of the, I had to see the names on the bottles, but I don't know if that's my two Xanax bottles that was left at the house that we found in the trash. That would be the two Xanax bottles that the doctor had put me on for sleep. That was missing. One of them was full and one of them was about half empty. And when we started going through all the trash that was left at the house, those were the bottles that was found empty.
That's your name on that prescription, correct?
It is, sir.
Blow it up. Same thing here, correct?
Yes, sir. That's the other bottle, because one was full and one was empty. I mean, when I left the house, one was half empty and one was brand new full.
Was it concerning to you that you lost this type of scheduled?
Yeah, that's a controlled
Scheduled
stuff.
drugs.
I mean, you had to show my ID and everything to get those. I mean, to me, luckily we found the bottles.
All right, and 26, that's a fair and accurate depiction of the riding chaps.
It is. That's a pair of my older chaps that I had when I rode my bike in the wintertime.
Towels and wash rags.
Yes, sir. That's
Item 36, now this is the,
we call it Roomba that runs around the house all the time. It's missing. It was just an odd picture. I think it was found on one of my old phones that I took over. My late wife had sent him, something other on one of the text messages or something.
and you got this valued at $900, correct?
Yeah, when
That's
we
pretty
originally
expensive.
bought them was when they first come out, and it was expensive. Yeah, we bought, I think, originally at Lowe's when it first come out, I believe. And that's the pictures of my Ray-Bans that are missing that was left at the house.
What's that a picture of?
That's a picture of my daughter at a wedding wearing one of the rings of her mother's that's missing out of the jewelry box, the blue topaz, her looking down at the ring. That was a gift. The picture was a gift to me from her friend's wedding. The picture is even gone from the house too. That's showing the mattress pad off of the bedroom downstairs is missing. We paid several $100s for that downstairs.
Item 46, you got that valued at $300.
Yes, it was a nice mattress pad to go over that bed.
Supporting document that shows what you paid for it, correct?
Whatever that was, yes, sir.
That's a receipt for what you paid for it, correct?
That's for the bed, I believe. That's for the bed, the mattress, I believe.
Okay.
Yeah, we paid $3,000 for the mattress. And that's how it was when we come into the house that day. The topper and all the comforters and everything was gone off of it, and everything was gone out of the room.
And the $3,000 mattress still there?
The mattress still there, but the topper and the comforters, everything else is gone, the pillows, everything.
What is this? Item 52.
That is an older picture of downstairs before we put shelves in down there that started some of the liquor collection. That's some of the older liquor that was downstairs. But when I re-entered the house, that shelf had been moved up to the office and had been staged with other stuff in the office of the house. And then all the liquor that was downstairs on the other shelf was missing.
You got that valued at $400, correct?
What now? No, the liquor.
No, I'm sorry.
No, the liquor missing from the house is about $5,000 or $6,000.
The item 52, yeah, it's $3,000.
Yeah, the liquor part that was downstairs was probably $3,000. Then there's different rooms that's got different amount of liquors we kept in different rooms.
$400, I looked at it wrong. That's his KitchenAid mixer, correct?
Yes, sir. That's the one that I had purchased for a Christmas present.
Okay.
For birthday, I think.
And these are the receipts for that purchase?
Yes, sir.
correct?
That's the one for the coffee pot there, about $200 and something, I think, for the coffee pot or something like that.
Coffee maker.
Yes, sir.
Item 57.
Yeah, that's one of the two. I had two of those Yeti killers are matching. One of them's missing. They left a strap to it downstairs in the basement, and then all the other Yeti cups are gone from up there inside. They had like a big gallon. That out of all the dishes, two skillets were left, and those red ones, whoever the red ones are, they was never at the house when I originally left there. They don't even belong to me. It's some kind of cheap ones you use for like camping or something. Those are some.
64, these air tags.
Yes, they was on the kitchen table the night that I left. I had just purchased those.
That's a receipt where you purchased this, what you
Yes.
looked up for the value.
That's a receipt from Amazon, I believe, or that's where I just purchased from Amazon.
It was an air tag.
What is an air tag?
You put like to keep location of your like keys or whatever you put it on or whatever. It's just a thing Apple makes. Is all
Okay.
it, yeah.
And it helps you find things?
Yeah, it helps you find things, whatever it is you're looking for. Or if you keep it on something, you can track it or whatever with.
Is it concerning that they were missing?
Yeah, because they're brand new, never been opened up or assigned to a phone or anything. Yes, I mean, they're still on the package.
What is this?
If you look in there's like a wine bottle sitting upside down. That's an older picture from when my late wife had took her grandkids there. There's a bread basket that come from Africa that one of our friends had purchased in Africa as a gift while they was over there. And that's what I was able to find it online. The exact one online looks like it. But that one there had originally come from Africa.
Hummingbird feeder?
That was my late wife's hummingbird feeder that was underneath. I had it stored, put up underneath the kitchen cabinet in the living room. The kitchen.
Dog food container?
Yes, sir. Those were the two drink holders. It was in a brand new refrigerator that I had just purchased. That was in the refrigerator.
And they were gone?
They were gone.
72 is what?
There's a stool. There's a white stool right there that's missing.
And then
that's where all the liquor that was in the kitchen, that whole thing was stocked full of liquor in the kitchen from corner. Now, some of that liquor that was in there was Miss Childress's, I will say that, but the majority of it was mine. I think more of the mixers were hers.
And you valued what you're missing then at $600?
Yeah, because that whole thing above, that whole kitchen cabinet above the microwave was full of liquor.
And
that's where I had went back to Boswell Harley Davidson and had to buy another key and remote for the motorcycle that was missing.
Okay. Sorry. Here we go. You got this listed as totes of bedding they're missing?
Yes, sir. We had took those pictures after my daughter had moved out. We stored some stuff. I had to remove. We stored some stuff upstairs and took pictures of it, and that stuff was all missing from the attic.
Again, that's a blue and white blanket that's
yes,
missing?
sir. That's one of the blankets that's missing that we had took a picture up there, and that big white tote that was in the attic it was in the bedroom now when I returned. And then here's the picture of the bed when I come in that day, and we pulled the comforter back on the bed, and it showed we didn't have no sheet on it that day, and had mismatched pillows still across the top of it. And then when you, sorry. And then go ahead.
Go ahead and finish your statement.
And then when you pull the comforter all the way back on one of the other pictures, you see where the whole mattress had been peed all the way over. Somebody had peed on the mattress.
We got that coming up. What is this?
And that's showing the closet to where all the vacuum cleaners were at. There was a dehumidifier. Dehumidifier where you dehydrator for food that was in there. Everything like that was in that closet. The mop bucket was gone. Everything's gone out of that closet.
And you got a vacuum cleaner here missing at $400.
Yeah, I just purchased it at Best Buy also.
And then this is the mop and cleaning supplies at $400.
So that was all that was left. The whole thing was stocked with wood cleaning supplies, paper towels, everything. There's the actual picture of the dehydrator right there that I had just purchased off Amazon the prior year.
And that's the dehydrator.
That's actually an actual picture right there where I was making jerky one night in the house with it right there. Then there was a picture there. That's how the hallway closet was. There was actually somebody had took some of the stuff out of that other closet and put in that closet. And there was actually also a pack of baby diapers in there with wipes. And I've never had no baby diapers or wipes in my house in years. So somebody had a baby, I guess, in the house there also.
Describe this photograph. Let's stop for a minute and describe this.
So if you see where the arrow's pointing, there's a half of a whiskey barrel there that's set in the living room of my home. That whiskey barrel had probably, I don't know, $500 or $600 worth of liquor in it right there. That's a picture of it right there sitting in the home prior. I just a random pictures. It's sitting behind another gentleman's car. There's my daughter with Miss Childress are loading a bunch of my stuff into the back of her Jeep that's coming out of the house. That's not supposed to be removed from the home.
And this photograph depicts that whiskey barrel probably getting loaded up as well.
Yes, sir. Because she bought me that whiskey barrel prior to us getting married before a Christmas present when we first started dating. So it was mine before we got married.
What is this? Oh, blood pressure testing?
Yeah, that was just showing the one that's missing from the house. It's just that little air cleaning kit that I kept in the living room is gone. That's one of the vases with the candles in it that my late wife had purchased and had an older picture I found that was missing. That shows the two candle. If you look in the picture, the candle holders right there, that was some of those candle holders. I had bought them after my late wife passed away at Bed Bath & Beyond. I think Bed Bath & Beyond or somewhere up there. When I returned to the home, somebody had turned the gas on and left the gas fireplace running, and they took the shut-off valve to it. I had to turn and order another one off Amazon to be able to cut the gas off coming into the house. They'd left the fireplace running. That's showing a picture of the bed that's missing from the home. It's actually a Mrs. Childress storage unit that she had, that I had stored it in, along with the dresser, the matching dresser that goes along with that bed. It's an antique bed that my late wife had prior to us even getting married. That's how the bed is.
And it's our position
And
that was not in the house when I want to make sure about this.
Yeah.
That was not in the house when you got dispossessed of the home.
Yeah,
It was in that storage unit.
It was in her storage unit. And that's actually the picture of the dresser that was in her storage unit too that belonged to my late wife.
But according to the order, she should have left that at the house. That was your separate property.
Yes, sir. That's all my property. Yes, it belonged to my late wife.
All right. And then we got towels.
Yeah, I buy those 1,000 at a time for the business. And that was, I had just purchased those on Amazon. I order them off Amazon for work.
That's a receipt for your leaf blower that you've.
Yes, sir. I bought it at Dixon County Farm Equipment here in town. That shows the model and serial number of it.
Some wreaths that are missing.
Yeah, that's just some of the odd and end decorations that are missing, wreaths and other things from the house that are missing.
You've got those valued.
Yes, sir.
Receipt for a battery charger, is that correct?
Yes, sir. I had bought a battery charger. I keep odd and end batteries charged around the house, and then I keep a lot of stuff on battery tenders, like the motorcycle or side by side or my boat or something like that. I have all kinds of battery tender chargers on everything at the house. Is that for the oil?
107, 6 gallons of antifreeze.
Yes, sir. That was the oil. I'm the antifreeze I purchased for. I keep a lot of stuff stocked, a lot of chemicals and lubricants stocked at the house for work. In case one of the other guys that works for me needs it, they can come by the house and get it, or they have the code to get into the garage to get something out if they need it.
Again, receipts for your antifreeze and things of that nature?
Yes, sir. I buy them at a couple of different places. If I can find them on sale at another place, I'll purchase it there.
This is number 109, which is
It's a Snap-on battery charger for my smaller batteries I use on my smaller electric impacts and stuff at work. If I use one of the electric ones, that's two of the three of the missing batteries that are missing also. That's my wash wand for my side by side and some of the fluid that's missing also. I never even took it out of the box and even used it because I hadn't had it that long.
110 and 111 right there on your list.
Uh-huh.
Number 113 is a water separator for a forklift.
Yes, sir. I buy those in bulk usually because I have my bigger account where we service them constantly every month, so I have to keep that stuff in stock, and that's some of the ones that are missing.
Would this have been?
And it should have been sitting on the right-hand side of the shelf when you first walk in the garage, is where it should have been.
And this is where you've looked it up and got a value for it, and that's what you're showing the court,
Yes,
correct?
sir.
And then 115 is listed as just a power cord?
Yeah, all my power cords are and adapters and all that stuff, all that, I had all those in different totes and stuff, and all the totes with all the power adapters, everything's missing from the home.
This is where you've looked up the value of a,
Yes, sir, I just bought
Drill-
that, I just bought that drill
drill
bit
bit.
set right there, yes, sir.
item number 118. I'm gonna go through these pretty quick. This is just tools
Yes, sir.
that you've got for your business that are missing.
Yes,
All of this look familiar to you?
It does. I don't know what that receipt is, it's for something, I'd have to.
And then this is 122.
Some more of the decorations that was stored in the garage. And that's those were the flower pots that my late wife had that her grandkids had colored and put their handprints on. My late wife's grandkids, that's their actual handprints that was painted into the pot. They stuck their hand down in paint and put their hand on the pots.
Did Ms. Childers know this?
Yes, sir, she did.
She knew this?
Yeah, because her and my daughter had talked about those before and stuff like that.
Is there any good reason that would have been gone?
I have no idea why they would be gone, because I just knew there's something that has no sentimental with her.
He's mentioned his late wife so many times, I kind of feel like I should show this. Her name was Kimberly Lee, and she passed away August 2021 from COVID. It's super sad. She was only 47. And it's obvious that he is still not over her passing, and he moved on way too quick. And that's probably what got him into this mess.
And then there's, in that corner of that picture, I went back through some old pictures, because right after my late wife had passed away, I took a picture of her car. When I put it in the garage, I had it detailed and waxed and parked it in the garage, and you can see the Rhino liner right there in the corner of that picture. That's one of the Rhino liners that's missing, the whole gallon of it that's missing. It should have been sitting there. And then there's a Snap-on stool right there. That's an older picture of another refrigerator we used to have in the garage.
And again, this is a 127 receipt for air filters.
Yes, sir. Those air filters, I keep 3 or 4 different kinds in stock all the time at the house, and usually anywhere from 12 to 24 of them. And the ones that are missing, there are multiple fits. They can fit multiple different things, even down like the side-by-sides and stuff like that. But they're mainly for forklifts, but the ones that are missing can be multi-used on different things if you have a side-by-side or something like that.
Right, these are various receipts just to show what they cost, correct?
Yes, sir, it's just receipts. I was able to go back to the place where I bought stuff where I had on my email. Then that's another picture, an older picture from the house. It was took actually showing where the motorcycle was when I left the house, but you can also see in the corner over there, the hydraulic fluid that should have been at the house that's missing from the house. But then when we come back to the house, the motorcycle had been moved over to the other end of the garage.
Same thing, you're showing this as a receipt where you replaced the items that were missing.
Yes.
And this is the brake cleaner that was missing.
Yes, sir.
Replaced
There were
it for
several
that.
cases of it missing. Yes, sir. I keep all that stuff overstocked at the house.
Okay. Black RTV number 135, what is that?
It's like silicone. We put like a part on the engine. We got to have some silicone gaskets or whatever. That's the older pair of Ray-Ban, Oakleys that I kept in the saddlebag of my Harley when I rode my bike. They were missing.
Yeah, this is number 138, which would have been receipt for tools. that
Yeah,
you
I think I
replaced.
just purchased those off eBay. Maybe that may be an eBay receipt or an Amazon receipt, one of the two. I bought some tools off eBay a lot for work.
And then the same thing here.
Yes, sir.
As I'm looking at this is all stuff that was in
It
the
was left at the
garage.
house because that, about the time I bought some of that stuff was right around whenever me and her, whenever I was removed from the house.
Again, this shows what the price of all that is when you went to go.
Yes, so that was
try to
back on my
replace it.
bank transactions from my business account.
Okay, what is this?
That is a picture that she had put online of her tiller for sale. That's actually one of my late wife's tables that she used to, when she did some painting that she painted off of. That's one of the tables that's actually missing from the house. Because there was 2 of them at the house and only one of them was there. I think one of them's there right now, but one of the ones is missing from the house.
This is a towable tube that goes with a boat.
Yes, sir. That was brand new, still in the box. Had never been took out of the box. I'd bought it at Bass Pro Shop. It was, I think I paid about $300 for it. $307. It was still in the box. And that's the picture, probably of the other Yeti cooler that's missing from the house because there was 2 matching coolers.
6 surveillance cameras.
Yes, sir. There's that's 2 of the cameras. There was one, and there's actually a picture of Logan Brown actually taking the camera off of the back of the deck, and that's actually the camera that caught the altercation that morning on tape at the house that's missing from the house.
Okay.
That was a picture of Logan taking it down.
Is there any reason he would have taken that down?
I don't know. I mean, I bought the camera. I don't know why they want to steal the camera and take the camera from my house. I mean, I don't know why she would have Logan up there taking a camera off the back of my deck.
And this picture was compliments of your neighbor,
That's
correct?
compliments of my neighbor right there. Yes, sir. And that was the
That
camera.
previously testified.
Yes, sir. Yes, sir.
And that's just another picture.
That's
of him
another
taking
picture of him
down.
taking the camera down from the house. And that was, I think, a couple of days right before she actually moved out of the home, I believe.
You've listed on your list here, and these are, well, so you've got a receipt here for a lot of the alcohol that's missing. that
Yes,
you
sir.
knew that
Probably
was
several
there.
$1,000s, but probably in total. I mean, some of the alcohol I'd bought over the years when my late wife was still alive, I collected. Like I said, there was only one signed bottle. A lot of it was mainly more high-end bourbon bottles of liquor. There was probably, $5,000 or $6,000 or more worth of liquor in the home.
This is showing what it costs. These are the.
Yes, sir. Yes, sir. That was some of the receipts I was able to go back and find. But there's a picture down there that shows. That's a picture that was put online for Annabelle Brown, one of the girls that was actually in the hot tub picture of the house that was staying in my home with Miss Childress, that she'd put my Ray-Bans online for sale, because you can tell the picture was took at my house because you can see the white curtains in it that Miss Childress hung up in the home after I had moved out of the home. Or not moved out, was took out of the home.
Did you know Annabelle Brown?
I did. I mean, her mother used to date back off and on years ago.
Okay. And she was at your house?
Yes, she was one of the ones that we testified before in the other court with the girls that was in the hot tub party in the hot tub in my house.
And you do believe this is her selling your merchandise?
It is, yeah, because you can tell the pictures took inside my home off the glare of the sunglasses.
Oh, okay, I see what you're saying.
Yeah, you see the glare, and you can see the white curtains that was hung up in my home.
Off the glare in the sunglasses? Okay.
Yes, sir, yeah,
All right.
yeah. So that shows that picture was not took inside my home. That's the 2 rings that are missing from the home. Well, I take that back. That's the only 2 pieces of jewelry that was left at the home whenever I got back to the home. Miss Childress put that picture online of my wedding band and my late wife's wedding band with a picture of my late wife that's actually missing from the home also. And you can tell that picture was not took inside my home. That table's not in my home. That's the house, like it's got paneling in it wherever the picture was took. It was took right back down offline as soon as it was put on. But that shows that she took the jewelry out of the home right there. That's a picture of my jewelry outside that home.
Took the jewelry out of the home, then it was back, this jewelry was
Yeah,
back.
that's
in
the only 2
home.
pieces of jewelry that was left at the home, and they were sitting on top of that jewelry box inside the bathroom whenever we entered the home. That was the only 2 that was left there.
Is there any reasoning for her to post that picture and put this message?
It was a
under
shot.
it?
It was a shot online at
Irrelevant.
me, is all it was, and my late wife,
Honor,
because she knows how
irrelevant.
disrespectful that is.
We have an objection. What?
Your Honor, I feel like this is irrelevant
Just the
to
motive
the
as to why
post.
she was.
It clearly the items weren't stolen. They're in a picture, and you just stated they were back at the home.
Objections is to relevance, but I believe if you're objecting to the photograph itself, overruled. If you're objecting to him, asking him why this would have been posted, I think that obviously would require speculation. I'll sustain the objection as to the question regarding why this was posted online. Go ahead.
But the bottom line of this, your testimony
Yes, sir.
This is
Yeah.
your house.
That picture's not taken in my house, and that's one of the pictures of my late wife from high school that's also still missing from the home there. And like I said, that table is not in my home, and that house, that's not the color of my home. My house are repost gray in the walls of my house, and I have no paneling in my house.
Judge, if I may, I've got the thumb drive that's got all these pictures on it, Exhibit 2 collective.
Does that conclude our photographs?
Yes, sir. You've also put on your list, there are items, things missing that has no dollar value on it, correct?
Yes, sir.
And there's just no way you're gonna get the sentimental value out of these
No,
items?
there's before my late grandmother passed away, she had made all of the kids quilts, either a starburst quilt or a wedding ring quilt, and she had made me a homemade wedding ring quilt that she sewed by herself. That quilt is probably, if you valued it, I mean, it'd probably be $500 to $1,000 quilt. It's an older quilt, but I mean, there's really no value. It's a sentimental thing. All of my late wife's stuff is missing. I mean, you know, from her phone, a lot of her clothes, all of her jewelry is missing from the home.
Now, hold on, you got tax records that are missing?
Yeah,
in this list?
all of my tax records are missing. We found a couple, even all the way down, the tax records that belonged to her and her first husband of over 20-something years ago are gone from the house. Yeah, there's tax records that go back that far that
Your
are
business
missing.
records?
All my business records, my business license. I mean, there was nothing left at the home that pertained to my business at all.
Apparently there was a private leather, item 155, a private leather briefcase.
Yes, sir. That had a lot of our personal stuff in it. You know, she would do work for the company, or even her place she worked if she went into the office. She kept a lot of her personal documents in there that pertained to the company she worked for before she passed away. And then a lot of stuff that pertained to my company as far as, you know, customers' information. There's all kinds of customers' banking information missing.
Titles to vehicles?
All of my titles to the vehicles are missing. I've had to go get titles replaced over at the tag place here in town.
Christmas ornaments that are
Christmas
special
ornaments.
to you?
Yeah, the older stuff is missing that belonged to my late wife. A lot of the newer stuff is still there, but majority of the stuff that belonged to my late wife is what was missing. There was still some of the stuff that was still there, but it's just like somebody had picked through some of the stuff.
I'm sorry, Judge, if I could, I want to ask you about the hot tub. The vandalism pictures were kind of separate.
That's the piece that the chemical cartridges set down in. When I pulled it out, there wasn't any cartridges in it, and that right there had been broke. That shows the filter and all the puke that we cleaned out of the hot tub, where the filters were clogged up with, like, I guess it was puke, and that's where I started cleaning the hot tub out there. You can see there's two of the beer caps there that was found down in the bottom of the hot tub, and there's another picture that shows where they was rusted over, sitting in the bottom of the hot tub. Right there, you can tell where they'd been down in the hot tub, and I don't drink beer or nothing like that, so it wouldn't have been mine.
And this is a estimate of what it was to.
That's just from me going back and buying the filters and the chemicals. That doesn't include the time of me spending cleaning it and everything else. There's an actual picture of the mattress there where somebody had pissed all over or urinated all over it.
And you got receipts there where all that was cleaned?
I did. I spent about $800 or $900 having a company come out and clean the mattress.
Go back to the picture of the urinated mattress, please. Go back to the picture. I didn't get a chance to see it.
You can see the whole mattress, how it's been turned yellow right there. I guess the hardest part of that to me is my late wife stayed in that bedroom the last week of her life, and that's the best she slept in the last week of her life. That's why I take that picture right there more personal than anything. Because I left that room. That room still sits today just like she left it.
Yeah, I think we talked about this picture already, but that's the fecal matter in your clothing, correct?
Yes. That was a mat or a rug that we have on the back deck where a fireplace was, and I don't smoke. And then somebody was burn holes all in it. And then that's where we started going through some of the trash and found bags and bags of cigarette butts. There's the white powder, the first picture of the white powder that was found down inside the motorcycle. And actually, I think that's maybe Officer Lashley or Hunter standing over there, whichever one that was standing over that day right across from it. You can kind of see some of it there. It's even around on the sides of the tank and stuff right there also. You can see the white powder going down through there right there on it also. That was.
What is this, a picture?
I
It's a
think
picture
that
of
was
all
the water.
What
Yeah,
is-
that was the water that come out of the tank of the side by side. When we drained the tank, we put all the water. Actually, we drained it over to a 5-gallon bucket originally to begin with, and we poured some. We siphoned some of it over into that. And that's what it looked like after we siphoned it over.
And as a mechanic, you understand how to do all of this?
Yes, sir. Yes, I'm a certified mechanic.
And this actual contents of this bottle is what was in the side-by-side?
Yes, sir. That one. Yeah, that one's pretty much. It was like I said, 90% water was in the gas tank of the side by side. That right there is a picture of where she had hung all kinds of things over all the doors and windows in the house after I left the house, and took it down before when she left the house, because that stuff was never there. We never put it over the kitchen window or the back door windows.
Just kind of on the side of the neighbors where she testified she was trying to put up stuff?
Yes, sir, it is. That's the one, on the back, where the neighbors, that faces the neighbor's kitchen, is from our kitchen to their kitchen there. And then there's where she
Share all of these holes and all this
Yes, sir.
damage?
Yeah, and that right there is a picture of where she put chain locks over all the doors inside the house, in the bedroom, all the doors, even the front door, the back doors. Even that's in the master. That's where she'd put something over the sliding back door that goes outside. There's some scratch marks from where they'd move stuff. There's the doors down, the main front door downstairs, where they'd put stuff over the front doors downstairs, black the windows out. That was some marks from on the wall. That's just more marks on the wall. That's on top of the dresser in our bedroom. That bedroom suite's about 3 years old. Me and my late wife had purchased that brand new bedroom suite right before she passed away. And somebody took something there and put like a sander or something other down inside the sink and put all kind of swirl marks on inside the sink, and you can see there.
That wasn't like that when you
No,
left
sir. This is
home?
brand new. This is a brand new home. And then that was where somebody had stuck something down inside the commode, left all kinds of black marks inside the commode. That's in the master bathroom right there. That was where one of the animals, I'm assuming, she left outside all the time before she left the home. That was the screen over the back sliding door that was tore plumb up whenever I got back to the home.
Judge, if I may, as Exhibit 3, you prepared a list of all of the vandalism that's going on in the home.
I did, sir. Yes, sir, I did. From what I've been able to tell.
And is that your list?
What is Exhibit 2?
It is.
And I would ask this to be Exhibit 3, is a list of the vandalism that's at the home. Have you put a value as to the vandalism?
Well, you figure the time that I've had to spend on it, I've had to basically shut my business down and either pay the guy that works for me to come over there and work. So you figure our going labor rate right now is $140 an hour on a new customer if they call. And so you figure that's per person. So you figure $280 an hour that I'm losing a day, just sitting there having to pay him to come over there and work at the house that I've had to shut the business down probably for a week total off and on, between having to work on the motorcycle, the side by side, and everything else, that I've had to shut the business down to be able to get my home back in order to even live in it properly and feel safe.
Do you have an amount that you were looking, I know you put as item 17, there was $775 for carpet cleaning and cleaning the mattress?
That's what I
and the
paid.
urine.
That's what I paid a company from Spring Hill to come out and do.
Any other values that you can put on any of this damage? I mean, give me a number.
Well, should have been another receipt for we had a painting company. I had a painting company come out. I think it was $900 or $1,000 what they was going to charge to fix all the holes in the walls and repaint the trim and everything that been messed up. It was a receipt for them, or an estimate from them on that.
$900?
I think it was $900 or $1,000 or something like that. It was about $1,000, I believe.
As far as the other stuff, is there a value? You talked about just overall time and things of
Time,
that
whatever
nature.
you figure an 8-hour day would be at $280. You figure a week of that, because that's what, like I said, that's what both of us average a day is $280 an hour. So you got to figure that.
And Judge, the photographs that I've shown, I'm going to ask those to be put into evidence as well, so next collected, but they're on that thumb drive as well. All of those photographs, I forgot about that, all the vandalism photographs are on that one thumb drive that I handed in.
Right. We'll show that vandalism, that thumb drive contains all photographs.
You had 3 guns.
Yes, sir, I did. When I returned to the home, like I said, both officers searched the home for the guns. None of the guns, none of the ammo or the holsters was there. That kind of become top priority to try to find 3 missing handguns. It was
One of the detectives contacted her, and you got 2 of the guns back.
Yeah, I believe
correct?
Detective Lovell went to her residence wherever she was living at. I don't know where she was living at, and she told him, from what I heard originally, that she only had 2 of the guns. I believe.
One of
he
the
said.
guns is at
One of the guns right
Sheriff's
now.
Department right now,
is
correct?
one of the guns, after the fact, we had to file a police report on a missing gun. And then I believe Detective Martin reached out to her, and she told Detective Martin that I'd physically give her the gun, which is not true, because that was one of the guns that my late wife had purchased for me before she had passed away, saying I would never get rid of something my late wife passed.
One of your relatives has 2 of those guns back.
Not my relative. A friend of mine has them. She has them locked up in their safe at their house.
There's one outstanding that Detective Martin still
Yes,
has.
it's supposed to be at the Dixon County Sheriff's Department right
And
now.
he's saying that he wants some sort of indication from a court as to whether or not he can give that gun to you. correct?
Yeah, because he wants to know who to legally give the gun to. I mean, it's registered in my name, so and I never gave the gun away.
Point of information.
Let me ask this question. What type of gun is Detective Martin holding?
It's a little black 380. It's got a laser sight on it. It's like a little palm handgun.
Brand, you know, what make?
He's got the original receipt on it over there. I can't remember
That's all right.
I can't remember the exact name of it, sir. But it's when we have one of the receipts for it where I purchased it at that Golden Eagle Pawn in Dixon, brand new. Or my late wife gave me the money for it.
Smith & Wesson, 2 Smith & Wessons and a Ruger. Which
Yeah,
one is
one of them's a 45, one of
Which
them's a
one
9.
does Detective Martin have?
The 380, I believe. Is that what it is?
The Smith & Wesson 380?
Yes, it's one he has.
And that's the,
Golden Eagle Pawn. Yeah, that's the one he has right there.
that's the receipt that you bought it in May of 2020.
Yes, sir. That's the gun that's still missing there.
Well, it's not missing. We
Well,
don't
I mean, yeah, we know.
have it.
I mean, physically, yeah, it's not missing, but I mean, to me, it's missing.
All right. Point of information, Judge. So we're just taking up this one motion, which I'm fine with, and then we're going to kind of reset the rest.
It's 10 after 4, you're not going to finish even with this motion, much less get to very much more, so you're going to be looking at whatever's left being rolled over to another day. So we'll stop with this motion and then allow Ms. Childress to cross-examine your client whenever you're concluded on the motion, this motion at least, and the rest of the motions will all have to be heard on another day.
Yes, sir. That's all I have for this one. Thank you.
Childress, you may cross-examine, and I would remind you that we're only dealing with this one motion about all of these issues that Mr. Hawley's gone into. And you need to ask questions rather than make statements, okay?
Yes, Your Honor.
And let me just say that Monday we have a criminal, well, tomorrow I have Fox Hardwood versus Jackson, which is supposed to be an all-day contract dispute, non-jury bench trial. Then I have Monday a criminal docket call, and jury trials are set all of next week. So we'll have to talk about when these other motions might get heard, but it's going to be a while. All right, go ahead, I'm sorry.
Mr. Claiborne, you stated many items in here that you said you purchased, correct?
A lot of there's a lot of the stuff I've had, majority I had before we got married.
So, ma'am,
You may. You'll hand that to everybody.
May I see it before?
If you could read the date.
The date, December the 31st. It was bought under my business account on my business, through the business.
But that was bought while we were married, correct?
The business purchased, our marriage did not purchase that. I bought it
Again,
under
that
the-
was purchased while we were married, correct?
And then again, it was purchased through the business, because one was bought for the
You need
office.
to answer her question first.
It
and
was
then
bought
you
while
can-
we was married, but it was bought through the business. I did not purchase it myself with my own money. No, the business purchased it.
Why did you purchase it?
Purchased one for the office and one for the bedroom.
I believe you purchased one of those.
No, I did not. I did
You
not.
can testify, you can ask
Okay.
questions.
So you purchased both of
I
them?
purchased both of those.
Okay, fair enough. But you would say that those were purchased during the marriage, so they're not stolen. They're not
They
your
was
personal
purchased-
property,
They was
correct?
purchased through the business, yes.
Mr. Claiborne, do you recognize a hummingbird feeder?
Not off the top of my head, unless it was the one that was purchased and took down to the graveyard, but that's not the one that's missing from the home. There was one that was bought and took down to the graveyard. The one that's missing from the home was underneath the kitchen cabinet that belonged to my late wife that she put outside every year that I took down and put it up so nothing would happen to it. And that's not even the picture of the one that was showed here in court.
And that's a receipt from
I have no
your daughter,
idea.
Sydney Claiborne.
Okay, then that's the one she purchased and took down there to the house, because when that picture was took there, that's not the one that was took down to the graveyard.
So, but that was the one that was at the graveyard, correct?
I'm assuming, I don't know, but that's not the one that was at the house. So that was not at the house. The one from the house was put underneath the cabinet.
And your daughter purchased that.
I have no idea who purchased it. I don't know.
Okay, we'll move to the next one. And line item number 55.
Okay, those are yours. There has nothing, that's not what's missing from my house. It's not on my list.
You called out crock pots.
A crock pot, yeah, a red crock pot that belonged to me and my late wife, a red one, not two. These are that you bought for a Christmas party. That's not what I have on the list missing. I have a crock pot. That was the three that you bought for a party at the house.
Okay, so yes, I did purchase 3.
Yes.
But you're saying that there was one missing?
There's a red one missing from the house that me and my late wife had purchased together before she passed away that we've had for years.
Do you recognize the items in those pictures?
I do.
Do you recognize where those pictures are taken at?
Those were taken at your dad's house in Nashville.
Okay, so could you mention the reference number that's on those items?
123.
So on 123, you stated in your motion 2 large black totes with yellow lids.
Yeah,
Can you describe those?
Those
for
are
me, please?
barblet totes, but you had some and I had some, and most of yours were all to the storage units over in Dixon. You had you had 2 units over there, and one of the units was stacked all the way to the top with black totes.
Do you have receipts for those?
You'd probably go back through somewhere through Lowe's. They've been bought over the years.
Are those part of the unopened air tags that you stated were purchased? left
No,
on the
that's
table?
not. That's the air tag right there with the one that Sydney left at the house that she kept paying, that actually me and you took down to the White Bluff Police Department and actually turned into the police department to offer to that one that arrested me 3 times.
So
Yeah, no, that wasn't even at my house when I left. That's actually at White Bluff Police Department right there.
So when were the air tags purchased?
Right before I got removed from the house off Amazon, off of the business account. It may have been off the business account.
And during that time, were we married?
We were married, but it was purchased through the business. The business is separate from the marriage.
Did you not assign those air tags?
Oh, I did not. They had not even been opened up. There was a brand new packet that hadn't even been opened up. There was more than one pack. Some of those had been opened up, yes, but there was still more that had never been opened up.
How many packs of air tags were purchased during the marriage?
I cannot remember. I have to go back, pull my Amazon up and look. Because you carried one on your keychain. There was one in the other work van, and then I think that was the only two that we'd purchased, maybe two more off of Amazon. Those were the ones that was left at the house that had not been opened up.
And the ones that were purchased, you purchased, correct?
I believe it's off Amazon.
And
yes.
you assigned those to my vehicles in your work van, correct?
No, I did not assign to your vehicles. You had one on your phone that you assigned from your phone to your keychain, and the other one that was in my other work van was assigned to my phone and my location.
So you're saying we purchased 8 air tags?
No, you took one of them. I never assigned it to you. There was 4, I believe 4 of them originally purchased at two different times.
Again, the air tags were purchased while we were married, correct?
It was purchased through the business.
Was everything purchased while we were married through your business account?
I purchase about 90% of my stuff through the business, so that way it kind of protects me from the business separately. And everything, that's why I always use the business account. I use my personal account hardly for nothing.
I mean, it's 90% of what you purchase for your business. 90% of that applies to the items that we needed to purchase while we were married.
We didn't buy much while we was married. We bought a few things together, a computer desk and some other stuff. And you purchased some odd and knickknacks to the house that you took when you moved out.
Again, many of these items on this list were items that were purchased while we were married, correct?
No, it was not. Not when you go back to when you've got stuff from 20 years ago that me and my late wife purchased together. All of her jewelry gone, everything else. I mean, me and you purchased none of that.
This goes along with that one.
Okay, so mixer that's missing from the home.
You stated that it was missing from the home. However, one of those text messages is for you to return my mixer from one of your daughters, and the other mixer.
And you got that mixer back.
The other mixer. Can you describe what that picture is?
That's the picture of where I had purchased it for my daughter for her birthday. That was at the home on my counter when I looked, because when I had her removed from the home, I kept the mixer there, along with a missing coffee pot that I had purchased too that was missing from the home.
But you would agree that you purchased those as a gift for your daughter, correct?
Before I had her removed from the home, yes, but they were missing from the home and they was not to be removed.
Please
from
answer
the
the question.
I answered the home.
Did you purchase those as a gift for
I
your
purchased
daughter?
her as a gift for my daughter, but they was at the home when I left.
So those items do not belong to you, correct?
Yeah, because when she left the home, when I had her removed from the home, the items were left at the home in my possession. And we actually have a letter from Sydney Franklin, her requesting the items.
Describe who that text message is from.
It's from Sydney.
Can you tell me what it says? And what's in
It
the
says,
picture?
I found another matching.
Sustained statement made outside of the courtroom that you're introducing is in fact hearsay, so sustained, it will not be admitted.
Yes, Your Honor. Actually, Your Honor, if it's a text message to me, can the piece that I can testify to be admitted into the courtroom?
Statement made by any person outside of the courtroom that's being introduced to prove what's said in that statement to be true is hearsay, which means that even if it's a message to you, you cannot testify about it because of the simple fact that unless there's some other basis for it to be introduced, but because it's still you're repeating what someone outside has said outside of the courtroom.
Yes, Your Honor. Can you describe the picture that's in the image that's captured within that text that I sent?
It's some missing stuff from the home. There's pictures of the blankets and stuff that's missing from the
Can
home.
you describe those blankets?
I mean, they're green and white. There's a white comforter up there in one of them.
And those are mentioned as stolen as well, correct?
They're missing, they're not stolen technically. I can't say stolen.
So that text message is, let me rephrase that. Those are items that were located up in the attic at the home, correct?
They wasn't there when I returned to the home, no.
In that picture,
I don't remember exactly when the picture was taken.
there may be a date on there.
January the
Judge, I'm going to
14th.
object to the hearsay. If there's a date on this thing, it is hearsay. He didn't take the picture, so we can't authenticate the date. If there's a date on there, that would be hearsay.
Saying he can't just read a date on a photograph if he didn't take the photograph.
Yes, Your Honor.
If you took the photograph, you will be able to testify about the date.
And these are, okay. Can you describe those pictures for me? Or specifically, is that the hall closet in the upstairs of the home?
That wasn't like that when I left the home, no. That stuff was not in that hallway closet when I left the home, that I can recall, no.
So
I don't remember that like that, no. Because it's showing all these food containers and stuff for here. These food containers and stuff should have been in the kitchen.
okay, fair enough.
If I remember correctly because that one of those wooden baskets right there is one of the wooden baskets that was brought out the night by you when the police would let me go back in the home and get my stuff. So no, there was more than those in the house. And that meant my medicine was kept actually in that hallway. I believe that hallway closet that night. So yeah, that picture was took after I was removed from the home.
That picture was not.
That was not how the hallway was that night I left, because you was crying and screaming that there was no dog food at the house, and that was testified to in White Bluff Court that you couldn't feed the animals, but there's a whole cases and cases of dog food right here.
Again, that picture was taken while you resided in the home.
I don't recall that
I'm gonna
picture being
object
there.
to the testimony.
I'm just going off what you testified to in White Bluff, that you couldn't feed the animals.
There's an
but-
objection on the floor, you need to stop
sorry.
talking. The objection is to, or making a statement. Mr. Polly?
Well, it's relevance and it's hearsay on a picture that he can't authenticate at this point. He's testified to some of the generalities of it, but she's getting more into the exactness of it.
Sustained.
You stated that I stole your, is it Ativan, lorazepam,
What is it?
that was removed from the home?
The what?
Lorazepam. That you had to take, you showed pictures of it.
That wasn't the lorazepam.
That's incorrect. There were
Xanax.
pictures of it. Yes, that's the generic name for
Okay,
Xanax.
well, whatever's on the bottle, yes. But I mean, yeah, there was 2 bottles that was left at the house. I mean, I didn't.
While we were married, did I take that same prescription?
But not under my name, when those names are on my bottle. Those are my
But I
bottles.
took that same prescription,
I
correct?
don't know. I remember you took them, but I don't know what milligram you took, to tell you the truth. You took so much stuff, it's kind of hard to tell.
That's hearsay.
Judge, I'm object to the argumentative.
Well, just answer the question. Don't volunteer additional information, and you don't respond if he does.
Yes,
You
sir.
can object to what he says as being non-responsive.
Yes, Your Honor. 1 milligram every 8 hours is needed. Can you state for the courts what your milligrams were?
Without seeing that picture up there again, what the milligrams were, no, I cannot
enough.
recall.
Okay, fair enough. Do you recognize that document?
I do.
Can you read off can you tell me who the complainant is?
It would be me.
So can you read off the items that were allegedly stolen from that home?
We're missing from the home is it was one of the rings, a golden weaving basket ring, that we had a picture with her on,
Can you state the value of that ring that you listed?
probably $1,000 maybe,
Can you read what you stated in the police report?
that the ring was missing from the house.
Let me specify, can you state the dollar value
I said
that is on that police report?
probably $1,000. It was something my late wife would have bought.
I don't need probably, I'm asking you
It
to
said
read.
$1,000 is what it was on here, is what she probably would have paid for it, is what I'm assuming.
What is the dollar value that you listed on the police
I
report
said
for the value of the
$1,000
ring?
is about probably what she would have paid for it, is what was listed on the report.
Can you flip to the front page and specifically read off the items that are listed with their dollar value?
Judge, I'm gonna object. What's on the front page, and this is a police report, he wrote some things on the back page, which is fair game, and I've let her question. But this front page, this police report's not been authenticated properly, and I first time I've seen it, I didn't know what was going on with it.
Police reports are not typically admissible as evidence because of the fact that they constitute a report by an individual who is not a witness, even if the officer is testifying, the report itself would be hearsay.
Yes, Your Honor, I can redact it and reword it.
All right.
Some of the stuff on here is not even mine anyway.
Okay, I can redact it and ask the question another way. So you stated that the ring was $1,000 and that it was
That
your,
was my estimated guess of it.
and it was your late mother's, right?
No,
Or your
my
late wife's?
wife's would have been something she had purchased probably.
Can you identify the person in this picture?
Can I see that, please?
That'd be Sydney,
Can you tell me what she's wearing?
that ring is missing.
The $1,000 ring
I'm assuming that's it. It looks like it. I
that
don't
belonged to
know.
your late wife?
That's one of the rings that's missing of my late wife's.
Can you flip the page, please?
Okay.
Where there's just the ring listed. What is the dollar value of that ring?
Judge, I'll object to
$60.
Your Honor, it's
the
real.
authentication for the document at that point.
Because I don't know that that's the
first
same.
page was okay, but I don't know anything about this other.
Your Honor, there-
When I told you a minute ago that you don't talk when there's an objection on the floor, I actually meant it. So
Sorry.
be quiet until I hear what they're arguing about. What is it, Mr. Holly?
He's testifying from a document that's not been authenticated. I'm testifying to hearsay and the proper authentication. When we flip the page and actually look at something that somebody else has printed, I understand that the one page I saw was he identified that as his daughter, so I'll let him testify to it.
Your Honor, the ring, the pictures that I presented, I actually printed myself, and the relevance is because there are multiple items on this on this motion that has been filed that have already been previously reported to other law enforcement agencies in an attempt to bring false theft charges against your own daughter.
Well, you'll be asking him a question if you're arguing to me. Number one, at 4:30 in the afternoon, we're going to adjourn this hearing. And all I can tell you is I don't have another date unless it's a regular chancery date, and we put it at the tail of the docket. So the next chancery date that we have is September the 6th, and I'm assuming that's going to be a full day. September the 7th. September the 25th.
That has Jennifer Roberts, Kay Taylor Brown on there, that's a final hearing, she said it was gonna take quite a bit, but we can put it on that day.
Your Honor, for planning purposes, I do have an 80-page document. It's a spreadsheet with every line item that's been mentioned in this motion. I do have the evidence, I do have pictures, I do have videos, and I do have receipts to support it to review.
Good to hear, because I've already ordered you to provide discovery to Mr. Holly, and that is the type of document he's entitled to hear or to review before we come back to this court. This case will be reset for for September the 25th. We'll take up the matters that are already set, and we'll resume this case after the regular docket on that day.
Thank you, Your Honor.
You have already been ordered to provide answers to the discovery that was requested, and that would include this 80-page document you're referring to. So,
Yes, Your Honor.
Mr. Claiborne, you may step down, have a seat by your lawyer. Court stands adjourned.
Thank you, Judge.
All right.
Court is now adjourned.
Ms. Childers Claiborne, we are not able to take up your entire case today because of the lateness of the day. Mr. Holly has a number of motions that have been filed, and one of his motions is a motion for default. Is that correct?
Yes, sir.
This is a motion for default judgment. Right. You may argue your motion.
Judge, I'm looking at the order from the August 24th day that we were in court. This court signed that. I think I got it yesterday or maybe the day before. And
I don't have it in the file, I don't think. It may be in the back. Yes, I do, I'm sorry.
and it was not pro tunc. We were here that day, and it was announced on the 24th day of August. You made a specific announcement to Ms. Claiborne about the discovery and what needed to be done. And I put that in the order. Everybody knew about it from August 24th. But that part of the order, that the wife shall provide full and complete answers to all discovery questions previously filed by the husband within 30 days of today's hearing date, or sanctions may be imposed. She came by the office on Friday and dropped, and I was out of the office on Friday, but she dropped off answers to discovery. I'm going to give the court, if I may, for my motion, tender a copy of what she gave. They, first off, are not notarized as they are required under the rules of procedure. Glaringly, when I looked at these kind of like over the weekend, I noticed the answer to like the very first question that is there concerning her income, and that would be
which question are you referring to? Because the question number one on the copy you've given me is, have you ever been arrested?
right. Looking at the first question about her income, to provide me her current employment. Let me get my bearings here. Number 3, if you're employed, please state the name and address of your current employer, brief description of your job, immediate supervisor, base rate of pay, attach your last 3 pay stubs.
Involving alimony, or is it?
This is a temporary motion. It's what we're in the midst of right now with all those filings, but no, this was a 5-month marriage.
I was going to say they've been married for 5 months.
We have not asked for spousal support.
Right, so why do you need to know what her income is?
Well, I take that back. She was asking for spousal support, and she's got a motion. The court said you wouldn't hear that motion at that time because she hadn't provided an answer to discovery.
Right.
When we were here that time, I objected because I didn't know in the discovery questions, and I had filed them. This has been going on since, and I go back and look, I believe since February of this year, asking for discovery when Mr. Baker did represent her, and I know he got those. But when I look at this, she didn't provide anything regarding her employment. She is employed by Metrocan. My staff actually verified that on Friday. What you got is a copy at the front of this of a discrepancy letter that we did on Friday, and I need to, and I'll give that to her at some point. It might have been mailed already, but again, she dropped it off on Friday. We just did that actually on Friday afternoon, my staff did. But they realized there wasn't any of her current employer. They called, they verified. She's working at Metrocan. I went back and looked at my security footage, and I can pull this up for the court. You know, she shows up in a blue shirt that appears to be a Metrocan, shirt. And I've got no pay stubs. I've got no mention of it. She hasn't told me about that. And again, for someone that's, asking for spousal support and things of that nature, that's an important question. The bank records show several transfers from different banking accounts I believe that she's done, and I've got basically a couple of accounts. And I don't have anything that refers to the account number that those EBs are coming from. And I noticed there were two separate bank accounts that she's transferring money from, it looks like herself, and that has not happened. I do not have anything in the record of her answers, to put that together. She talks about, produce fully, one of the questions, request, produce fully and all copies of email, text messages, letters, things of that nature. And she apparently in the discovery has said that she doesn't own a cell phone anymore. She's thrown them all away. When I asked for social media posts, her answer to that is she's disconnected from all social media, and she's not able to go back and retrieve any of that information, which the court can take judicial notice. You can still go back and retrieve that information that's logged in on your account. So the full and complete answers as to what I've stated are not there. And it's been quite the while, been months, she's had available to do this. She brings it into my office on Friday afternoon. There is a listing there of, we went over, if the court will recall, several photographs of what the house looked like with the TV in place, and then the TV's gone and that kind of stuff to show the missing items. The powder around the Harley gas tank. There's a lot of vandalism to the house as well. She didn't really address a lot of those things. The people that came to the house, again, that question is not fully answered, in my opinion. But moreover, the most glaring question to me, among all the others, is just she refuses to tell me her current employment. She's done that now for quite some time. I don't know why, when you are working and apparently working possibly that day and you're over in my office in a shirt, what appears to be your employer's shirt, and then you don't answer discovery that way. And it's just basically, in my opinion, she's just not going to answer this discovery properly. It specifically says it's supposed to be notarized and sworn to, and she has failed to do that in the many months that she's had it. So I am asking for a default judgment. Mr. Claiborne's here. He does have two witnesses that can testify about the marriage. We are still asking for approximately, I think it's around $43,000 in, missing and damaged items that court's already heard testimony on. And she's cross-examined Mr. Claiborne on that. So that would be the biggest, and I said this in my opening statements with that motion, this is a divorce. It's a 5-month marriage. But that's not really the time frame that we're looking at in this. It's the time that he was arrested for the domestic, which we highly contest. It's set for a trial, I think, in March of this year. Now it got continued. To the time that he got the house back was just a couple of months, actually. And that was when all of this damage did occur. But I've got witnesses that can testify and put on some proof as to their knowledge of all of that as well.
Well, looking at it, I want to make sure I'm understanding what it is that you're saying she's not fully answered. Your interrogatories that you handed me are question number 1. Have you ever been arrested? It says see attachment. There is no attachment that addresses that issue. Is that correct? Number 2, please state your full name, including any alias. See attachment. There is nothing in the attachment that I see just looking at that addresses that answer. Is that correct?
Yes, sir. I don't see anything.
Question 3, if you're employed, please state the name, address of your current employer, a brief description of your job, the name of your immediate supervisor, pay, et cetera, et cetera. It says see attachment. And again, unless I'm missing something, I don't see any information that is supplied in the attachment that answers that question. Number 4, for all checking, savings, and retirement, account 401 stocks and bonds. Now, there are some bank account records that are attached that says see attachment. Number 5, during the course of your marriage, please state each and every time that you have been to a place called the Red Room or any equivalent swingers club by way, date, name and address, names of unknown of individuals with whom you had a romantic and/or sexual contact while at said facility. It says, again, see attachment. There's nothing that I see in the attachment that addresses the answer to that question. Then we go forward to number 6. And it talks about the names of every person that was on that property of the marital residence. Have a seat until I call you. Every person that was at the marital property or marital residence by the name, date, time, and so forth says see attachment. Again, I see nothing in these answers that are attached, rather, that would answer that question. Please state specifically with each and every account to your knowledge that deals with the estate of your father by way of the name of the financial institution, et cetera. And again, I don't know if these bank accounts are the ones that would answer that question or not, but it says see attached. During number 8, during the time you occupied a marital residence while he was not allowed on the property, talks about her driving the Nissan Armada, plate every trip she took in the Armada, the date, purpose of the trip, et cetera, says see attached. I see nothing that would indicate that. Number 9, number 10, number 11, number 12, number 13. 13 might be potentially answered by the attachment of her descriptions of the property and so forth.
It is.
And number 14 would not have been answered. Number 15 would not have been answered by that.
No.
Number 16 would not have been answered. 17, assets which you consider to be marital property. I would take that her listing of those property items that were there and so forth that she's gone through, that might be potentially answered. Number 18, identifying the name of every male or female with whom you've had sexual intercourse, oral sex, et cetera, says see attachment. There's nothing to indicate that. 19, whether the plaintiff has been a good spouse, says see attached. There's nothing in that indicates that. Goes on about witnesses and every other. So the great majority of all your questions were just simply appears to be just us. I don't know if that's a stamp or what, if it says see attachment, but on every one of those it's see attachment, and none of those things seem to address the answers to your questions.
Because I would say even some of those that you brought up, they didn't even put down in the deficiency letter, but I would rely specifically on my deficiency letter as well. You go through that, that's all the concerns that I've got, and as you can tell, that deficiency letter, it's a smooth 2 pages, almost 2.5 pages here of things that she has left out as well after we went through it, and I've kind of confirmed that a little bit with that letter.
When you ask for sanctions, you're asking for me to grant you a default judgment, strike her pleadings, and just allow your client to proceed with the divorce.
Yes, sir.
The other option is that I grant your request for sanctions and bar her from presenting any proof on any of these issues. That's another option that I have.
Yes, sir.
All right, let me hear from Ms. Schroeders-Claiborne.
Thank you, Judge.
Your Honor, first of all, this is the first time I'm hearing about this default judgment. So I didn't bring anything to prove otherwise. However, when that documentation was dropped off at Mr. Hawley's office, there was indeed a separate attachment that detailed, and I believe it was 6 pages long. And I have a copy of that in my desk drawer at work because I made myself a copy and I left him one. And I can prove to you that that was turned in because Mr. Hawley himself even made mention about my cellular devices and my Facebook not being able to provide those. And that was also in that separate attachment. And I did in fact answer every single question on there to the best of my ability. When he's talking about my employer, most of those questions were answered in April. I just did not complete those because a lot of it had to do with the criminal investigation. So the only answers that I had to go back and put in was in fact the ones that were pertaining that I had not answered before. Mr. Holly is fully aware that I'm working. He's mentioned it in here several times. However, due to the amount of stalking and harassment that I've gone through, I mean, his client has been indicted several times now on stalking and violation of order protection and bond conditions. I don't feel safe providing my work location and address, as well as my home information, as well as my social security number, my driver's license number. I mean, but I did answer with the exception of I did not update my employer. At the time that he served me with those discovery requests, those were in April, not February. We had not even filed for a divorce at that time. We were still living together. They were sent to me the middle of April, and I did answer those. And I actually have the email at my work where I did send the answers that I had to Olin Baker. I did answer to the best of my ability. And in those motions that you have currently, I did answer those to my best of my ability. Why Mr. Holly has left my attachment out, I don't understand, considering he has provided the responses verbally in this courtroom. Aside from that, the last hearing that he mentioned involving the $43,000 of items, not counting what the cost of the house being vandalized is, I only got 15 minutes to 20 minutes during court last time, and to cross-examine Chris, I specifically said, I have hundreds of receipts in Facebook posts and communication where the majority of that stuff I did purchase. I have that information. I did provide him the spreadsheet. And I also have witnesses as well as video and pictures to submit to the court. The video was taken at 5:08. There's pictures of all of us pulling out onto Highway 70 at 5:13, 5 minutes later. No one was in the house supposedly for 3 days. So, I mean, I need the opportunity to present those.
Well, you've been given the opportunity on cross-examination, but we did not finish the trial, or the hearing, and when we came back to court the next time, which was theoretically going to be today, you were going to be given an opportunity to resume your cross-examination.
Yes, Your Honor.
I wasn't cutting you off, but it is that. We are not obviously going to be able to take it up today and get anywhere with it, so we're going to have to find you another date. In the meantime, I am going to simply pass your motion for sanctions, Mr. Holly, until she is allowed to produce what she says is her answers, that she says she provided an attachment, which I'm not seeing in what I've been given. And if she produces that, then we'll consider whether or not your sanctions are appropriate or not. At this point, Mr. Holly, I'm going to file what you have provided to me with the clerk, and just advise you that you need to get with the clerk here about resetting this motion, and then we'll go from there.
And Your Honor, I advise Mr. Holly that if it's reset for October, I'll be out of the state the middle of October, from the 10th until the 18th. So I just request that the next hearing not be set during that time. It's arrangements that I cannot.
Out of town from when to when?
From the 10th until the 18th, and it's something that I've already paid for.
Well, this would be an appropriate case to have heard on Halloween, October the 31st.
Yes, Your Honor, I'm
We've
too.
already set,
Some of them made Thursday and Friday's always maybe to that day.
they have been moved to the 31st. Did I give you that date?
You just did one, no.
I know, but how did you move everything that quickly?
I on my email, I sent emails and told them they had that was an option.
Judge, if I can, this has been reset twice. The whole back row has been here. I've got one lady that's not going to be here on the 31st, but I'd
We're
ask
going to
her.
hear this on the 31st. We'll just have
You
to,
did it first, I mean, that can you,
what did I set on the 31st already today?
from the night, you didn't, you said,
Miss Robertson, oh, okay, that's the 10th. All right, we'll set this first on the 31st to finish this area.
Thank you, Judge.
Thank you, Your
And
Honor.
all subpoenas can be continued to that day. So everybody's in the courtroom.
Everyone who's under subpoena, I apologize. We have too many cases to get heard in one day, and as a result, this matter can't get heard. It was last on the docket. It'll be first on the docket on Halloween. We'll see you all then. Everybody continues under a subpoena for that.
Thank you, Judge.
Thank you, Your Honor.
Court stands adjourned. Time I've got, so. All right. See ya. All right, we have two motions to quash in the Claiborne case that I've been handed. Claiborne versus Claiborne. Is Ms. Claiborne, Childress Claiborne here? Go out in the hallway and call in Ms. Childress, Amy Lee Childress Claiborne.
Because of the rule last time, used to step out.
By the way, anybody that feels aggrieved by the fact that we don't have enough days to get your stuff heard, contact your local representatives of the state legislature, both the state house and the state senate. In fact, call every one of them, because for the fourth year in a row, we were up to get a fourth judge. And for the fourth year in a row, everyone around us, Montgomery County and Williamson County in particular, were awarded additional judges, and we were not. So there is no rhyme or reason for why that happens, except for the fact that we all kind of have an idea of why it happens. So, Ms. Childress Claiborne, we are ready to take this matter up. Is the rule requested?
It has been, Your Honor.
The rule has been requested, so if there anyone who's going to be a witness in this case must go outside of the courtroom and remain outside of the courtroom until you are called to testify. You are not to discuss the testimony of any other witness with anyone prior to this, and that includes watching any live stream of this proceeding.
Your Honor, I plan to call Miss Stacy Davis as a witness as well.
Stacy Sanders, if she's going to be called as a potential witness, then she'll need to go outside.
And I'm sorry, also Pat Jones as well as the neighbors.
Have you subpoenaed them?
No, Your Honor.
Then if you haven't subpoenaed them, you have no right to necessarily force them to leave the room. Mr. Holly, do you wish to waive the rule regarding those witnesses to allow them to remain, or you want them out?
Only without subpoenaed, they're not on her discovery for any witness. I don't have any witnesses listed. I mean, that's all news to me who she was going to call today. So I'm not willing to waive it.
Your Honor, ever since March, they've all been out in the hall as potential witnesses.
Out of an abundance of caution, Mr. Holly, let's have this lady that she's just designated go outside. I'll make a decision whether or not she's entitled to call.
Great.
Judge, may I interrupt briefly? May I step downstairs to circuit court until Piper is called later if it's called?
You can go anywhere you want to between now and Piper.
Thanks, Judge.
Because I have no great confidence that we're going to get to the Piper case, because it is last on the docket. So.
Yes, Judge. Thank you.
All right, if those witnesses are outside of the courtroom, then I am in a position where I want to hear this motion. We have two motions to quash.
And I still renewed and I refiled my motion for default judgment as well, Your Honor, for today. I put together the discovery and
well, let's first take up the motion to quash. You are here, if I understand, on the motion to quash, Mr. Mills.
Yes, Your Honor. I'm representing the town of White Bluff. Two officers were subpoenaed by Mr. Holly and Mr. Potter's here on behalf of the county. A county detective was subpoenaed. Ready to take that up if Your Honor is ready.
Ready to go. I assume that's something we need to address on the front end, simply because of the fact that it will determine how many witnesses are available and what evidence is available.
Your Honor, the gravamen of the motion is that under Rule 45, non-party witnesses must be given 21 days to respond. These subpoenas were issued on October 20th, 11 days ago. So that's the main thrust of this motion. as to the subpoena ducis tecum, which compelled testimony and the production of a pretty wide range of documents, evidence, and tangible things, which we have not had a chance to review. I believe the White Bluff officers were served last Wednesday, issued 11 days ago. Also, there are criminal investigations that are pending that involve both parties. So if the court denies our motion to quash as to these subpoenas and requires their testimony, we would ask the court to limit their testimony to any facts unrelated to those criminal investigations. So that's the basis. I don't know if Mr. Potter has anything to add for the county for Detective Lovell.
It's the same argument, Your Honor. I think that the county detective was subpoenaed to appear today and give testimony. The same argument Mr. Mills has made, asking for a lot of documents, records, papers, electronically filed information, etc. Certainly was issued less than 21 days ago and served even later than that. And so I think there's an absolute right to declare the subpoena ducis tecum void ab initio because of the time frame. But if Your Honor compels the testimony of this officer, as Mr. Mills pointed out, it's our understanding that there are pending criminal investigations, that there should be some limit on what the scope of the testimony.
Mr. Hawley, did you issue a subpoena?
I did. A couple of them. 2 White Bluff City officers and then Detective Lovell, who is with the county on behalf of, that's what Mr. Potter was arguing. First off, Judge, I don't have any issue with the testimony going to whatever is civil in nature. I agree with that wholeheartedly. Part of the reason for the delay in these subpoenas is the lateness of the answers and the discovery that I got. If Your Honor is looking at my motion, and when we get to my motion here in a few minutes, what you will know is that she answered the discovery late on a Friday, September 22nd. I had that Valdez case on Monday, a couple of other ones. I'm in the office on Sunday trying to figure out and make sense of the discovery. As I was looking at the discovery, I was taking her answers, looking at it, looking at the questions, flipping it over upside down and doing that thing. And I left her answers upside down on my desk when I ran out of there late Sunday night to get everything prepared. When we came to court last time on the default judgment, the answers that were filed with the court didn't include her written answers. I've corrected that today in my filing. I put everything together, explained that in my motion, and it's all there. It's still grossly deficient. I still want to take up my default judgment momentarily. Part of it, if you will look, and I can pass it back, but part of the problem that I had was when she answered the discovery, when I wanted to know where all of these items were. In this case, this motion for contempt is about her cleaning out his house. You heard the testimony of the officers already. But I get this with typeset that is, I don't know, 1/8 of an inch maybe. I had to get my magnifying glass out to look at it. It's riddled with some of these things now she's claiming she gave to the officers. And there's some different kind of stuff she gave. I don't know why you would need, there's like a sugar tester for your blood. There's some things in there. I have no idea why they would need that in an investigation. But she claims she gave it all to Officer Sudduth, Chief of Police in White Bluff, Chris Fulcher, and Steve Lovell, detective. My question for them is, do you have it or do you not have it? Is she telling the truth? Is she not telling the truth? My understanding, I expect the evidence will show, Officer Sudduth said whatever he got, he gave to Detective Lovell. Chris Fulcher's out there with one air tag he said he had, and that was all that he has. And that's what the evidence is going to show. Detective Lovell says he has a couple of boxes of things out in the car that if, told to come in or wants to, inquire about that, he does have those things. But that was the reason for the lateness. By the time I had a chance to look at her discovery and determine that from the 22nd of September late in the day, which I think if I calculated right, it's about 10, 12, 13 business days. By the time I had a chance to read her discovery where she's now saying that some of these items went with the officers, that's when I said, well, we may need the officers here to figure out what exactly she gave. I've spoken with, and Detective Martin, Troy Martin is in this, I've spoken with him. She claims there's a lot of stuff given to Sheriff Eads. The evidence will show with Detective Martin, he investigated that. Sheriff Eads didn't have anything. There's a couple of things that Detective Martin's had. He's been here the entire time. I haven't seen him this morning. I hope he comes. I may have to call him. But the basic gravamen of what I'm after is not necessarily for anything criminal. It's just for these guys to testify as to what she actually gave them, see if it goes to the truth of what she's saying in her discovery. The discovery answers were not signed. Again, that's part of my motion here in a few minutes. They're not under oath now. They're nothing but just pieces of paper that were given to me. But that is what she has told me, and she gave it to me months late. I filed this discovery. I think the discovery is 6-7 months late. I haven't looked at it in a little bit, but it was very late from the time she gave it to me. But I was scrambling to get them if she when I did, based on what she told me. I'm gonna ask that they stay and at least provide that testimony to the court. They are here.
All right, Ms. Claiborne, you want to come to the podium? And this is, all I'm hearing right now is the motion to quash that's been filed by the town of White Bluff and Dixon County on behalf of these witnesses that have been subpoenaed.
Yes, Your Honor. The reason that I wanted to take this stand is I want to discredit several things that Mr. Hawley is saying. I believe
We're not arguing the motion.
Yeah.
We're not arguing a motion for default. Focus on just the motion to quash the subpoenas that we issued. Did you issue a subpoena for these two officers?
No, Your Honor.
You did not issue a subpoena?
No, Your Honor.
Then have a seat. Since the subpoenas were issued by Mr. Hawley rather than Ms. Childers Claiborne, it is this court's opinion that rule pretty clear, as was set forth in the motion, that Rule 45.07 of the Tennessee Rules of Civil Procedure is styled, and this is important, protection of persons subject to subpoena. The purpose of the rule is to protect people who are being subpoenaed that are non-parties. Subsection 1 of that rule states as follows: a party or attorney responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden or expense on a non-party witness subject to the subpoena, and shall provide the non-party witness at least 21 days after service of the subpoena to respond, absent agreement of the non-party witness or court order. Now, in my opinion, I am of the opinion that it is that rule would prevent the witnesses who have been subpoenaed to produce any documentary evidence, period, unless they've been given 21 days. But I don't see anything that would prevent them from being subject to subpoena to testify in person, and therefore I will grant in part your motions to quash as to the production of any records, any kind of documentary proof, but the witnesses who have been subpoenaed can testify as to non-criminal matters. Mr. Hawley has made that clear. That's what he intends to do. So their testimony will be limited to non-criminal matters. And if either of you wish to remain during their testimony to advise them, because since you are the attorney representing those witnesses, you have the right to remain during their testimony to ensure that they are not exceeding the civil portion into the criminal investigation. I don't want to turn this into a preliminary hearing for the criminal cases, and I'm not going to allow that to occur. So, go ahead.
Thank you. We'll advise the witnesses.
All right. Now, Mr. Hawley, have you argued sufficiently your motion for default?
Judge, I got a few more things to add. The court should have filed October the 5th from me a motion for default judgment. And this is, I think, more or less the second, maybe third time we've taken this default judgment up. Every time that we've taken it, she's done a little something to carry it a little more further and get it continued. The bottom line with this is she's not answered her discovery yet. And attached to that motion, you should have everything that I got from her at this point. I looked at it closely. And again, the last time I was in court late on Sunday trying to prepare for everything, and she dropped this off at the last minute for our hearing purportedly on that following Monday. That Friday afternoon she came in, I was looking at the questions like we do, looking at the answers. I was flipping them over upside down and doing that on my desk. Looked at them really quickly. Didn't have time really to read the small print of the other answer. But I didn't flip that one back over and put it back in and have it in that stack to hand to you that following Monday morning. But I do now, and the answers are all there. I had prepared a deficiency letter at that time for Ms. Childers, and I stand behind my deficiency letter. It was still accurate because when my staff had looked at this for the deficiencies, that they had looked at her answers. The first thing I'm going to point out is in the 6-7 months or so since these things have been filed and outstanding, she still has not provided a signed copy under oath as required under the rules. That was made plain in the deficiency letter. The deficiency letter was sent back out to her again. So she heard about it all that day that we were in here. She got the deficiency letter. These answers have not been signed. And if you look at what she's missing, she didn't put down any aliases, obviously I know her name, but alias, social security number, and driver's license number. And those are pretty stock questions, and I didn't get anything as far as an answer on that goes. See attachment, there's nothing in there. Please state your current employer as well as your last 3 months pay stubs. I got nothing. There's no answer to that question. And I would submit to the court, mainly we're arguing today about money. In this motion for contempt, it's about the cleaning out of the house and all the things that, when this court ordered that she would leave the home and have nothing damaged or destroyed, the court's heard enough to understand that's where we are with this motion. And she has a source of income here with her employer that ties into this at the very end if the court grants it as her ability to pay. And I don't have anything. I have confirmed with the office she does have and has had a job for quite some time at Metrocan. I can show Your Honor the staff footage of my cameras at my office. I believe she had a Metrocan shirt on when she dropped this stuff off on Friday. But she hasn't, and she refuses to answer that question. There goes on with bank accounts. There's issues with her father's estate, which again is money to her, which would affect her ability to pay. She's refused to answer those questions. Interrogatory number 22, I think, is important. Please state your witnesses, address, telephone numbers. There's nothing. And she comes in today and said, I'm going to call these witnesses. It'll be the news to me. First I've heard of it. And she refuses to answer that question about the witnesses and refused to answer about them in the overall case in the divorce. It affects today as well. Of course, there's other questions here. I'm trying to hit the highlights. The request for production of documents, obviously the pay stubs are not there, tax returns are not there, business statements, anything having to do with Facebook, and she has put quite a few things on Facebook regarding all of this, and there's nothing there. What she considers to be her separate property list, separate property owned prior to the marriage, recordings, anything of Mr. Claiborne, I have absolutely nothing of. And these are minus the recordings, I think. I don't know if there's any of that or not that she might have. But the rest of this stuff is all boilerplate discovery things that go to our issues here today. And it's the reason why things take forever is because you kind of got to go off on a fishing expedition when you get into these motions or a final hearing when people don't adequately answer the discovery. I'm kind of in a hamstrung situation here. I do think based on the conduct of Ms. Childress and her flat-out refusal to answer these, I'm entitled to a default judgment in some manner. I would ask that the parties be divorced today, that put on some testimony about the proof if you need it again from him, but the motion pretty well sums everything up and adds it up. Or the only other issue with the divorce is I think it's $42,000 some odd dollars worth of property that she's absconded with or vandalized at his house. And Your Honor heard hours of testimony on that, saw the pictures, saw the receipts, saw everything that we put up on the stand. But it's just not fair for her to be able to avoid the rules. I know she's representing herself, but this court, and she has been representing herself for some time, this court made it pretty plain, and it's in the order, that she was to provide a full, complete answer to the discovery the last time we were here. not to mention this time. And I've just failed to get anything that I can use. And again, the other thing that I'm getting, the court looks at the back of this where it says, you know, she's listing and addressing that list that Mr. Claiborne did. I had to get a magnifying glass to help me out with that. I'm not as young as I used to be. My bifocals weren't working, but I submit to the court, if you see that, that's just another situation that we have to deal with in this case from Ms. Claiborne. And it's another way to just get a dig in as far as the whole process goes, which he puts it in font that's that size. Thank you, Judge.
Shoulders Claiborne, you may address the motion for default.
Yes, Your Honor. I guess I don't really.
Happy anniversary. You just had your first year anniversary, October the 3rd. So
Yes, sir.
I'm sure it was a joyous occasion for you and Mr. Claiborne.
Well, it would have been, but unfortunately, a week after I was in your courtroom, I lost my job with Metrocan. They eliminated my position after.
Well, I say that sarcastically because this was a 4-month marriage, and we are now a year into your marriage. You were married in October and filed for divorce. Mr. Claiborne filed for divorce in March of 2023.
Yes,
So,
Your Honor.
anyway, more like a 5-month marriage, but in any event, divorce has been pending longer than you and Mr. Claiborne lived together.
Yes, Your Honor.
I want you to understand that makes a difference as far as the law is concerned on the length of your marriage.
Yes, sir. Yes, Your Honor.
So I need you to address why you have not answered more fully the discovery pursuant to the order that I entered in August of this year.
Yes, Your Honor. So when you entered that order in August, you gave me 30 days to respond to Mr. Hawley. I did that. I delivered the discovery request in a packet on September 22nd. Furthermore, Mr. Hawley stated when we were in here last that I didn't submit my discovery responses at all, even though he was quite vocal in quoting my responses that I did provide. Now, Your Honor, when we were in court last time, you advised me that I needed to bring in my evidence, that I did turn it into Mr. Hawley, and those answers needed to be here today. Your Honor, I would like to present, I have a video on this thumb drive. 12:06 p.m. is when I walked those answers into Mr. Hawley's office. This is a screenshot of my answers where, in fact, interrogatory number 2, my social security number, 41151.
Don't say it out loud, please. This is being live streamed across the world. You don't need to put your social security number out there. Mr. Hawley, do you have any question about the fact that she produced those at your office?
I do. You have everything that she produced. I haven't seen what she's looking at here, but if she's going to.
Mr. Hawley.
Okay. And I'm going to disagree with you, Mr. Hawley, of the video where I handed it to Bobby in your office. There's a screenshot and there's my answers. And if you look at response number 22 that you previously called out to Mr. Wolf, I did in fact answer that as well. Not one of my responses was left blank.
Well, again, Judge, I just need a little bit of time to compare this with what I've got. For that being the case. I did not get this. This is not something that I got. This court, and if you don't have it, I've sent that to the court attached to my motion as to what I got. That says see attached.
Well, Your Honor, I have no problem if someone can instruct me on how to use the computer. It's on my thumb drive.
What is?
The video of me with those responses on the top page, walking those into Mr. Hawley's office from my Jeep, walking in to the only lady that was in the office was Miss Bobby, and you can hear me telling her, this is my discovery from Mr. Hawley. I did a screenshot of that video, and that screenshot aligns with my answers. My answers were on the top. I recorded that for a reason, Your Honor. I have been drugged through the unimaginable with this attorney and his client, and I have had to document and cover my every move in my entire life right now. I have the evidence to prove I turned in the responses.
Well, if you desire to try to demonstrate that video, you may do so if you have the type of equipment necessary. I cannot try your case for you, Ms. Childers-Claiborne. You have the obligation representing yourself since your prior attorney has withdrawn. It is your obligation to put on whatever proof you wish to do so. But I want to inform you of the following. On August the 24th, this court put an order down that stated as follows. It is therefore ordered, a judge and decreed that the wife shall provide full and complete answers to all discovery questions previously filed by the husband within 30 days of today's hearing date, August 24th, 2023, or sanctions may be imposed. Now listen to me as I explain to you, because if you had a lawyer, your lawyer would know this, but you're charged with the same knowledge of anyone else. Each interrogatory, I'm looking at Rule 33 of the .01 of the Tennessee Rules of Civil Procedure. Each interrogatory, which is what we're dealing with, shall be answered separately and fully in writing under oath. So none of these have been sworn to. Mr. Hawley's allegation that you did not sign them before a notary or provide them under oath, and therefore, and that if they have not been fully answered, then under those circumstances, they don't comply with the court's order. The Rule 37.01 is what Mr. Hawley is referring to as far as what he's asking for default judgment, failure to make or cooperate in discovery sanctions. And basically, it provides that if a person fails to provide the answers under interrogatories that were required under a court order, that an evasive or an incomplete answer, for purposes of this subdivision, an evasive or incomplete answer is to be treated as a failure to answer. It allows the court to make award of expenses for the motion. Failure to comply with a court order. If a party fails to comply with an order regarding discovery, or provide or permit discovery, including an order made under the previous order that I've done, then these are what the court can do. An order that the matters regarding which the order was made or any other designated fact shall be taken as established for the purposes of an action in accordance with the claim of the party obtaining the order. In other words, basically it says it's not a default judgment, but it basically says whatever Mr. Hawley and his clients say is the truth is to be taken as the truth. Paragraph B, an order refusing to allow the disobedient party to support or oppose a designated claim or defense, or prohibiting the party from introducing designated matters into evidence. In other words, I can simply say, because you've not fully completed your discovery, that you can't introduce any evidence on these issues that are before the court. Paragraph C, an order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding as any part thereof, or rendering a judgment by default against the disobedient party, which is what he's asking me to do. In lieu of any of the foregoing orders, or in addition thereto, an order treating as contempt of court for failure to obey any order except an order to submit to physical or mental examination. And then where a party fails to comply with an order under 35.01 requiring a party to produce another for examination, that one doesn't apply. So you see what the rule provides is pretty clear. You can't just submit a bunch of stuff and say, I've answered the discovery. Your answers have to be complete, directly responsive to the questions that were asked, and under oath. And in this case, those things have not been done. So whether or not you delivered some documents to Mr. Hawley and have a video of it is not really the relevant issue. The relevant issue is whether or not you fully answered those discovery questions and whether or not that constitutes a violation of the order of this court regarding discovery entered in August, and whether or not I'm going to then allow you to put on any proof regarding those issues.
Yes, Your Honor. And I'm sorry, my point that I'm making is I answered every question Mr. Hawley asked me. There's a printout. Mr. Hawley has my documents. What I'm stating is on this thumb drive, those answers were on the top page because I knew he would pull this. And I walked them into his office and physically handed them to Bobby. And she acknowledged and took them. I answered every question that came my way, and I answered it within the time frame that you advised me to issue it in. The reason they are not notified, I have been very vocal since March that my name is not Amy Lee Childress Claiborne. My legal name is Amy Lee Childress. I do not own one government state ID with the name Claiborne on it. You have to have an ID to get something notarized. Mr. Hawley is fully aware of what my name is. When he's sending the letters to Metrocan, on the outside it says Amy Childress. On every motion inside.
And you think that prevents you from appearing in front of a notary public under the name Amy Childress and signing the documents under oath?
Your Honor, I signed the documents that I gave to him. I do not have an ID that has the name Claiborne on it.
I'm going to take a recess. Mr. Hawley, you compare what she's producing. When I come back, if she's able to produce a video of it, I'll allow her to play it, and then I'll make a ruling regarding. I'm going to necessarily have to examine what it is that you've asked and what her responses have been to determine whether or not she's in compliance with that. So we may not get started before lunch if I have to review all of that.
Yes.
We'll take a recess and allow this to take place.
All right.
Well, let me
Put them on a subscription, do they show up every month whether you need them or not? That's what I generally do. Stack them.
All right. Mr. Hawley, you've had an opportunity to compare what Ms.
I have.
Childress.
It looks like a different typeset, or maybe that's the way she copied it. And that's what I was saying. I hadn't seen this before because of the stretched out typeset. I don't know how she took a picture of this thing. I've included this in my motion. This is in there, but it still doesn't answer, in my opinion, any of the questions that I brought up. Now, if you look at this interrogatory number 2, she states 102B West Hills Terrace, Sidney Claiborne. There's 2 numbers after that. I don't know whether that's her social security number, Sidney Claiborne's social security. It's that for the answer to that question. But outside of that, I'm still prepared to go through these line item by line item with several things that she's not produced, including the witness list, including all the other things that I've mentioned. And they never were signed. She hadn't produced that. They've not been signed. They've not been affirmed under oath by her as required by the rules. But this is a different picture of what she dropped off, but it's in my October 5th motion. That's exhibit, I believe it's exhibit B, what she actually returned. So I still stand behind, as far as a list of everything that's not appropriate. If she's going to testify or whatever, that's her social security number, I guess that would be one answer to, again, the 2-page deficiency letter that's still outstanding. I don't know how the court wants to do that, but if we need to go line item by line item, I guess I can.
What the court wants to do is to finish this case because this case has been pending for far too long, considering the length of time these parties were married. So there's no question but that these answers do not comply with the rules of civil procedure, nor do they comply with the court's order regarding the requirement that she fully answer those questions. As a result of that, courts considered all of the different sanctions that can be imposed on this, and what I'm finding is that the most appropriate is to refuse under subsection 37.02 subsection B. The court finds that the defendant should be prevented from and prohibited from introducing any evidence regarding the matters that are requested in the discovery that you have filed. And therefore, she will not be allowed to introduce evidence on the issues that were raised in your discovery request, and you may proceed with your case. But I'm not granting a default judgment. She'll be able to testify about grounds and so forth, but as far as introducing a lot of evidence that's set forth in your discovery request, I'm not going to allow her to do that because it's not being complied with the order. You may call your next witness, Mr. Hawley.
I have a moment with my client? So just a point of clarification, as far as the answers not being signed, all of those types of things, she's not going to be able to put on any evidence for either questions that I've asked.
Correct.
And that's for today as well as,
That is correct.
unless she remedies it at a final hearing. I would then call Colin Deaver. He can be my last witness to call then.
Ms. Childress, I understand that you may not agree with my ruling, but the fact of the matter is that the rules require that those answers be filed under oath and that those are sworn to. And the reason for that is that the opposing party may rely upon them as an accuracy. Where the rules require it, there's no provision for me to waive that, and as a result, your answers were not sworn to. I understand your reasons why you've given them, but rather than grant a default, simply a default, I'm simply saying that you cannot you cannot put any proof on regarding those issues that were asked about in the discovery request.
Yes, Your Honor. I think the problem that I have with it is I have the evidence to prove that Mr. Hawley has been lying in the last 2 court hearings, and it's on my thumb drive, and regardless of what Mr. Hawley wants to state, I do have that factual evidence that I did answer the questions. The way those were typed out, the reason it has an address, my social security number, and my driver's license number, if you read the interrogatory questions, they correspond with what was provided. I did not feel the need to retype those, but I'm fine with not using any of my information. I do have every bit of all of my documents to support that I did not cause the vandalism. My witnesses are here, and I will need the court to allow time because I do have videos as well as a lot of documentation.
You understand what I've just ruled, that you're not going to be allowed to put on evidence regarding the issues that Mr. Hawley asked about in his discovery request.
Your Honor, Mr. Hawley did not ask
Number
about.
one, when I am talking, you need
Sorry.
to be quiet. So we're going to consider whether or not those questions were asked, and I'll decide whether or not. Raise your right hand and let the clerk place you under oath.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, if you will, sir, state your name for the record.
Colin Patrick Dever,
Mr. Dever, what is your address?
6501 Harding Pike, apartment T14, Nashville,
What is your
Tennessee.
last name? I'm sorry.
Dever. Dever rhymes with never.
Okay.
Never Dever.
Pull that base of that microphone towards you a
Sure.
little bit so that it picks up, please.
Is that better?
That's better.
That's
Okay.
better. You want to spell your last name for the court?
D-E-V as in victory, E-R.
All right, thank you, sir. You know Miss Childress, correct?
Yes.
And y'all at one point were pretty good friends.
Yes.
I mean, she came to you with all these issues that she's dealing with Mr. Claiborne, and you guys talked about all of those things, correct?
She didn't come to me to talk about Mr. Claiborne. I found out about it after she asked me to pick her up from the hospital. And on the drive home, that's when she told me.
And you had spent nights at Mr. Claiborne's home?
Yes.
You'd stayed there for how long?
Every week I would spend like a few nights so she wouldn't be alone because she was concerned.
Mm-hmm.
And, but I had, have my own place and my cat. And so I needed to get home and do things. So
At one point, you became estranged from Miss Claiborne, did you not?
we had a bit of a falling out. And, but
Is it because she wanted you to lie to the,
I object, Your Honor. I don't even know how Mr. Holly can say that there was a falling out.
Number one, you have to object on a legal basis for an objection. There is no legal basis to say that you don't like the question he's asked. So overrule your objection.
I'm sorry, could you?
at one point, she was requesting that you lie to the police and file a false report about something that Hunter Anglin and Chris Lashley, the two officers that had previously testified, something that they had done. Is that accurate?
Not that I recall.
You don't remember anything about that at all?
I do not.
So
Our falling out.
you're
was-
saying that she never wanted you to make a false statement to the Dixon County Police Department?
Not that I recall.
Not that you recall?
No.
You think you would recall something like that?
I would think so.
I want to plug in here and put something on the screen if the court will allow. And if I can plug in. I'm going to show you a text message. I want to ask you if you recognize this text message.
Yes.
You wrote this, did you not?
Right.
Can you read that for the court, please, sir?
You wanted me to make a statement against the Dixon County Police Department. I would not do that as I thought they did nothing wrong.
Well,
But
I'll show you another Facebook post and ask you if the last paragraph is something that you wrote.
Yes.
That's on your Facebook account, and you wrote this.
Yeah.
Can you read that last paragraph for me, please, sir?
She wanted me to say the officers did something wrong. I said I would not agree with that.
No, the last statement, being a good Christian, that paragraph right there.
Being a good Christian, I find it hard to bring myself to use this kind of language, but she's fucking crazy bitch.
Go ahead.
She wanted me to say the officer did something wrong. I said I did not agree with that.
She's trying to promote to you to make a false statement, it sounds like. Is that accurate?
Yes, sounds like that.
I want to ask you if you posted this statement.
These are all through messengers.
I'm plugged in. Let's see. I want you to look at this statement, and I'll ask you if you typed this statement.
Yes.
Can you read that statement for the court, please, sir?
I'm going to kill this C. I just got subpoenaed. This crazy ass bitch doesn't want me to understand how much drama can one person create. Don't pay me back the $1,000 I lent you. Just leave me the hell alone.
You had lent her actually money, correct?
That's correct.
This statement as well, sir. Did you type this paragraph?
Yes.
Can you read that paragraph for the court, please, sir?
I'm over this no talent bitch starting up trouble again. I just caught a call from the Dixon County Police Department about the complaint brought up against the officers. and my name was mentioned. What you need to do is pay me back the $1,000 I have lent you and leave me alone.
You got a call from the Dixon County Police Department about a complaint brought up against the police officers, and your name was mentioned. What did the Dixon County Police Department ask you about that?
Did I recall anything inappropriate? I don't remember it was a female, I guess, sergeant and I said,
You're not.
no, I didn't recall anything that I felt
Do you have an objection?
inappropriate.
Ms. Childers?
Yes, Your Honor. This question is actually in part of a criminal investigation, which is part of what the other two attorneys spoke about. Can I have them intervene and see if the question is allowed?
Holly?
This is non-hearsay, Judge. It goes directly to Ms. Childers' credibility. She's asking Mr. Dever to get involved in filing a false police
The
report.
objection is as to the question that his conversation with the Dixon Police Department, he's reciting what he was being asked by the Dixon Police Department, which is a hearsay statement that they're asking, the question from them asking him, and his response would be hearsay. I sustain an objection. I don't think that really has a relevance anyway, but it is hearsay. Sustained.
That's all I have. Thank you, Judge.
Ms. Childers, you have the right to ask questions of this witness. It is not a point for you to argue with him or to make statements. You can ask questions in the form of a question if you wish to do so. Do you wish to ask any question?
Yes, sir.
Come to the podium and you may ask your question.
Colin, how would you explain our relationship?
Well, we've been friends for 9 years. We met at a fundraiser raising money for a social service organization, and we just clicked. And, spent Christmases and Thanksgiving at your place and with your dad, and it was very good.
How would you describe my emotional state with everything going on? Is it a way that you had seen me in the past?
Judge, I would object to the relevance, first of all.
State is not relevant. Your emotional state is not relevant to the grounds for divorce or to the issues regarding property.
Yes, Your Honor. The post that Mr. Hawley showed said several times that I was crazy, and that's why I was asking the question.
All right, well, I'll overrule the objection, allow it for that limited purpose. She's trying to rebut the statements by Mr. Devers as to her mental state, so I'll allow it for that purpose.
No, and I was just so mad at you over that damn parrot of yours that I was watching that I lashed out inappropriately and used language that I should not have, and I apologize.
Thank you. Sorry, give me one moment. I just need to think how to word it. Did I ever ask you to lie to Dixon County Sheriff's Department?
See, I'm not recalling that you ever asked me to lie. I was just furious, and maybe I worded it inappropriately and wrong. I was just really mad, as you can tell by the text. So,
Without answering or providing any details of the investigation, can you state, did Dixon County Sheriff's Department indeed reach out?
yes, it did.
Did I ever reach out to you one time asking you to say anything to Dixon County Sheriff's Department?
I'm not recalling it.
During the course of everything that has gone on, I know you've had some medical issues.
Were you ever under the influence of alcohol or any type of, prescribed medications when these messages were typed up?
No, I was just angry.
And I know you were a little shocked about how those messages came up. Can you tell me, did you provide those messages from your messenger to Mr. Hawley in the text messages?
Judge, I'm going to object, first of all, to the relevance of how they were there. They were there. And secondly, it goes with the discovery. I mean, I well asked to provide everything having to do with any sort of social media, anything with witnesses, all of these things that she's not answered.
Sustained. Witness will not answer the question.
Have you ever shared your social media information with anyone?
Again, Judge, same objection.
And so the question is, have you ever shared it with anyone?
Yes, Your Honor, because the point I'm trying to make is Mr. Hawley, his client, has continued to stalk and harass not only me, but people in my circle, and Mr. Cullen does seem to not be aware that anyone accessed his social media account.
Sustained, because this witness has testified he's the one who posted those messages. I don't think that it's relevant whether or not there is any other issues. Any objection?
No further questions.
Mr. Hawley, you have any redirect for this witness?
I do not, Judge.
Mr. Dever, you may stand down. You are released from your subpoena. You may go about your business, or you may have a seat in the courtroom if you like.
Thank you.
Mr. Hawley, you may call your next witness.
I have just a quick moment, Judge.
You may.
That's our proof, Judge.
Plaintiff is rested to proof. Ms. Childress, you have the right to ask to put on proof if you wish to do so. Do you wish to call any witnesses or testify yourself?
Your Honor, I'd like to call Detective Lovell.
You'd like what?
I would like to call Detective Lovell as a witness.
Again, Judge, I would object. There was a witness list that I asked for. The court has already ruled Detective Lovell's not on here anywhere as far as a potential witness. He's a subpoenaed witness for me today, but she didn't issue a subpoena for him at all. And I object because, again, it's in discovery that I asked for this stuff.
Your Honor, I answered the discovery questions. I did. And at the time of the divorce, the people that I were going to call as witnesses are the ones to testify to the abuse, what I endured during the divorce. What Mr. Hawley has filed is a separate contempt motion against me, where at the time items were removed from the house, I was not under a motion. More or less also, the divorce had not even been filed. I'm speaking to this in regards to, these are witnesses to what Mr. Hawley is claiming, and in the spreadsheet that I did send to him, and if he can't read it, again, it's on my thumb drive. I don't mind taking a recess, but Mr. Lovell is actually listed as a witness.
And what do you intend to prove through Mr. Lovell?
With Mr. Lovell was present, so was Detective Martin in the room when I had the meeting with CID at Dixon County. It must not have been false. There's my evidence.
You talk to me, don't talk to him. Tell me what it is that you think that you are going to prove through Officer Lovell.
Because Mr. Lovell was present in many of the meetings.
Doesn't matter where he was present. What are you wanting to prove through, what are you going to ask him? What are you planning to put on in the way of proof?
I want to ask him if he was present whenever the CID team was questioning me. There was an investigation. The previous law enforcement officer that he did bring to the stand confirmed that he was reprimanded for being unethical.
Judge, I would object to this because it's a gravamen of what you've already ruled in the motion to quash, that we can't get into anything having to do with the criminal investigation.
Well, Mr. Hawley,
we highly contest the aspect of that domestic assault.
Something that's relevant becomes an issue before the court. It's relevant if it tends to make something more true or less true that is an issue before the court. We are trying a divorce case. We are not trying a criminal case. And as a result of that, unless it directly goes to the grounds for divorce or goes directly to the division of property, it is not relevant to the issues before the court. Whether or not this officer was present during the time that CID investigated or interviewed you is not going to prove anything that the court has to consider. It doesn't prove anything regarding the grounds. What you're attempting to do is to rebut something that you asked these officers about whether or not they were reprimanded. Well, but whether they were reprimanded or not does not go to the issue of whether their testimony was truthful or not truthful. It has to go with whether or not you feel like they acted professionally.
Yes, Your Honor, my point being is because Mr. Hawley was questioning if I had Mr. Dever lie to have him contact the sheriff's department, and I did not, and I wanted to show the proof of that. But as to Mr. Hawley's point about the criminal side, Your Honor, you're correct. This is a divorce hearing. It should be in regards to a divorce. What Mr. Hawley and his client are coming after me for is theft. And my entire box, again, you can see it's been through Sheriff Eads, the DA's office, Mr. Crouch, all the law enforcement in this county. All of my evidence is based on criminal activity because Mr. Claiborne filed a false police report on me about what was removed from the house, and even went as far as reporting a gun into NCIC.
We're getting into testimony. I think the court's going to allow her to testify in a minute, but she's arguing her case.
Mr. Hawley,
We're making those statements.
I'm going to allow her to call Mr. Lovell, but I'm limiting it unless it has some direct elements. You'll need to object to anything that goes beyond the scope, but I'm going to allow him to be called as a witness since I don't think I'm going to prevent her from calling a witness, but putting on the evidence is a different matter. So Mr. Lovell will be called as a witness. I'll allow you to object and then I'll rule on it.
May I address the court briefly? You're talking about grounds for divorce, but today we're just here on a motion for contempt. This isn't the divorce trial. I'm not prepared to put on grounds for divorce today. I filed a motion for contempt because of the previous
Why
order.
are we trying? Let me say this. Does your client want to be divorced?
I would ask for default judgment for at least a divorce today at the end
You
of
want
the
to be divorced from this man?
absolutely, Your Honor.
They're granted a divorce today,
Thank you, Your Honor.
right now. Now, since we're not talking about grounds for divorce, the division of property goes without fault to, is to be equitable or fair without fault. So I'm not going to consider the fault of the parties, but it also goes to the classification of property as to whether it is separate property owned by one of the two of you before the marriage or whether it was marital property acquired during the course of the marriage. So those are the issues that are before the court. So let's limit it to that. You've now been granted a divorce. So the issues of what happened and what caused it are not relevant to this court's proceedings anymore. We're now going to go to the issues of property division, which is only about who owned what and how much it was. Now, we've also ruled that you can't put on proof about the property issues because of my ruling regarding the answers to discovery. And if those were questions that were asked during the time that these answers to discovery were requested, then I'm preventing you from, under that rule, from putting on proof about it. So what I want to know is, do you have proof regarding any issue that is still before the court?
Yes, Your Honor, I do.
What are you planning to put on?
At the time that the discovery questions were handed over to me, I had never left the marital residence. So, Mr. Hawley, there's no way that he could have asked that question. He couldn't see into the future to see what this next motion would be. The motion was filed after the fact. What I plan to present to the court, I have hundreds of documents of receipts, proof that these are my items. I have video of what
Did you produce all of those for Mr. Hawley? All of those hundreds of receipts that you claim?
No, Your Honor, I was not asked to. I was asked specifically by the court to provide Mr. Hawley the spreadsheet, and I did do that. And I have a copy of the spreadsheet on my thumb drive if anyone has a problem with how to make it out. However, based on the witnesses that are here in this courtroom, Mr. Holly was able to read that spreadsheet because Mr. Lovell is here to testify in regards to electronic devices that were handed into the city of White Bluff.
Well, if I can, Judge, interrogatory number 29
Have you filed the interrogatories in the court file?
and number 28, I have. And they're also attached to the motion that I filed for the 5th. The last time we were here, I gave them to the court as an exhibit. And then they're also attached as her answers. The questions are written out and she's got a handwritten answer. And the request for production of documents, number 29, produce any and all documents and/or items you intend to introduce as exhibits into the trial of this matter. And again, number 28 says basically produce anything from your spouse to others, photos, videos, any other material in any other way relating to your spouse. But I think she's stopped from putting any of that on.
Your Honor,
And again, as far as something classified as marital or separate property, I think it comes into play today from the property that maybe she took. But as far as an overall classification of everything, I mean, I'm not really prepared to get into a divorce trial today. I just filed a motion for contempt because there's some $40,000 worth of stuff that's no longer there.
I've granted you a divorce. I'm referring you to a special master regarding the identification and classification of all of your property. And we'll let someone else take the time that doesn't have all of these other folks who are needing it. So each one of you will be required to post with the clerk and master a deposit of $1,000 towards the payment of the special master's fee. And then I'll designate special master, Mr. David Brogdon will be the special master for your case. He will determine and hold an issue. I will draft an order that refers it to the special master and sets forth the issues that are to be resolved by the special master. You've been granted a divorce that terminates anything except the division of property and the motion for contempt regarding those property items. So,
Mr. Brogdon will be allowed to look at the contempt as well and determine that, or?
it will be allowed to determine the issues of property and therefore and where those properties items are located.
Yes.
Your Honor, Mr. Holly filed a motion against me in his motion saying that I'm entitled to be represented by counsel if I could not afford one. I no longer work. I do not have $1,000 to pay in this matter. Can I request that I have a public defender?
Don't get a public defender in a civil litigation. You can represent yourself. I'll reserve the issue of posting the special master's fee, but you will have to pay a special master's fee at the conclusion of the case. And this court cannot and will not devote the time that it seems to me would be required to sort through the mess that the two of you have created in your marriage of 4 or 5 months. And all of your claims in your box with evidence labels on it do not, don't particularly persuade me that these issues are relevant. But if you want to litigate them, I've granted Mr. Claiborne a divorce and you a divorce. So you are now able to go forward with division of property issues in front of someone who might have a little bit better, a little bit more time to devote to it. So I'm going to take a recess. I'm going to draft the order referral to the special master, and then we'll come back and I'll start the next case. So you might want to contact the next people in order.
Yes, Your Honor. Thank you.
Thank you, Judge.
I'll take this file. I wanted to address an issue that I wasn't aware of at the point in time until I began to go through the file. Ms. Childress has never filed an answer to your complaint for divorce. There was no answer filed, no counter complaint. She apparently had some motions filed through her prior attorney, Mr. Baker, who filed on April the 4th a motion for an opposition to the motion for possession of marital residence. On April the 19th, filed a motion for exclusive possession of the vehicle. On April the 19th, he filed a motion for pending a lighting support. And then on May the 9th, Mr. Baker filed a motion to withdraw, and that was heard and granted. No answer has been filed to the complaint for divorce. No answer has been filed to your motion for contempt. A party appears from the record according to the documents. So therefore, this court is revising the judgment that I previously entered. Your motion for default is granted based upon the fact that Ms. Childress has not filed an answer to contest the issues that are before the court. And a default judgment means that you, as though you never appeared in this court. And as a result of that, Mr. Claiborne is granted the motion for default judgment as to all the issues that are raised in the complaint. And therefore, the court, having heard proof on those issues, grants your finding of civil contempt in the amount of damages that you have set forth at the prior hearing. You'll draft an order and submit that to Mrs. Childress. Ms.
Your Honor,
Childress.
I was never given the opportunity to prove that I submitted those responses.
But I want you to understand this has nothing to do with the issue that you are talking about. This has to do with the fact that a review of the court's file, and the court speaks from its minutes, demonstrates that you have never filed an answer to the complaint as required by the rules. As many of the other shortcomings of the handling of your side of this case, the complaint alleges various items that you are guilty of all of these different things, and including inappropriate marital conduct, cruel and inhuman treatment, and it shows that you don't own any real property and that you are various properties subject to a equitable division. A default judgment means that you not having answered the complaint and raised those as issues, that there's nothing, and that there was no answer filed by you or Mr. Baker as to the motion for contempt. So therefore, you have not technically appeared in this court as a party, even though there were some motions that were filed on your behalf that were never completely litigated.
Your Honor, the divorce and the contempt are two separate issues. I answered the interrogatories like I was asked by the court. I provided those responses. I don't know how to do this, but I can't represent myself or hire an attorney when there's over 50 motions being filed on me in this courtroom. I provided my responses. I just wanted somebody to look at the thumb drive to see I'm telling you the truth. Mr. Hawley, it was pointed out numerous times in the last two court appearances that he did have my answers. He quoted them on your stand. I watched the YouTube video back. I did provide the answers, Your Honor. The divorce should be two separate matters. There was nothing removed out of that home while I was under any type of restraining order. When the devices and the information that I provided to law enforcement at the request of them was handed to them before the divorce was even finalized. I have my evidence to prove all of this, but I've never been given the opportunity to present it to the court.
As I explained to you earlier, it's not a question of whether you delivered or did not deliver something. You did not comply with the order of the court regarding the rules of civil procedure, which apply to you as they do to every other person. And I have, in this court's opinion, bent over backwards trying to assist you and trying to give you an opportunity to do these things that are required by the rules. Because of the fact that primarily, I just learned from my review of the file that no answer had been filed to the divorce complaint. I was in error in not granting a motion for default to Mr. Hawley. A motion for default means he wins because you actually didn't show up in the sense of a legal proceeding. And for that reason, it seems to me that there's really nothing more that I can do for you because as a part of the divorce action, the motion for contempt was a violation of the statutory injunction. That should have required an answer to be filed by you, and although we had an extensive hearing, you have never technically appeared on that issue. You have not filed a response to it. You have not filed an answer to the complaint for divorce. So I understand you may not agree with my ruling, but my ruling is based simply on the law and the rules of civil procedure that apply to every person who appears in this court. You can consult an attorney. There are procedures that you can follow to try to address this issue in some sort of a motion that you might want to file if that's what you decide to do. But you may want to consult with an attorney about that first.
Your Honor, I
Yes,
don't
Gordon?
have the money. Do I have the option to appeal, to have it heard in another courtroom?
You have every option available to you under the rules of civil procedure.
Your Honor, in the motion that Mr. Hawley filed on me in that contempt, it said that I have the right to legal counsel. It was signed off on.
It's because he filed it and gave you a notice of rights, but he's filed it as a civil contempt rather than a criminal contempt, which means you do not have the right to an attorney. Civil contempt means I'm not going to incarcerate you in jail, and for that reason, you do not have the right to have an attorney appointed for you.
But Your Honor, it was listed as criminal contempt. That's why I didn't understand why it was in your courtroom.
I'll draft the order, Judge. For the court, I'll draft the order.
That is judgment of the court. She's not found in criminal contempt anyway. It was civil contempt on the issue of these items being removed. Even if it was just as a hearing on the division of property, she didn't appear in the divorce itself, so therefore this court is of the opinion that the plaintiff's proof should prevail. You can consult an attorney, you can consult the rules, you have every option available to you for someone who is disgruntled with an order that the court puts down. That is the conclusion of everything I'm hearing in this case.
Yes, sir. Thank you, Judge.
Your Honor, am I divorced? Am I
You are
divorced?
divorced.
Thank you, Your Honor.
Take your contact with your.
Ma'am, you can leave.
He keeps
You can
harassing
leave.
me. That's his attorney.
You can leave.
Sorry, Judge.
Brian Grammon versus Tony Marie Grammon.
Two addresses for her for the order, for the notice for today and all of these things. And there's some 7 or 8 envelopes here that have been returned. I've got also, there is a notice that we filed December 28th, setting it for the 15th from the court's direction today, the 15th of February. There was a letter that she had sent to the DA that was requesting everything be dismissed on a certain amount of money that Mr. Claiborne would pay to her. And the DA had given me that letter because it dealt with the divorce. She didn't really know how to treat that letter. I knew how to treat that letter, but she was going to look into it. I don't know what they ever did with that. It kind of goes with the criminal case. But I got an email address off of that where she had sent it to the DA, and I've been sending all this stuff to her email address as well. And I've got a confirmation that where we sent that to her if the court needs it. And that's all to say that I think she had ample notice that the court had set this on February 15th for a review of the order that I sent into the court. From the default judgment, I kind of did the best I could. If you will recall, when it was granted, she was yelled something at me, and the bailiff told her to leave. And it's one of those things, we just kind of broke camp and took off as quick as we could. We didn't have a chance really to clarify a lot of things that were in the order. And I think that the court was wanting us to come here today to basically have some instructions on this order for me to possibly revise the order and do some things differently. Without any, without any direction from the court, I guess, on that, I said that she was, it was civil contempt. He was granted a divorce on the grounds that were in the complaint, for divorce. Court will recall, we went through testimony with Mr. Claiborne. We introduced as Exhibit 1, or Exhibit A, I think it's marked, a sheet of items, several sheets of items that were dealing with the divorce and that she had absconded with, and we had a value on there. And he took a couple of hours to testify to all of those that, we had pictures where they were there in the home at one point, then they were gone from the home, and what a value of all that was. And in the order, we were, from the contempt default, asking for all of that, or the value of that to come back to Mr. Claiborne. That she be jailed on civil contempt, immediately held until such time as she returned all of those. If the court wants to give her 30 days, or whatever the court wants to do, honestly, it's.
Well, my problem with your order is that a great majority of the order was accurate as to what the court's ruling was, but in the body of your order, she was found to be in civil contempt And my recollection was that I was awarding your client the value of the property that was set forth, the items that were set forth. And without going into too much detail about it, it seems to me that there's two options you have on a civil contempt. Civil contempt, she can be incarcerated until such time if she purges herself by returning those items, or that I can give him a judgment, a money judgment against her for the value of the items that he said. I have no idea whether or not she ever will be able to be located, or, to even incarcerate her, but giving him a judgment for the value of the items was what I had in mind on the day of the hearing. You had proven a value, and I don't recall, it was some $40,000, it seems like, maybe more.
Everything on that list, I think, was more like over six figures, was it not?
Okay.
Yes, sir. It was like over six figures. Well, from our standpoint, I think what we would request, as there is and I may need to talk with Mr. Claiborne a little bit if that's our option at hand, but I think what he would ask for is that if the court's direction is to give her a certain amount of time to return the items or be incarcerated with a capias, I think that's probably what he would request, other than a monetary judgment, and she can purge herself by paying him, that amount or whatnot.
You had included in there that there was an arrest warrant to be issued immediately for her, and that the clerk was directed to issue that capias in a body attachment, and that she would be released on the issuance of a signature or cash bond not to exceed $100,000, et cetera. And the court never ordered any of those things.
Yes.
So I think that clearly she was found to be in contempt for having removed those items, and the court is of the opinion that a finding of contempt and giving her some reasonable period of time to return those items, being 30 days. And at the conclusion of that, if she has not complied with the court's order, then a capias would be issued for civil contempt. So I think that would be the appropriate way to handle it. The only other thing that I wanted to address is the fact that there was an order of protection that had been transferred, I think, from General Sessions to this court, and that was never dealt with in the hearing of this court. But obviously, this court is based on the information and the fact that it was never pursued within the 15 days for a hearing, that order of protection had expired by its terms and by statute, but I declined to issue an additional order of protection. And this order needs to reflect that.
I will, if it's okay with the court, I may put that in a separate order since it is the order of protection. The reason why, she filed that order of protection and we appealed that. So it was really her. I'll draft the order with what the court is saying here and send it to the court. And if it's okay, I'll put that in a separate order. I will say that we did discuss that. I remember that one time in court when she was present, and you did let her know that it had expired by its own term. So I'll draft the order.
I thought I had, but we just need to have it clear in the record. So.
You had. And may I put in there, Judge, that if she is arrested, she has a right to either return the items or pay the monetary amount that he put on the side that he testified to was that. So
return the items or pay the dollar value. Either of those would purge herself. So.
Yes, sir. And I'll make those changes in the order. Everything else in the order was satisfactory?
Yes.
Okay. Thank you, Judge. I'll make the changes. That's what you want? Thank you, Judge.
All right. In the matter of Arias Malachi Jacoby March, we heard that, I'm sorry. No, I'm sorry, that is for hearings.